Hey guys, good morning. Good morning. Well, actually, good afternoon. It's 12:03 because I'm late. We're on day 10 and it is closing arguments time. So if you missed yesterday, state rested, defense called one interesting witness, and then don't believe they're calling any other witnesses. So we're going to get to closing arguments today. We're going to be able to skip some breaks and make this real efficient here and see what the defense comes up with as their final arguments here to help their clients. So hope everybody's doing well. We're going to get started. The court volume isn't on at this point, but as soon as it is, let me know how volume is for you. And captions, let's see if we got captions. Get those going.
If you can, or you have the numbers of what he needs, you can.
All right, so how's this volume? I did send in a request, by the way, for the full interviews for Isaiah Chance and Sean Gathright.
Did you?
I don't know how quick the response will be, but I did request them. This is the same judge, Michelle Cisco, as the Alicia Andrews trial, though she's now disqualified over there.
There is a folder with home suites as well.
Also, Tyreek Hill trial, I don't know if jury selection's complete. I haven't seen an update or a feed.
Switch the restroom, I think. Ready?
A lot of camera time on him today. Yeah, Tatum says, please no spoilers. We will catch up. There's been days where even though we start late, we run out of catch-up time and get caught up.
Okay, everyone, let's go on the record. So, first of all, with regards to the jury instructions, I did receive the aggravated battery instruction. So if you guys had a chance to look at it, see if there's any objection to it. So take a look, let me know. And then I was looking, I haven't looked at I received the updated verdict forms. I have not looked at them line by line yet. I would note on the aggravated battery lesser, I don't know if the state wants to include a finding as to great bodily harm or deadly weapon, or if you just want to leave it as is, aggravated battery.
As it's charged on the aggravated battery, there was no great bodily harm language in the original indictment. So it would be, if there was a conviction on aggravated battery, only a special finding for the firearm language, because that was charged.
Okay, and so that's already then included in the special finding, right?
It should be
Yeah.
in the special findings that they include if you find first, second, or aggravated battery.
Okay, and, okay, very good. So I'll look over these verdict forms myself, and everyone else needs to do that as well, but, okay. And then what's the state's position on whether you get a principal instruction for attempted manslaughter?
Your Honor, can we just revisit the verdict forms very quickly?
Yeah, sure.
Last night I had prepared for each of the defendants a verdict form that had essentially the formatting updated with the alignment. I will email the ones that I made for each defendant to everyone, but may I pass this forward to the court so that you may review it today compared to what you have?
Yes.
Okay.
Because remember, they're planning to do jury instructions reading tomorrow because
Should include all of the examples, but the formatting is just.
there's 4 defendants that need to go through their closings.
All right, very good. I'll take a look at that. Okay, and so as far as principal goes, do you get a principal for attempted manslaughter?
Yes, sir. I did check last night. It would appear principal would apply to any criminal offense as defined by statute.
Okay, anyone disagree based upon legal research?
I do not disagree and have found no research to indicate otherwise.
Okay, very good. And so then on the principal instruction as to counts 3, 4, and 5, I need to also throw in the aggravated battery, right?
Yes, Your Honor.
Okay, I'll just make a note.
So they can be a principal for anything. Which means they don't have to be the one that actually did the action.
I'll make those changes. So I can be working on these as the state is doing their initial opening. Okay. And then on the firearms enhancement, 3.3A, I think there was a question. I'll need to include AGBAT in those as well. And the manslaughter is just by overt act, correct? Not culpable negligence.
That's correct, Your Honor, and it would apply, manslaughter would apply only to 3.3A and not D, but they're on this, so if you're looking at that page, which is my
Right.
23.
On 3.3D, does AGBAT get included, though?
It does, Your Honor.
Okay. I'll make those changes. Okay. All right, so now's when I need to have the discussion with the defendants as to whether or not they're going to exercise their right to testify or to remain silent. So as we discussed yesterday with all four of you, you need to understand that the decision to testify or the decision to remain silent is solely your decision. No one can force you to choose one way or the other. Not your attorneys, not me, not the state, no one. That is solely your decision. Okay, does everyone understand that to begin with? Mr. Rashad Murphy, do you understand that? Mr. Davion Murphy, do you understand that? Mr. Sean Gathright, do you understand that? And Mr. Isaiah Chance, do you understand that? Okay. All right, so I'm going to start here with Rashad Murphy. Have you had sufficient time to consult with your counsel regarding your right to testify or to remain silent? Okay. And has anyone, including your attorney, threatened you, coerced you, or promised you anything in order to get you to make the decision to remain silent? And do you understand it's solely your decision what you wish to do? Is that correct?
Yes, ma'am.
Okay. All right, Mr. Davion Murphy, have you had sufficient time to speak with your counsel regarding your decision to testify or remain silent? Okay. And has anyone, including your attorneys, threatened you or coerced you or promised you anything in order to get you to make that decision?
What if
Okay,
someone
very
said
good.
yes?
And as to Mr. Sean Gathright, have you had sufficient time to consult with your counsel about whether or not you wish to testify or remain silent? And what is your decision? Okay. And has anyone, including your counsel, made you any promises that you've relied upon or threatened you or coerced you in any way in order to get you to make that decision? Okay. And finally, Mr. Isaiah Chance, have you had sufficient time to consult with your counsel about whether you wish to testify or remain silent? Okay, you get answer out loud. And what is your decision? Okay. And has anyone, including your attorneys, made you any promises you relied upon, threatened you, or harassed you in any way in order to get you to make that decision, Mr. Chance? All right, and do all of you understand, I'm assuming no one's made you any promises regarding the outcome of this trial. Is that correct, Mr. Rashad Murphy?
Yes, ma'am.
Mr. Davion Murphy? Mr. Sean Gathright? And Mr. Isaiah Chance? Okay, and do you understand no one could? No one is a fortune teller. No one can ever predict what any jury is going to do. Also, I think the only person I'm aware of that had a prior conviction was Mr. Davion Murphy. Is that correct? Okay, and Mr. Rashad Murphy, Sean Gathright, and Isaiah Chance do not have any previous convictions, felony convictions, or crimes of dishonesty convictions, correct?
Not aware of, Your Honor.
Okay, so Mr. Davion Murphy, just as it relates to you, do you understand that if you were to take the stand, your attorney or the state could ask you if you've ever been convicted of a felony, and you would have to truthfully say yes, and then they would ask you how many times, and you would have to truthfully answer whatever that number is. And as long as you answer truthfully, no one could get into the nature of those charges, all right? The only way anyone could get into the nature of the charges is if you testified untruthfully. So do you understand that that would be the process if you chose to take the stand? Okay, all right. Okay, very good. So Anything else we need to discuss before we bring in our jury and proceed to closings? As I indicated, I'm going to bring in the jury. I'm going to ask each defense counsel if they have an announcement to make. That's when you will announce you are resting. And then at that point in time, I will find that you've renewed all motions, previously made motions and objections, and then we'll go right into closings. Yes, Mr. Sinardi.
Your Honor, on behalf of Davion Murphy, we're renewing our motion for a mistrial and ask that this case be severed from these other co-defendants based on the statements of Detective Griffin that he was previously in prison.
Okay, very good. I've taken that under advisement. So I'm looking at the issue. Okay?
Oh,
All right. Okay, anything further? All right. Anyone
So
need
Nick-
to use the restroom before we get going?
that was pretty quiet with Nick Sinardi, but he said he renews his motion for a mistrial based on the mention of the prior with Griffin on the stand.
Motions, previously made motions and objections, and then we'll go right into closings. Yes, Mr. Sinardi.
Your Honor, on behalf of Davion Murphy, we're renewing our motion for a mistrial and ask that this case be severed from these other co-defendants based on the statements of Detective Griffin that he was previously in prison.
Okay, very good. I've taken that under advisement. So I'm looking at the issue. Okay? All right. Okay, anything further? All right. Anyone need to use the restroom before we get going? Okay, hearing nothing.
Your Honor, if I may run to the restroom, but I understand you have to instruct the jury.
Well, I only have a paragraph to read at this point. So, yeah, that's fine. Go ahead. And, oh, for the record, I am making a finding that each of the defendants is knowingly and voluntarily and intelligently waiving their right to testify in their defense.
Judge, I'm a little not certain. Did the court indicate there was no time limit for the state or the defense?
No. You guys, I'm not going to give you a time limit. Listen, we've been at this now. We're going into week 5. A lot of evidence, a lot of witnesses. I'm not going to set time parameters, but you guys are experienced enough to know that you can start wearing out a jury if you're repeating yourselves, right? So,
We'd ask for a time limit for the defense.
well, the thing is this. Here's the thing. If I give you, let's say I give you an hour or an hour and a half, right? I give each defendant an hour and a half. Well, right now, I've given the state 6 hours. So I'm going to rely upon you all as professionals and your experience dealing with juries and recognizing that at
What?
some point you start wearing out a jury.
Judge, I'm not gonna take 6 hours.
Thank God.
That's okay.
I promise.
Everybody celebrate in the chat. Holy moly.
All right, so as soon as Ms. Gismer's back, then we'll get going.
I was like, we're all in this together. This is going to be a long time. Maybe not a good time. Whew. And I saw it was Doherty up at the podium, so she's doing the first half of closing. So state's going to go, then the defendants will have their chance, and then the state gets a rebuttal close. So at least the first portion of closing is going to be Michelle Doherty. Oh, but thank goodness they said they don't plan to take 6 hours. Do you guys remember us watching Hilton? Closing? We're like, when is it going to be over?
I don't think we're going to this morning, but I think this results will first.
Oh, okay, yeah, that's fine. Is that, so it's going to be, what is the lineup going to be? Mr. Gonzalez,
You know, I think I would go next. if that's what-
Wise, then, who wants a third spot? It's either Mr. Petredis or Mr. Sinardi.
Okay, that's fine.
Petredis and then Sinardi. Okay, very good.
Sinardi is closing it up for the defense, guys.
Okay, very good. Are we ready to proceed? Okay, let's bring in our jury. Okay.
All rise.
No time limits on closing. And she repeated the same thing from a few days ago where you guys know you can tire a jury out if you just keep going on and on and on.
All jurors are in.
Okay, very good. Welcome back, members of our jury. On the overnight recess, did anybody read, watch, listen to any news or social media posts about this case? Talk to anybody about this case or do any independent research about this case? See no hands, I take that as a no. All right, Mr. Gonzalez, on behalf of Defendant Rashad Murphy, do you have an announcement?
Your Honor, at this time, Rashad Murphy rests.
Okay, very good. Mr. Sinardi, on behalf of Davion Murphy, do you have an announcement?
Yeah, subject to all prior motions and objections, Your Honor, Davion Murphy would rest.
Okay, and Mr. Wise, on behalf of Sean Gathright,
Sean Gathright, rest.
and Mr. Petredis, on behalf of Defendant Isaiah Chance.
As AT of the rest.
Okay, and do all of you renew all previously made motions and objections? Mr. Gonzalez?
Yes.
Mr. Sinardi, yes?
Yes, Your Honor.
Mr. Wise?
Yes, sir.
And Mr. Petredis?
Yes, sir.
Okay, very good. All right, members of the jury, both the state and the defendants have now rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say, however, is not evidence or your instruction on the law. But please do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendants have given each of their closing arguments. All right, state?
Yes, Your Honor, make you support.
Yep.
Members of the jury, there is a real gang war going on in Jacksonville. ATK and 1200 are at war with 6 Block. It is blatant. They shoot each other and then they post about it on social media. When one of the opposition dies, you see photographs of Bill Belichick and Tom Brady, the GOAT, being posted in the early morning hours. You see laughing emojis. They produce and post drill rap videos, making fun of people who have been shot and murdered. There is nothing fun about the gang war in Jacksonville. And on June 23rd of 2024, this violence spilled into Tampa when these 4 men decided and planned and came to Tampa for one night for one purpose, and that was to hunt and track and kill Charles Jones. That is the only reason they came to Tampa. That was a planned, premeditated, cold, calculated, organized mission that they did here in Tampa on the only one night that they were here. They wanted to take out their rival. They wanted to kill Charles Jones. He is Mr. Six, Little Six, Six. He is 6 Block. He is the most prominent member of 6 Block. And the only reason that they were here in Tampa, Florida, was to kill him. All of their efforts were to kill him. This was a conspiracy that started long before June 23rd of 2024. This started in Jacksonville, long before they came here. And the evidence shows that. They conspired with one another to come to Tampa. There is never going to be an eyewitness in here that is going to be able to identify those 3 gunmen because they were prepared for this mission. They were heavily armed and they were masked. And those eyewitnesses that talked to law enforcement couldn't give one detail about those shooters because they were ambushed and they were afraid and they were fearful of their lives. Camilla Bentley panicked. She prayed in her car for the car to start. And in a panic, she fled out of that parking lot for her life and crashed into Armani Turner's vehicle. Armani Turner did the same thing. She backed up and she fled for her life with her passengers. She fled for help. She went and down that road that she didn't know and saw USF patrol, saw flashing lights, and got help, and then went back to where her boyfriend had been shot and gunned down. The two other victims in this case, Gino Norris and Xavier Edwards, they can't give you details about those shooters because they were in a vehicle. Gino Norris was asleep when all of a sudden he heard gunfire and then a car crashes. And they fled. They fled for their lives because they were in fear. They ran and they hid in the third floor of the Holiday Inn until law enforcement arrived to get them life-saving treatment. So there are no eyewitnesses in this case that can identify those armed gunmen because they did their job very well. They planned this to the most tiniest detail. You don't have an eyewitness, but what you have is much better than any eyewitness that can ever testify in any case. You have what we call a silent witness, the unflinching eye of a camera lens. The video evidence in this case tells you and shows you everything that happened to Charles Jones and his friends on June 23rd of 2024. All of those cameras at Truth 18. The cameras covering the door, the cameras covering the steps leading up to it, the parking lot. All of the cameras at Teasers, the first club that they went to, that covers the door and that parking lot. And it shows that Isaiah Chance, Sean Gathright, Rashad Murphy, and Davion Murphy, and Alicia Andrews were on a coordinated mission. You don't have to guess what they were doing because you can see it for yourselves. Those cameras don't lie. This is at Teasers. Every time where the victim was supposed to be, he was supposed to be at Teasers, the silver Chevy Cruze appears first. This is a coordinated attack. The silver Chevy Cruze is the surveillance team. They are the eyes of this mission. Their job is to track and locate Charles Jones. And Isaiah Chance is using his girlfriend, Alicia Andrews, for cover because he's got a COVID mask on in June in Florida so that his face cannot be seen. And he doesn't want to appear out in the open with other men, with other gang members, because that will tip Charles Jones and all of his friends that there is going to be trouble. This plan is planned in every detail. They are using a girl so he can be seen walking with a girl like he's just going out to a club. And the silver Chevy Cruze gets there first. And then after they walk around to the front and get eyes on the victim and see who he's with, see what vehicles that he is in, they communicate to the second vehicle, the black Chevy Impala. The video camera, every place the victim went, shows these two cars. And these are Jacksonville cars. There are two cars that come to Tampa, and they come to Tampa on June 22nd of 2024. You know from the mapping where they went. They went to the Airbnb that they had booked specifically to come down here to kill Charles Jones. That is all they did that night, was scout the location, track the victim from club to club, and then to the hotel where they finally kill him.
And get McDonald's.
The video shows you exactly what happened in this case. And the video shows that they were prepared. They brought their masks, they brought their firearms, and they thought ahead to have two teams. So the silver Chevy Cruze is the surveillance team. The black Chevy Impala is the hit team. Let's call this what it is. It was a hit on Charles Jones, and the evidence and the video support that that was the only goal that they had. At Teasers, they never go in that club. They never approach the bouncer. They never approach the door. Their only interest is Charles Jones. And when they see him, Alicia Andrews and Isaiah Chance leave. They've done their job. And they communicate to the second vehicle, Sean Gathright, who is in the Chevy Impala. Here is the victim. Again, this is the timeline, 2:29 a.m. And the silver Chevy Cruze has already parked, and the defendant, Isaiah Chance, and Alicia Andrews have walked around the corner and not approached this door, but walked enough around the back of that parking lot so they could see where the victim was. See his car, see who he's with. How many people are they going to see with the victim? How many people are they going to have to shoot and kill? This diagram shows, State's Exhibit 39, exactly their path that night. They're not there to go to a club. They're there to see where Charles Jones and his friends are. There is so much digital evidence in this case, and you have heard a lot about the license plate readers in this case, that show coordination, tandem movement between the silver Chevy Cruze and the black Chevy Impala. No dispute the silver Chevy Cruze belongs to a relative of Rashad and Davion Murphy. No dispute that Rashad Murphy specifically got a vehicle that is not registered to his name before coming to Tampa to commit first-degree premeditated murder. He got that vehicle for a specific purpose. No dispute, the black Chevy Impala is Sean Gathright's mother's vehicle that he personally uses, that we have video footage and license plate reader after license plate reader after license plate reader that show it in his house in Victoria Lane in Jacksonville. That's his car. Those two Jacksonville cars come to Tampa on the very day that they know Charles Jones, Julio Foolio, is scheduled to appear at a club that lists the address. And they scout that address. Their cell phone records show that they go there earlier because they're casing the location. They want to see where the entrance is. The cell phone mapping. We've heard a lot about the cell phone mapping. And those coordinates for all of the cell phones, for Alicia Andrews, for Charles, for Isaiah Chance, for Sean Gathright, for Davion Murphy, and for Rashad Murphy, the phone that stays in Jacksonville. Those records aren't provided by law enforcement. They are kept by the cell phone providers. It's their data from their equipment. Those are accurate information. Sometimes there is not all the data that may be available. Some may be missing, but it is accurate data. They are kept for business purposes, for billing purposes, for customer service to ensure their clients get the best coverage. Those are the records. Those are the data that law enforcement is looking at. But they don't just stop there. They confirm and they verify. They verify it with real video evidence showing that person in the location at the time where the device is registering. One example, Alicia Andrews' cell phone mapping shows her phone in the vicinity of Truth 18 around 4 a.m. And guess what? They're there. They're on video. 4:03 to 4:05 a.m., more video evidence, still shots from the video surveillance of Truth 18, showing them, again, they don't go to any club. They walk and they check out that sign. That sign happens to be right in front of, across the parking lot, the front door of Truth 18, the very club that Charles Jones and his friends are entering. They are tracking them, tracking Charles Jones and his friends. They are the eyes of the surveillance mission. Here's from her phone, from the digital extraction from the iCloud. That was taken on her phone. It happens to be a view of Truth 18 at the very moment when Charles Jones and his party are getting ready to leave. The evidence clearly shows they are conducting surveillance and they are communicating. Alicia Andrews, the person who is not in the gang, is communicating with Sean Gathright's phone, the other person not in a gang. That is how sophisticated they are. They planned this, and they planned not to get caught. They know law enforcement will be looking at them when this happens. So they are utilizing people that are not known gang members to use their phones and their devices so they do not get caught. And there is communication between her device and Sean Gathright's device all through the tracking of the victim, including Alicia Andrews' device sharing her location. 4:25 a.m. This is when she started sharing the location with Sean Gathright. 4:14 a.m., that is when the black Chevy Impala again arrives after the silver Chevy Cruze has already put eyes on the victim and his friends. The video evidence in this case has been examined by law enforcement, by Detective Ramos, multiple times to get all of the facts that we can. And these are the facts that you can see for yourself. These are the true facts of this case. And it shows coordination between those two vehicles. It shows the only reason and the only purpose that the silver Chevy Cruze and Isaiah Chance and Alicia Andrews are at Teasers and Truth 18 and then at Home to Suites is to get eyes on the victim. They're not there to have a drink. They're not there to go into a club. They have no interest in any of those things. That's what you do if you're a tourist when you come to Tampa. You check out the parking lot, you check out a sign. That's not what they're doing. They are there at the very moments that the victim is there. Charles Jones went into that hotel and then comes, and you can clearly see he is in the front seat passenger of his car. That is important because you will see that when the shooting finally happens, the shooters track the very vehicle that he is in. Because again, Isaiah Chance and Alicia Andrews have done what they are supposed to do. This second video is now when you can see the black Chevy Impala purposely going the long way around the hotel to park on the side so he does not come in direct eyesight or eye line of Charles Jones and his party. This is Tafa McRae pulling up. That's what happens next in the sequence. Again, another person that had been traveling with Charles Jones all night. Now you're going to see him and Aaliyah Albritton, I apologize, get out of his vehicle and go into the bathroom. And it's at this moment that Camilla Bentley pulls into the driver's seat. Here is the silver Chevy Cruze. It doesn't avoid the victim's party. It wants to know exactly where everyone is. They need to know where Charles Jones is. He's been wearing a bright red cap all night. They want to know where the other vehicles are. They are familiar with who Charles Jones is with. Xavier Edwards, Robert Howard. You know they know who Robert Howard is, right? He's the one that went to prison for killing Joe Rod Adams on a manslaughter. You know they know every single person who Charles Jones is with that night. Tafa McRae, close friend of Charles Jones, a relative. Xavier Edwards, Gino Norris, all close friends of Charles Jones. His girlfriend, they know all of the vehicles and all of the players that Charles Jones is with. The next sequencing is the silver Chevy Cruze going around the corner to meet up with the black Chevy Impala. And you saw from the Tesla video and the other video of the side angle that the black Chevy Impala isn't registering as a guest in Holiday Inn. They're not registering as a guest in Home to Suites. They're backing in at an angle behind the building so that they cannot be in sight line of the victim and his friends. Now the silver Chevy Cruze, again, will pass the victim, and this time they will have direct eyesight of where Charles Jones is. They are passing right directly in front of him and his friends and know exactly where all of them are parked. you can see the person with the firearm is targeting his exact location. This is another angle of both shooter 1 and shooter 2 coming around before they fire upon the victim and his friends. Guns already out, masked, and loaded for rapid fire, quick succession. Charles Jones never had a chance. Shooter number 3, hanging out on the back in the very path that Xavier Edwards would drive through trying to flee for his life. All of you got to see that for yourself. You didn't need a witness to tell you what happened to Charles Jones on June 23rd of 2024. The evidence is crystal clear and the videos do not lie. I don't have to prove that a gang war is going on in Jacksonville. I don't have to prove which members killed what other members. None of that is what is at issue in this case. It is relevant to motive, why this homicide happened. The state does not have to prove motive. That is added evidence to show you why this happened, but it is not required. The only 3 things that I have to prove, that the state of Florida has to prove to you to prove first-degree premeditated murder of Charles Jones is 1, Charles Jones is dead. There is no dispute to that, the first element. 2, the death was caused by the criminal act of the defendant. 3, there was a premeditated killing of Charles Jones. All 3 of those elements have been proven beyond and to the exclusion of all reasonable doubt. And you're going to see that it says the defendant. There are 4 defendants in this case, and you need to apply the evidence, look at the evidence to each one of the defendants separately and individually, and make separate verdicts for each and every one of them. And we have already talked about the principal instruction, but we will talk about that again. It does not matter that Isaiah Chance is in the scouting vehicle. If he intended for this homicide to occur, and he absolutely did, that is the only reason any of them are in Tampa. And if he did something to aid or assist, then you have to treat him as if he had done everything that the shooters have done. And that goes to all 3 of the shooters as well. They are all participating. We may not know which of their bullets penetrated into Charles Jones' vehicles multiple times and into him and killed him. But it is enough that they intended for him to die and that they did something to assist. They all did more than just shoot those firearms. You know they did based on the digital evidence. They tracked him, they followed him, and they hunted him. The digital evidence in this case makes no mistake that on their free time, when they weren't scouting teasers, they were online trying to locate him because the victim was posting online, saying that he is at an Airbnb. You saw all the digital evidence of Sean Gathright. He spent a lot of time looking for where that Airbnb is on his phone. Tried to set up a woman that he knows in Orlando to pose and call one of Charles Jones's friends to find his location at the Airbnb. Rashad Murphy also trying to locate where the victim is. They stalked him, they hunted him, they targeted him, and then when they found him, they gunned him down. That is first-degree premeditated murder. We talked about killing with premeditation. It is consciously reflecting to kill a person before doing it. And we talked about that there is no time that has been placed upon the requirement for premeditation. It can happen in seconds. This premeditation clearly had begun in Jacksonville when Sean Gathright and Isaiah Chance are loading up that black Chevy Impala with heavy bags. Attempted first-degree premeditated murder. This is for counts 3, 4, and 5, and only applied to the shooters. Gino Norris, Xavier Edwards, and Camilla Bentley all survived, but they were purposely shot at To prove attempted first-degree murder, again, we only have to prove 3 elements beyond and to the exclusion of all reasonable doubt. The defendant intended to commit the crime of first-degree premeditated murder. The defendant committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And the defendant failed to complete first-degree premeditated murder. They got to the hospital, and all 3 of them survived their injuries. So they were not another victim of this gang war. The line between mere preparation and an overt act is a question of fact, again, for you to decide as a member of this jury. Mere preparation consists of devising or arranging the means or measures to commit the crime. An overt act consists of some movement toward committing the crime after the preparation. You saw the loading of the bags, you saw they scouted teasers location, you saw they tracked the victim to 2 locations before home to suites. An overt act need not be the last possible act toward completing the crime. An overt act consists of some movement toward committing the crime after preparation. Let's take a look at those videos from home to suites. They're all shooting at the victim vehicle, the black Dodge Charger, and yes, they shoot at Typha McCrae's vehicle as well. He's gotten out of it, Camilla Bentley is in it. But you see, shooter 1 is shooting, shooter 2 is shooting, shooter 3 is shooting. Their muzzle flash goes off so many times, it is hard to count in those videos. The impact of those guns are setting off that Tesla multiple times. Xavier Edwards, the victim in count 3, shot in his arm. Gino Norris, the victim in count 4, shot in his arm. Take a look at the vehicle of the victim, Charles Jones, that black Dodge Charger. These aren't novices. You heard from Officer De Jesus, a SWAT-trained officer, to maintain proficiency for SWAT. He trains every 2 weeks, not just every 2 weeks. He said to be proficient, he does it on his personal time. To be able to be accurate in high stressful situations, to be able to be accurate in non-stressful situations is a skill. It requires training. Take a look at where these shots are hitting. Every place that was occupied in Charles Jones's vehicle, Xavier Edwards is the driver, Charles Jones is the front passenger, and Gino Norris is in the back. The driver and the passenger seats have been hit. And they haven't been hit just anywhere. They are hit on the headrest. That is skill accuracy. And if it is a hit team, these are kill shots that you are seeing right there. And
I want to see their faces right now.
That is exactly what they are. They are a hit team put together for the sole purpose of killing Charles Jones, Julio Foolio, their arch rival. Look at the back seat where Gino Norris was laying down. They thought he was laying down, or this wouldn't be another attempted murder. They intended to kill Charles Jones and every single person that was in the vehicle with him. That is attempted first-degree murder because they failed to do it. Gino Norris and Xavier Edwards survived. Camilla Bentley, count 5. They knew Typha McCrae was with Charles Jones, and they targeted his vehicle as well. Camilla Bentley was in the driver's seat and got out of there, but she got shot as well. They knew Charles Jones's friends, his entourage, his party was in this vehicle. And again, it is accuracy, it is skill, because those 2 shots are right to the rear window. And they cross in front to the front, and you know that they got her. They intended to kill all of the people in those vehicles. That is attempted first-degree murder. The black Chevy Impala. There is no video showing who is inside. There is no video showing their faces when they get out. They have been designated shooter 1, shooter 2, and shooter 3. Let's talk about principles. This is the instruction that the judge will read to you. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did. If the state proved beyond a reasonable doubt the defendant intended the crime to occur, and did some act or said something that was intended to, and that did incite, encourage, assist, or advise. This is an or. It just has to be one of these things. And you know that they did multiple things. All of them had multiple roles in this first-degree premeditated murder. For first-degree premeditated murder, the state must prove the defendants intended that the killing of the victim occurred. And they absolutely did. All of them. All of them knew coming to Tampa. That's exactly what the plan was. If the defendant is found to be a principal, he is legally responsible and accountable for everything that his co-defendants did. So how do we know who these armed, masked gunmen are? The video doesn't lie. There are a total of 5. 2 in the silver Chevy Cruze, and they are also covering their face with COVID masks. And then 3 in the black Chevy Impala. The first thing that law enforcement does is they locate and track who the registered owners of those vehicles were. And they did a lot of investigative work with license plate readers, narrowing it down, and that is called deductive investigation, and that is evidence. And they were able to locate the 2 very vehicles involved in this case and track them all the way from Jacksonville to Tampa. And it is no coincidence that they are not only from Jacksonville, but they actually happen to be members of the rival gang of the victim in this case. And it is no coincidence that both of these vehicles are at points traveling in tandem. They are passing the same license plate readers as the other one because they are traveling together. This is a coordinated mission. Every piece of evidence shows and proves that beyond all reasonable doubt. And it leads us to the Airbnb. The detectives in this case followed the evidence. You've heard from Detective Ramos how he found this Airbnb, how he was tracking LPR readers, how he found using cell phone footage of data that there was an Uber. You heard from the Ring camera that there was, when he was watching the Ring camera, he could actually hear the Uber driver have a conversation and realized that there was an Uber at play. And it led us to the Ring camera and the Airbnb on Gazebo Pond Lane that coincidentally is within a few miles of the very place Charles Jones was going to be performing. And here Alicia Andrews is by her cell phone records at the vicinity of the Airbnb. And look, there's video evidence showing that she's holding her pink phone in her hand. Here is, and all of these occurred June 22nd. You see the timestamp there. The motion has already happened. She's knocking at the door and somebody lets her in. She is the only one caught on camera. Go back. I want you to take a good look at this photo because it's also very telling. You saw the Vivint cameras from Sean Gathright's home, and you saw what was being packed and loaded up in the black Chevy Impala. People on vacation with heavy bags at a place where they are truly on vacation would park in the 2 very spots that are there for that Airbnb and unload those heavy bags. There is no black Chevy Impala that is parked in front of that Airbnb. There is no silver Chevy Cruze that is parked there because they know that Airbnbs have Ring cameras and you have to access the front door. They left out of that Airbnb many times that night. There was a scouting trip to Teasers. There was a trip to McDonald's. None of them are seen entering that Airbnb, even though Davion Murphy's phone places them there, even though Isaiah Chance's phone places them there, even though Sean Gathright's phone places them there. Why is it, do you suppose, they don't want to be seen in Tampa within a few miles of where Charles Jones is going to be performing? It is because they are intending to kill him, and they don't want to have any connection to Tampa. This Airbnb is first booked by, again, Alicia Andrews, who can't do it, and then is later booked by Rashad Murphy. This is Alicia Andrews, again entering that day, the only person caught on camera. After the crime had been committed, though, on June 23rd, after Charles Jones had been gunned down, they are now appearing on the Ring camera. Where had they been before then? Davion Murphy, Sean Gathright. Let's take a look. Detective Ramos went to this Airbnb. He filmed it. He took photographs of it. This is the pathway that you have to take in order to get into this glass sliding door with heavy bags. You got to go around the corner, park down that parking lot, and then you got to walk through grass and a dirt path, and then you got to go through a gate. They are hiding their appearance here. You never see Rashad Murphy. You never see Ghost on camera. That is his nickname, Ghost. He never breaks and goes in front of that camera, but you know he was there because the Uber driver picked him up from that location. Isaiah Chance and Alicia Andrews and Rashad Murphy leave Tampa in an Uber back to Sean Gathright. This is what the evidence shows. These are the facts. These are the facts that Tampa Police Department uncovered. It is a departure time of 15:08 and arrival time 18:32 hours. Travel time 3 hours and 24 minutes on June 23rd of 2024 after they had successfully completed their mission and taken out the head of their rival gang. There's the Uber trip ticket. You heard the testimony from the Uber driver. The only concern that they had was they wanted to eat at one point. Rashad Murphy stayed sleeping, didn't leave. But Isaiah Chance was worried about him speeding, told him not to speed a couple of times. Wonder why he's worried about speeding. Here is that Vivint camera that proves that Rashad Murphy, yes, Rashad Murphy happens to be at the very Airbnb that he booked in his name the day before. Whether he booked it or gave his license to Isaiah Chance, it doesn't matter. He assisted. He allowed his license to be used. And he's actually using the Airbnb. He's there. And there's proof of it on the Vivint camera. Alicia Andrews is there. There's Rashad Murphy and his hat. And they're going to Isaiah Chance's BMW. These are the facts and the evidence of this case, and you get to see it all for yourselves because it was all captured on video. Let's take a look at Rashad Murphy. That's him in the Vivint camera, and that's him after he had been taken in custody in Gwinnett County. Again, the investigation led right to him because the first piece of information that the detectives were able to crack in this case are those vehicles. They don't know the 3 gunmen yet. They don't know the 2 people who are tracking and are in the surveillance team, but they know the silver Chevy Cruze belongs to Jasmine Glennon, who knows Rashad and Davion Murphy, and they know the black Chevy Impala that belongs to Donnelly Lyle, Sean Gathright's mother. They don't know where those vehicles are because they fled Tampa the moment that they were done killing Charles Jones and got back to that Airbnb and celebrated. And when he is caught in Georgia, because there were bolos put out, felony bolos put out for both of those vehicles, the law enforcement authorities in Georgia located that vehicle, and you heard from those Georgia police officers that he immediately fled because he is in one of the suspect vehicles that was used to kill Charles Jones and injure his friends. He absolutely knows why law enforcement is looking for him. Let's take a look at this Walmart video. That is still photos from the Walmart where he's up there in the corner. That is the day before the murder, June 21st of 2024. And you can see what he's wearing. He's wearing all black. There's been a lot of talk about, oh, well, all black for gunmen is, I guess, not unique. And that may be true, especially for this particular gang, because all of the videos making fun of killing members of 6 Block, they're all dressed all in black just like this. But what somewhat is unusual, I think, in June of Jacksonville, Florida, hot, sunny Florida, maybe not all the black, because even I like to wear all black, but certainly a ski cap in June is somewhat unusual.
Oh, they're going to come for
But
me. I'm always
useful
wearing a
if
hat.
you need it to be pulled down and cover your face. He's wearing, and it's not just that he's wearing all black, it's also other things that you have heard that has been uncovered in this investigation. Detective Drabeck says that he is a lefty, that he has been seen using his left hand, Rashad Murphy. And based on the body style, after they have identified all of the players, they then start looking at the videos to see who fits what. And it just so happens
He's writing
also
right now with
wearing
his
these
hand.
black military combat boots with the leg of the jeans or these black jeans tucked in, just like shooter number 1 with the extended magazine Glock. And he's using a left hand, and his clothing and body style of the 3 armed gunmen fits shooter number 1. Do I have to prove to you who shooter 1 is, who shooter 3 is, who shooter 2 is? We will never be able to take off their mask, but we absolutely know every player in that black Chevy Impala, beyond and to the exclusion of all reasonable doubt. You do not commit first-degree premeditated murder with anybody else except trusted co-conspirators that are members of your gang, members of your allied gang, or somebody who is your close childhood friend who wants to be in your gang. They would not have let anybody else in to do this. And we all know who they were with. You also heard from Detective Drabeck about the left hand and how when he was interviewing him and when Drabeck was watching him that he was trying to use his right hand and was not quite able to write legibly when he asked him to sign his name. All of that, fleeing from law enforcement, lying to law enforcement, that is consciousness of guilt. They will never admit to law enforcement what they did. They will come up with lie after lie after lie. The cell phone mapping in this case was instrumental, and it is evidence. It is forensic digital evidence. And those cell phones that we all carry are like little miniature computers. And they are also tracking devices. Whether you turn on location services or not, when you are utilizing a phone, you are utilizing cell phone towers. And depending on the cell phone company and the type of technology they have, some are more advanced than others, some are advanced timing that try to actually pinpoint the location. And some is just cell phone data based on cell phone towers that still give you directionality and a range of where that cell phone is. But those records are kept by those cell phone providers for business purposes, and they are accurate. We have had hit after hit of where each of these players are, and we have been able to support their locations with video footage. Alicia Andrews' phone is at the McDonald's the night when Charles Jones is killed, right before they go to McDonald's. And you can see on video Davion Murphy. Davion Murphy lies to law enforcement when he knows they have him. He knows they've tracked him to Tampa. He's like, oh, I was at an Airbnb. And he gives this name of Darius Beals and says, oh, I was there, but I wasn't there on the 23rd. On the 22nd. I was there the 23rd after the murder occurred. He doesn't want to place himself in Tampa on the 22nd because he knows what that means. He knows that that means he was in Tampa before Charles Jones was gunned down, and he was in Tampa when Charles Jones was gunned down. So he lies. He never admits to being at this McDonald's. But you know that he is lying, and that he is lying for a reason. Alicia Andrews' phone is there, and so is Davion Murphy's phone at 1:40 a.m. after they had arrived to that Airbnb. Silver Chevy Cruze, again, the video doesn't lie, the cameras don't lie, and this McDonald's has a camera at every angle on the exterior of that McDonald's, as well as on the window of the drive-through, where now we can all see for ourselves Davion Murphy. Again, Alicia Andrews' iCloud, and I want to mention this, these are extractions from their phones from Apple, because we never get the device of Alicia Andrews. We never get the
Extreme
device
tacos.
of Sean Gathright. We never get the device.
Wait, this was our favorite thing from the Alicia Andrews trial because it had the Fukenburger and Extreme Tacos and Taco Bus. You guys remember this? And we went all in on voting where we'd go for a group trip for the Alicia Andrews trial.
Of Isaiah Chance. Because they had gotten rid of them.
And they went to
You've heard
McDonald's.
testimony that they had new phones. That Detective Ramos had to go to Apple to get what were considered backups. Because if you have an iPhone, regardless of whether or not you get rid of and destroy your device, if you back it up, Apple will have it. So the data from the phones that we get in this case aren't from their phones. And again, they have gotten rid of phones for a reason. You saw Sean Gathright get pulled over in Jacksonville after this crime. He had a new phone. And also a piece of evidence was a sheet with all the phones that he wanted to program his new phone with. And 2 phone numbers on that sheet were Charles Jones, wasn't written Charles Jones. Next to Charles Jones's phone number was G. His nickname is Guttaman, Guttazay. He knows him as G. And Rashad Murphy is also on that note because he wants to make sure that he still knows Rashad Murphy's number. But Rashad Murphy, that shared phone number that he and Charmaine Steiger have, that phone number was written down. Rashad Murphy's name was not written next down to that. GH was. GH, the first 2 letters of Ghost. He gets rid of his phone, he thinks he's deleted the data, and now he's got to reprogram his phone with all the important numbers that he'd written down so that he could reprogram his phone. So ask yourselves why, like any normal person that has an iPhone, that gets a new iPhone, just relies on the backup. Because if you want to know all of the phone numbers that you have saved over the years, nobody remembers numbers now because it's just a click of a button, a click of a profile pic. You just go to an Apple store, Verizon, or whoever your carrier is, and they do what? They back up the phone and all of your contacts, all of your data magically appear. Unless you do not want somebody to see what you have been doing on your phone and you deleted it, but you forgot about the backup and didn't realize law enforcement could still get it. So again, not just the ammunition suitable for firing in an AR found in his car after the homicide, but proof that he had got rid of his phone and was reprogramming it with 2 very close contacts, Ghost and Guttazay. This is from Alicia Andrews' extraction, showing her again following and tracking the victim, going to teasers. More mapping of her 341. And then, of course, we see coordination, verification, proof, because we know she is in the silver Chevy Cruze with her boyfriend, Isaiah Chance. And yes, there is photographic evidence that backs up and support all of these phone records and the cell hawk mapping that was done on the advanced timing. Photo that she took from, or her or Isaiah took at Truth 18 parking lot, still on the Apple iCloud. And again, we see her leaving, going to the Uber, and again, her phone is showing she's exactly in the vicinity of the Airbnb the following morning. And the Uber driver, the tracking of her phone again continues throughout the state of Florida as she's going home. And again, her very location is supported by the license plate reader in Bradford County, showing she is in that vicinity when she is driving by in the Uber, driving to Sean Gathright's house. Let's look at Isaiah Chance's cell phone location. This is before the murder. This is when he is at Sean Gathright's house. This is when you clearly can see a firearm with an extended magazine. Just like what shooter number 1 is carrying and firing at the victim in Home to Suites the following day. And guess what? His phone records, Isaiah Chance's phone records, put him here at the very time he's arrived to start loading up at his good friend Sean Gathright's house. And make no mistake, they are good friends. We have multiple hits of that BMW, Isaiah Chance's BMW at Sean Gathright's house. But again, based on what you actually can see, when you see the video cameras from Sean Gathright's house, you see Isaiah Chance, he knows the code. He just casually goes in. You see a family dog that does not bark at him. You see that he freely enters this location. They are good friends. He has entrusted a good friend to conspire with to commit first-degree premeditated murder. Here he is loading up. Again, his cell phone places him there at the same time where you can see him on video. His cell phone, there is not as much activity during the course of the homicide because they really are relying primarily on his girlfriend's phone. But there are a couple of times that his phone is providing location data at the same time that Alicia Andrews' phone is providing location data. And at 2:30 a.m., it is showing him in the location of Teasers when the silver Chevy Cruze is there, when he can be seen on video walking with his girlfriend in that parking lot. It is there when, I'm sorry, this again is Alicia Andrews when she gets back the next day, 6:23 after the homicide. This is another one of Isaiah Chance's. Going back to 2:38 a.m. Again, silver Chevy Cruze, not black Impala. And this digital evidence has allowed us to show which one of the two tall individuals is in which vehicle. We know based on the cell phone data and the videos that it is Isaiah Chance with his girlfriend Alicia Andrews in that silver Chevy Cruze, because his phone is also hitting when it is only the two of them in that vehicle at approximately 2:38 a.m. His cell phone does ping at the murder scene. There's 3 pings that occurred around the time when the homicide is being committed. This is again the silver Chevy Cruze, his phone 441. We know that this is the silver Chevy Cruze. You heard from Detective Ramos that there was a little bit of damage unique to this particular vehicle, and when they finally located the vehicle in Georgia, it had the exact same type of damage. His cell phone mapping, putting him at the Airbnb when you can actually see him holding his cell phone, and clearly can see that that is Isaiah Chance. Again, another hit when they are putting up at Sean Gathright's house. We have now moved on to Sean Gathright's cell phone. His phone is obviously there. Loading up heavy bags into the suspect vehicle that carried the 3 armed assailants that gunned down Julio Foolio, Charles Jones, and gunned down his friends. Again, black Chevy Impala, car belongs to his mother. He is the primary user of that vehicle. No coincidence that his cell phone is pinging in that very location around Teasers at the time the vehicle finally shows up at Teasers. More cell phone mapping. This is when it is staging across the street from Truth 18 after the victim has arrived at Truth 18. Again, his phone data put him in that vicinity, corroborated by video photographic evidence that he is the person in the black Chevy Impala. Again, at the murder scene, black Chevy Impala parked, drives the long way around. Eventually he gets out with the 2 other gunmen. And no surprise, no coincidence, here we are the next day when he is entering a code to get back into the Airbnb, probably because that's the first time he's actually used the front door. But again, you see his cell phone device in his hand, and the data provided by AT&T clearly show that that device is in the vicinity of the Airbnb. Here we go to the Polk County 475 Opal. Afterwards, he gets rid of the black Chevy Impala. This is what is a hot car, right? He's just committed first-degree premeditated murder of a highly prominent rapper in Jacksonville. They shot up not just Julio Foolio, not just Gino Norris, not just Xavier Edwards, not just Camilla Bentley. They fired upon a fully booked home 2 suites. You heard that there were other people that were there that were impacted by the gunfire, even though they weren't shot. They are firing AR rifles
No, they're
in a
not.
public parking
Exhibit.
lot of Home to Suites and Holiday Inn with enough firepower not only to penetrate the cars, but to penetrate the buildings, windows, AC units. You heard from Pablo Gabor and how his family was staying there and was awoken to bullets penetrating their hotel room. You heard from Audra Agramante, who is moving her daughter into the USF dormitories, how they were awoken by gunfire and how she was flung to the floor because bullets were coming through their window. They know that an investigation is begun. I want to talk to you about tampering with evidence. The only defendant that is charged with tampering with physical evidence is Sean Gathright. And it's because what he does here. To prove tampering with physical evidence, the state must prove the following two elements. Sean Gathright knew that a criminal trial, proceeding, or investigation by duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee of Florida was pending or was about to be instituted. These are ors. And so what we are talking about, what we have to prove for element number one, is that he knew that an investigation by a law enforcement agency was about to be instituted. You shoot and kill a high-profile, prominent rapper from Jacksonville. You shoot up a Home to Suites and Holiday Inn that had many people, many guests staying there. You absolutely know law enforcement will be starting an investigation. There is no doubt he knew that they would be investigating the homicide of Charles Jones and the attempted homicide of 3 of his friends. And knowing that, element number 2, Sean Gathright altered, destroyed, concealed, or removed any item with purpose to impair its availability in such proceeding or investigation. So there's 2 things that he is doing here. He has actually removed the suspect vehicle, and he is concealing it. He doesn't want to be caught in the vehicle that was used by the 3 armed assailants, including himself. So he is going to hide it at Grandma's in Polk County. He's not going to take it back to Jacksonville with him. It's a hot vehicle. Sorry. But there's another video that you saw, because the one thing that he does when he loads items out of it and then goes to the gold SUV, he's seen on camera wiping the doors. And I know there's been a lot of talk about there's a rag with DNA, law enforcement can get it. What we are talking about is wiping down fingerprints. There is no need for law enforcement to do fingerprints in this case because he has wiped down the very areas that his other co-conspirators, his other principals to murder who were in that car, he's wiped them away. He's destroyed it. He's removed that evidence. That is the basis of the tampering with evidence that is count 6. Cell phone mapping again. Davion Murphy, he had the least data that was provided by the cell phone company. And you heard from Detective Ramos that he reviewed all of the data. And when looking at all of the data, there is something that is different during the time when the homicide is actually being committed. There's hardly any data there. And that can happen when a phone is powered down or not in use. And it is not typical of what you normally see by his regular data use. Lots of activity before the homicide, lots of activity after the homicide, no data during the homicide. So again, a known gang member who's concerned about phone being tracked can obviously shut off their phone and not use it. And he would not have had a need to use it because the 2 phones the vehicles were utilizing to communicate back and forth were Alicia Andrews and Sean Gathright. But again, cell phone data confirmed by video photographic evidence that Davion Murphy is indeed in Tampa, Florida on June 23rd, a few hours before his arch rival, his arch enemy, is shot and killed. There he is at the Airbnb. You also heard the video of Charles Jones. Charles Jones seems to be somewhat upset that Davion Murphy is appearing on the Ring video because Davion Murphy is not supposed to be there. Again, more cell phone evidence from Davion Murphy, not just at the Airbnb when he's captured on film, but also the silver Chevy Cruze. Rashad Murphy takes the Uber to Jacksonville. Somebody has to drive the silver Chevy Cruze back to Jacksonville. Cell phone mapping of Davion Murphy places him in the area when the silver Chevy Cruze is being driven back towards the Jacksonville area after the homicide. Now let's talk about the other evidence that is critical in this case. We have already established all of the elements of first-degree premeditated murder, of attempted first-degree murder, by showing you who were in those two vehicles. There is no reasonable doubt that all 5 parties have been identified. The 2 trackers in the silver Chevy Cruze, Alicia Andrews and Isaiah Chance, the 3 masked armed gunmen, Rashad and Davion Murphy and Sean Gathright. But there is even more evidence that shows they absolutely are the people who committed this horrific crime that terrorized all of those victims that were with Charles Jones that night. After they locate the black Chevy Impala and realized he has switched vehicles, they put out an alert to Jacksonville Sheriff's Office, June 26th of 2024, to the vehicle that he is swapped out for, the gold Toyota SUV. And there's a traffic stop on Sean Gathright.
His face in that frame.
And there is a multitude of evidence that is found in his car. We talked about the skill and the training to accurately be able to shoot and accurately shoot the driver and all of the passengers, as well as the driver of vehicle number 2. There certainly is enough evidence that shows that he was highly trained, he was highly skillful in being able to shoot an AR rifle. And all of this is relevant because they are parts or ammunition that are suitable for use in the very types of weapons that were used to kill Charles Jones. You heard a lot of evidence, again, from Officer De Jesus about what these parts are and what kind of firearms that they are used for. And this Max Tech is the same brand that was utilized here in Tampa and found in Tampa. All of this is relevant and shows not only that he is highly skillful and trained, but also connect him and is relevant that he has the exact type of parts suitable for use in AR rifles. He has the exact type of Mac Tech ammunition for the handgun. The only shell casings that were left in Tampa were Max Tech, and he just happens, again, coincidentally, to have that very brand in the vehicle that he is driving after he switched out the murder vehicle.
Tell us about the
But
knife and
more
hit.
importantly,
The knife and
and
hit.
you've heard a lot of testimony from Amara Drew, you heard a lot of cross-examinations
This
about
is so dumb.
the shell casings that are in this box from his vehicle. Before we go to his, I'm sorry, let me back up. Amara Drew was able to get the spent shell casings from the attempted murder of Charles Jones from October 7th of 2023. You've heard that there have been multiple attempts on Charles Jones's life because of what he does, because of the type of drill rap music that he does. They have tried to kill him before. And you have heard a lot of questions, cross-examination. There has been nobody arrested for that attempted murder. They did not know who did it. But in the investigation of this case, of this homicide, that led to the arrest of Sean Gathright and the stop of his vehicle, they now can connect him and his co-conspirators to the attempt on Charles Jones's life that occurred in October 7th of 2024. They tried to kill him before. They were not successful. And this time they were going to ensure that they were successful. You've heard how blatant this social media war is. You heard how after Charles Jones was shot in that foot on October 7th, that he gets online and goes live. This is what they do, and kind of taunts them, says, "I'm still alive," words to that effect. They were not going to miss him when he was in Tampa celebrating his birthday at a known location. This is evidence of motive. This shows that it is no coincidence that Sean Gathright and his good friend Isaiah Chance, who is an ATK, maybe going to 1200, allied with 1200, are with Rashad and Davion Murphy, arch enemies of Charles Jones, that they are connected to the attempted murder on Charles Jones's life. That is the most relevant evidence of motive in this case. They are tied to trying to kill him months before this occurred. Ballistically, that is the fact in this case that they cannot refute. It was fired by the same gun in that box. The same gun fired. Those shell casings are the same gun that fired at Charles Jones and injured him in October 7th of 2023. Then we get to the search warrant of his residence. 2 AR rifles, 2 AR style rifles located, similar in appearance to the ones that were used in this crime. Brass catchers, like the ones that were used to commit the homicide of Charles Jones. You saw the video footage. How many times were the two gunmen, shooter 2 and shooter 3, firing those rounds from those AR rifles? All of that muzzle flash. No shell casings left behind, because they had devices like that attached to it, trying not to leave evidence behind. Fortunately for them, not AR rifle spent casings were found, but 2 9mm spent casings were found. They did leave 9mm casings behind in Tampa, Florida. 31 to be exact. They did their best to try to get DNA, couldn't get DNA off of them. That was the only thing that those shooters left behind that TPD was trying to trace. But they were able to connect them ballistically, because out of Sean Gathright's safe in his house in a brass catcher, a mesh brass catcher, are 2 9mm shell casings that again tie them directly to the homicide here in Tampa. No doubt, no question. You heard from Amar Drew, the same gun, the same 9mm that fired those 2 shell casings in Sean Gathright's house are the same gun that shooter number 1 unloaded on the car of Charles Jones on that Home to Suites video, where he left all 31 of those shell casings. They got rid of that gun. They got rid of their phones. They got rid of that gun. You've heard about other 9mm that were tested that they had. We never found the 9mm. That's what Amara Drew would need to be actually able to test to see if we got the gun. We never recovered it because they got rid of it. These are photos of the gun. And again, everything else that was in Sean Gathright's house, all suitable for use in the weapons that were used here in Tampa to kill Charles Jones and injure his friends. The other thing you saw, I don't have pictures of it here, was evidence of destruction of evidence of firearms. They pulled out of the sink, soaking in water, a bunch of boxes and packages that had been ripped up and torn. As TPD pieces them back together, you all see that those are parts belonging again to firearms. Now let's get to additional evidence. There is a mountain of evidence in this case, and I'm going to go through it quickly.
Before you do that, just go ahead and take a quick 5-minute comfort break, okay?
Okay.
All rise.
Okay, we'll jump.
Instruction at the bottom of it, I looked at the standard, they give an example of what instruction at the bottom of it. I looked at the standard, they give an example of what extension of your body is, but I don't think that's applicable in this case.
I don't think so.
Yeah, so I'm just going to remove that. And then I also noticed for the verdict forms for Rashad and Davion Murphy, there was just one on count 5, the special findings. If you find Dave, and this is the same for Davion and Rashad Murphy, if you find Davion Murphy guilty of attempted first-degree murder, attempted second-degree murder, aggravated battery, and it was missing or attempted manslaughter in count 5, you must then answer the following questions about carrying, displaying, using a weapon, or being a member of a gang. So that, just in count 5, it was missing attempted manslaughter. In counts 3 and 4, it had attempted manslaughter, but in count 5, it did not. So I just corrected that. So I'll print those up. I don't know if you're going to use the verdict form in your closing, but I'll print up the corrected one, which I believe to be the corrected one, and the AGVAT in the event you wish to use it, Mr. Gonzalez. And then over the lunch break, I'll get everybody the corrected ones, okay? Okay, very good. I'll be back.
right, so now we can skip. So they cleaned up some of the jury form issues. That was kind of a long break.
State, you ready to go? Sure, go ahead. Yeah, no worries.
These cameras really be all in the pores. Like, you could start counting them. Jenna Finkelstein is like dying laughing over there. Wonder if she'll get yelled at by the judge.
Bring her back in.
All rise. All due respect.
Okay, very good. Welcome back. Everyone have a seat. And you may continue.
Thank you, Your Honor. Members of the jury, you have already seen a mountain of evidence that shows that Tampa Police Department identified each and every one of those 5 people that came to Tampa in those 2 vehicles. The forensic evidence just adds on to that. There is no dispute with the video evidence and what it shows, and that shows a highly organized and planned first-degree premeditated murder. We have been able to show and prove to you who were all 5 of those individuals that traveled here for a day and did nothing but stalk, track, and follow the victim, based on the video evidence and the cell phone evidence alone. But after the detectives did a further, deeper investigation into all of the forensic digital evidence out there, it is beyond all reasonable doubt that all 4 of those defendants, Rashad Murphy, Davion Murphy, Sean Gathright, and Isaiah Chance, are the 4 men who conspired to kill Charles Jones, traveled down to Tampa for one day in order to do just that, and they did kill him and shoot up his friends. And if you look at these Instagram accounts, all of the social media, we know who they are. Rashad Murphy goes to 187, Sean Gathright, that's his Instagram name, 5 Yandre, and Isaiah Chance, Gutazay. We have all of their cell phone records. We know what their phone numbers are. We know what some of the information that was on their phones, not because we got their cell phone devices with the exception of Rashad Murphy, but because we got Apple iCloud search warrants and got the data from the backups from their cell phone devices. We got their iCloud accounts via search warrant. Sean Gathright's Instagram return results shows what his username is, his account identifier. These are a photo from his Instagram. These are the different accounts that are associated with that phone number, with his Apple iCloud, and with his phone number. You heard all of that testimony from Detective Ramos and all of the information that was obtained from their Apple iCloud, from their Instagram, from their social media that prove that they were tracking and hunting the victim while he was in Tampa. Isaiah Chance, Mr. Richoff War. There is a very real war going on in Jacksonville between ATK, 1200, and 6 Block. And he is a do-it, and he is getting rich off of it because he is willing to take out Charles Jones, the head of 6 Block. There's a reason he changed his name to Mr. Richoff War. Another one of his names, Mastermind. That's his phone number, at @Gutazay, at Gutazay. These are his Gmail, that's his Gmail account, Gutazay42. All tracked back to him and his phone. This is one of his postings from Instagram. Rashad Murphy, Ghost 187, Ghost 187 official at Gmail. You heard that there is gang detective after gang detective that knows Rashad Murphy is Ghost. They just know it. Detective Ramos actually went out of his way to prove and tie this Instagram account to Rashad Murphy, because you could put any name to set up an Instagram account. You heard what he had to do to actually connect him to Ghost 187 to ensure that we know that he indeed is Ghost. The same way Sean Gathright refers to him, GH, on the notepad to set up his phone again. His Instagram return, the vanity name, Ghost 187, there was a Gmail that was associated with it. Subpoena to Google. Google Pay, when you are going to actually use finances or bank information to pay for something on Google, you cannot now use a fictional name. So he was able to get the actual real information, financial account, and the actual legal name associated with Ghost 187 official at gmail.com. And it is Rashad Murphy. Davion Murphy, that is his phone number, that is his Gmail account. Shug Spaz is what he is using to set up his T-Mobile. Again, you don't have to use your name, but you know the significance of Shug Spaz. That is the name he used as his subscriber name. Isaiah Chance, June 6th of 2024. The only count I haven't talked to you about yet is criminal conspiracy, and that is count 2. And all 4 of the defendants are charged with it, because all 4 of them conspired to commit Charles Jones. And criminal conspiracy is just the act of conspiring and agreeing to commit first-degree premeditated murder. And we have started our conspiracy from June 6th of 2024. It probably goes back even farther than that, in Jacksonville and Duval County, and continued on here into Hillsborough County when they actually committed the murder of Charles Jones. But we start the conspiracy, and I'm going to read to you what are the 2 elements we have to prove beyond all reasonable doubt to prove criminal conspiracy. The intent of the defendant was the offense of first-degree murder would be committed. In order to carry out the intent, the defendant agreed, conspired, combined, or confederated with one or more of his co-defendants to cause the first-degree murder to be committed either by them or one of them or by some other person. Those are the only 2 elements that we have to prove, that they conspired with another one of their co-defendants to commit first-degree premeditated murder. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or words that pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. This is a crime just to agree to do it. And here, this case, we actually have the completed crime. They are all guilty of this. The reason it says it's not necessary that the agreement or conspiracy be expressed in any particular words or words passed between the conspirators. When conspirators plan a cold, calculated, evil murder, there will be no witnesses outside of the co-conspirators to that conversation. We will never be able to present to you what they actually said when they were planning to do this, when they were planning to commit a hit on Charles Jones, because they are all in it together. They are a gang and they trust one another. They are family to one another, and they are not willing to talk about one another. And there will be no witnesses to that conspiracy. But the evidence in this case proves that they did conspire to do just that. The facts and the circumstances of how this crime was committed, how it is all captured on video from the beginning at Sean Gathright's house to them loading in, to all of those vehicles meeting together with all 5 of those individual people coming together already knowing what they are going to do in one night. And they did it. That doesn't happen unless they conspired and they planned it. So all of the facts and the circumstances that you have seen prove that they are all guilty of conspiring to commit first-degree premeditated murder. Not only did they conspire to do it, they actually did do it. And so when we talk about conspiracy, we do have evidence of it because, again, this war is so blatant that it went on social media. There is actually an Instagram story that law enforcement, gang detectives in Jacksonville, Florida, monitor. They monitor their Instagram. They monitor their Twitter. It's called X now. They monitor it all because they know that these rival gangs get on social media and taunt one another. They post drill rap videos. On June 6th of 2024, Isaiah Chance eventually gets on X with Charles Jones. But before that, again, we had ample evidence from his Instagram account and his postings of what he is posting about, which clearly show, again, we're going to talk about a gang enhancement in a little while, but that this is a gang war that is going on. He says, Heem, you never did shit about Tilly Green, ass purple. Light skin, F you. Couldn't even go get them ones who was sliding. Don't do shit, but you run your mouth all day. He is talking about Tilly, and you heard from those Jacksonville gang detectives about the significance of Tilly. Tilly is one of the people on his side that have been killed in this gang war. And you heard what they were talking about, these postings, that he is posting it and that he is upset. He's upset with ATK because nobody has gotten street justice for his friend Tilly. And he is very vocal and active on social media about this. And then there's even a thing, go to my Twitter, Instagram, keep deleting his stuff because of the content of what he is posting. That takes us to June 6th of 2024. I'm not going to play it again, but you saw that there was a dispute. And this is an open forum. It is a public forum. Anybody can be watching. Jacksonville Sheriff's Office is watching anonymously and recording it because Gonzalez is talking to his arch rival, Julio Foolio, Charles Jones. And they recorded it. They screen recorded it. And you heard that they are arguing on social media that Charles Jones may have talked about or accused him of being gay, and that Charles Jones is taunting Isaiah Chance. And you heard that Isaiah Chance specifically talks to the victim and asks him about what? How's your foot, cuz? Again, another tie to the fact that they tried to kill Charles Jones by shooting him earlier in October of 2023. He basically is asking him about that injury. And you know that he and Sean Gathright and his co-conspirators are connected now ballistically to that attempt on Charles Jones's life. And at some point, Charles Jones says, you've got bigger fish to fry, and there's a back and forth exchange between the two of them. And why do we start the conspiracy then? Because we know that there is a dispute between the two of them. We know that they tried to kill him earlier in October. But right after this very public display on social media for the public to see, his two co-conspirators, Sean Gathright and Ghost, who is saved in Sean Gathright's phone as Ghost, surprisingly enough, because this is from the Apple iCloud information, there is messaging between the two of them shortly after their good friend, Gonzalez, and the victim in this case, Charles Jones, is going live on X's fighting. They're concerned. They don't want public exposure right now. You have Rashad Murphy contacting Sean Gathright, Isaiah Chance, Gutta Zay's good friend, saying, make sure you're brought in a good headspace before we go with his move. We got bigger shit to tend to, ain't worth any energy right now. They don't want him publicly on social media fighting with the victim. They're very much conspiring to kill. It's not a good look to be in a public war with somebody they are personally trying to take out. Sean Gathright likes that message that Rashad Murphy sends. It is clear who they are talking about. The only person who just went live, it was their good bra, is Gutta Zay. Sean Gathright, I ain't heard from bro, but I'm gonna check with him. And then Rashad Murphy says he's probably not gonna pick up. He on IG, Instagram, letting these and get him out of character. He turned up on that right now. Also on Rashad Murphy, who's at war with Charles Jones, he coincidentally follows and looks at his very rival's Instagram because he is tracking him. He is following him, not because they're good friends. Charles Jones's group, his friend Robert Howard went to prison for shooting one of his cousins. They're not friends, but he is tracking Charles Jones's social media and actually has saved the very profile picture of Charles Jones to his own. June 14th. This is when Charles Jones is publicly posting on Instagram that he is going to be on Tampa celebrating his birthday at Teasers with the address, June 14th. This is why we have started that conspiracy as far back as June 6th of 2024. It is clear they are already planning on killing Charles Jones. They are already conspiring to do it. Gutta Zay, Instagram, ran up my money and all songs gone. This is another posting, 6:30 on Gutta Zay's Instagram. This is a photo of Tilly, another victim of this gang war, one of his friends that he's posting June 14th. This is Ghost 187, Rashad Murphy, liking Charles Jones' posts. So we know that they know Charles Jones is going to be here in Tampa and where and when he will be. They're not doing this because they like him. The extraction of Rashad Murphy's cell phone in Georgia. All kinds of stuff were taken out of his phone. They couldn't do a whole download because of the state of the phone, but they were able to get some cell phone extraction information. Again, he had a license of his cousin, Davion Murphy. We know that they are connected. We also both know that they are 1,200. Rashad Murphy's cell phone extraction had Isaiah Chance in his phone, saved in his phone. Connection after connection. There is a Youngin Ace video screenshot that was on his phone. Double G. Again, we know that is Isaiah Chance on his phone. This is on Rashad Murphy's phone. This is a posting on his phone of the victim, Charles Jones, Big Six and Little Six. And then a photograph on his phone of a black Dodge Charger. This is Charles Jones's black Dodge Charger. They are already tracking him, garnering intelligence, so they know what vehicle they need to look at when they come to Tampa to hunt and kill him. This is intelligence that they are gathering. That is the vehicle after they shot him up. And it matches exactly a photograph that he already had saved in his phone, so they knew exactly what type of vehicle Charles Jones would be in when he was in Tampa. Alicia Andrews' iCloud messaging. They need an Airbnb in Tampa, June 21st. Again, the day before they leave to Tampa. They are trying to get someone who is not associated, not affiliated with the gang, to put an Airbnb in her name. And this is what this exchange is. She specifically is looking for B&B in Tampa. Falls through. So let's go back to Rashad Murphy's cell phone extraction. This is a photograph of a picture that is on his phone wearing the same outfit, the same black boots that he shown in that Walmart video. And you can see this black mesh bag. You can also see the handle of a firearm. June 22nd, the day before coming to Tampa, he's wearing all black, he's got a black ski cap on his head, He's wearing all black, and he's got a firearm. He also already has obtained the silver Chevy Cruze that they use as a surveillance tracking vehicle for their mission. Cash App records. The forensic evidence in this case goes on and on and on, tying each and every one of them to this conspiracy to commit first-degree murder, and it shows them that they are tied and connected to the gangs, that they are themselves in it, and that they are friends with them as well. Isaiah Chance, Cash App records, Mr. Rich Off War, his correct address from his driver's license set up this account. Cash App is how we pay for things. These are all the display names that he has used. Clearly, he is the owner of this Cash App account. It has his official name. It has his nicknames on there, Double Gutazay, Redmond 23. And finally, back in 2023, August 11th, Ghost, August 11th of 2023, Ghost, and then August 11th of 2023, he changes his name to Mr. Rich Off War. There's only one gang war that you have heard over and over about in this case, and it is because it is evidence of motive, why all four of these defendants did what they did. And there is a connection. There is a $390 payment on the Cash App to Mr. Gutazay, Mr. Rich Off War, Isaiah Chance from J. Greasy, $390 Cash App payment on June 22nd of 2024, right before Mr. Rich Off War has to make the payment for the Airbnb that is in Rashad Murphy's name. Airbnb booking subpoena is again confirming that that was the actual address of the Airbnb, claiming that he had no idea that the Airbnb was in Tampa because on the messaging to his phone it just says Pond Oasis. He had no idea he'd be in Tampa, yet he tells law enforcement and lies to law enforcement when confronted with the actual evidence that they have against him. Oh yeah, I did go to the Airbnb just for a second. Lie after lie, not in Tampa, not in Tampa, not in Tampa. Oh, we've got you on video surveillance at Sean Gathright's house getting out an Uber. Oh, I was in Tampa. I did go to the Airbnb. I just went there for a second with Darius Beals. I didn't have my phone. I used Darius Beals' phone. Lie after lie. It is no mistake why he used a dead person as an alibi, because law enforcement wouldn't be able to question him. But what him and Davion Murphy, who also tries to use Darius Beals as an excuse, as a way they mysteriously got to the Airbnb, not before the murder occurs, only after, to stay there just a second. He can't tell law enforcement how he gets the address to the Airbnb and now how he mysteriously knows it is in Tampa, because he actually drives and shows up and gets there. We all know he does, because he's there when the Uber gets there. He has been there all along as part of this mission to kill Charles Jones. Connection after connection after connection. He is on the Airbnb account with his ID. The cell phone extraction of Rashad Murphy has Isaiah Chance saved in his phone as Vetaman. There is no mistaking their connection. Here's the screenshot of the confirmation of the Airbnb that is sent on June 22nd in the early morning hours. And coincidentally, his driver's license is screenshotted at the same time. They are tracking the victim. They are hunting him. I've said this time and time again, not just based on the video, proven by the video evidence from teasers, from Truth 18, from the USF poll cam, from the cameras from Home to Suites, but it is proven on their social media. The victim only location that he posted was teasers. He advertises about a pool party. He doesn't give out that address. All they know is Tampa, Florida. Here's a message some point at if the girls want the address, DM him. So he's not giving out the Airbnb address. So we have Rashad Murphy, time-stamped again, got a man, 6:22. There's a conversation between Isaiah Chance and Sean Gathright, where Sean Gathright is receiving the address of the Airbnb in Tampa. No surprise to anyone. And then a screenshot again, Rashad Murphy has got a man 6:22 is when, 7:55 is when Isaiah Chance, Alicia Andrews, and Sean Gathright get to the Airbnb, 7:55. And then there is a screen recording from Julio Foolio, Charles Jones, posting about the 5 to 6 o'clock pull-up pool party. And that is
This
screen
stupid
recorded.
recording is
Not-
wild.
We know that that's on, on Charles Jones' Instagram, because Detective Ramos watched it after the homicide occurred and then got the records of all of Charles Jones' Instagram stories. But amazingly, coincidentally enough, it is on Sean Gathright's iCloud return. He recorded where the victim was going to be at a pool party. And then what else do we get from Sean Gathright's phone? He knows that this is part of Charles Jones' story on Instagram, showing the Airbnb, has a lovely pool, it is waterfront. We know this is the Airbnb he's staying at because that's Gino Norris in the background. What does Sean Gathright do? He saves it in his phone. The mortal enemy of his close friend Isaiah Chance. He has 9700 North Nebraska, address to the club. We know that this is his phone. It shows Victoria Lakes, his home address, as one of the main locations. Shows that he is already checked out and is looking at Teaser's Gentleman Club, the place that
Crazy.
Isaiah Chance said that he was going to be at, the place that Rashad Murphy liked that posting of the victim, knowing that he's going to be at Teaser's. His co-defendant is looking up the address, MapQuest, so they know exactly how to drive to where the victim is going to be. Timestamp of the search. Teaser's Gentleman Club, 6/23/2024. It's not just Sean Gathright hunting and searching for the victim at this Airbnb. Charles Jones is posting and he is tagging Ms. Lee. There's post, and then it is reposted on Ms. Mizzle. I keep saying Ms. Lee, I'm sorry, on Mizzle's post.
That's how I read it too,
So
is
now
Ms.
we
Lee.
have Rashad Murphy also hunting for an Airbnb in Tampa. Sean Gathright is trying to find out where Charles Jones is. His co-defendant, Rashad Murphy, who claims not to even be in Tampa, is searching for, see this message, get the B&B from me, gang. That's his words on his Instagram messaging. Hunting, searching for Charles Jones. So now we have Rashad Murphy doing it, we have Sean Gathright doing it, and now we have Isaiah Chance. He's looking up Mizzle. The person he knows based on Charles Jones' Instagram story is with Charles Jones. They all three are hunting him. They want to know where he is at the Airbnb. They tracked him, they followed him, they hunted him, and they found him, and then they gunned him down. That was the only purpose for their trip. That was their mission, and they succeeded at it because of how they planned to commit it. Sean Gathright, again, searching for Charles Jones.
Hope
You
they
heard
show
about
them.
the extraction, the communication that he has with Kyla Enright and Nevaeh Gathright. I need you to text Fat Boy. A lot of conversation, a lot of questioning. Who's Fat Boy? Law enforcement believes Fat Boy is Xavier Edwards. Do we have to prove who Fat Boy is? No, we don't. I don't know who Fat Boy is. It doesn't matter because the context of this conversation is clear. Sean Gathright is trying to find out where Charles Jones is, where 6 is, by dubious means, by using a girl to get on a phone, FaceTime conversation with somebody they know that Charles Jones is with, pretending like she wants to get with them so that she can get the address of the Airbnb. I don't know who Fat Boy is. It's irrelevant. What is very relevant, which is evidence of motive, which is evidence of hunting for 6, hunting for Charles Jones, is the rest of this message. Hey sis, I need you to text
Oh,
Fat
wait.
Boy and tell him you're trying to pull.
Right? I don't know. Maybe not. Now that we have the picture, I'm so bad with faces. I don't know.
Pull up on him and trying to see him tonight. They want to know why. He's in Tampa right now, but make it seem like you don't know he there. He had a B&B with 6. He like, I want to pull up on him. I'm drunk and I'm trying to F you. That is what he is telling them to do. The purpose of this messaging to these girls are to use them to get intel. intel as to where Charles Jones is. No, they're trying to say, where are you? You want to come hang out with us? He's like, no, I'm in Tampa. I'm trying to see where his B&B is. He's trying to see where Six's B&B is. Who B&B? Six. I don't care who Fat Boy is. It couldn't be any clearer. This isn't coded language. It is very clear what Sean Gathright's purpose is. He wants to find Six. These girls actually do it. They report that he's at Beezer's. They get it a little right. He's going to teasers, not Beezer's. More social media from Charles Jones. Julio Foolio actually saying that he's about ready to go to the show. And we all know, they know where that show is going to be. Ron is contacted. Sean Gathright all of a sudden needs to add a new contact to his phone. Not saved before now. She is Alicia Andrews. She is Isaiah Chance. She's there with them all weekend. Why now does he need to save her contact? Because they are purposely going to use her phone to communicate while they are going on this mission. So he has to save her phone because these are the phones that are going to be utilized between both vehicles, the surveillance team and the hit team. Ron, Sean Gathright from his iCloud account. These are the confirmed numbers of Alicia Andrews, now saved as ERON in his phone. And they do communicate. There is a sharing of location, 2 a.m. There is incoming and outcoming phone calls. And you've heard about call detail records from Detective Ramos, and it's important because there is calling going back and forth, 208, 208. But you also heard from Detective Ramos that there is video footage clearly when Isaiah Chance has that pink phone up to his ear that is not on call detail records, that are not captured in these cell phone records. Because there are apps out there, you heard that, there are apps out there that you can use purposefully if you don't want to be tracked by cell phone companies, if you don't want to be tracked by law enforcement. Talked about Telegram, WhatsApp. There are other applications on your phone that can be utilized just like a cell phone for messaging, for phone calls. They are communicating surreptitiously, secretively, for a specific purpose. That is what people do when you are on a mission to commit first-degree premeditated murder. Timeline, 2:24 a.m., Chevy Cruze to Teasers. 2:27, Chance and Andrews exit the Cruze in the silver Chevy Cruze. 2:29 a.m., not there for a club, never go in, go back to the Chevy Cruze. What we do know is that Charles Jones and his entourage, his friends, the people with him, are in front of that club. They have spotted him, they have completed their task at that location. And guess what? They are trying desperately to get in touch with Sean Gathright. He's not picking up the phone. Whatever application they're using, he's not answering. So they send 2 messages, incoming and outcoming, again, with the timestamps on them. The communication, the coordination. No coincidence that there is communication and then all of a sudden this black Chevy Impala arrives. Going to Truth 18, 4:10 a.m. is now when we're at this timeline. Second nightclub. Charles Jones and his friends leaving, Truth 18, the second club. More sharing location between Alicia Andrews' phone and Sean Gathright. Communication, coordination. The evidence in this case is overwhelming. You have it based on the video footage, you have it based on the cell phone data, and now you have it based on all of the social media and what they were doing that night. The evidence in this case overwhelmingly show and prove that all 4 of these defendants conspired to commit the first-degree murder of Charles Jones. That they planned it, that that's the only reason that they were here, and that is what they spent the entirety of their night doing on June 22nd going into June 23rd of 2024. And that they actually found him and did what they intended to do. They killed him. They also knew who was with him, how many cars were in his party and who was traveling with him. And they managed to shoot 3 more of Charles Jones' friends and people that were with him. That is first-degree premeditated murder for all defendants. Conspiracy to commit first-degree premeditated murder for all defendants. And 3 counts of attempted first-degree murder for the shooters for intentionally shooting at and trying to kill Camilla Bentley, who's not even in a gang, Gino Norris, who is not in a gang, and Xavier Edwards. They intentionally shot into those vehicles, into areas knowing where people were seated, and they did that to kill them. That is 3 counts of attempted first-degree murder for the 3 shooters, and then tampering with evidence against Sean Gathright. There is a lot of evidence that you have had to look at over these last 2 weeks, and I know that you have been paying attention, and there are a lot of instructions that the judge is going to instruct you on tomorrow. And one of the things that she will instruct you on is that you need to look at each defendant separately and apply the evidence to them. But remember that principal instruction. That applies to all of them, because they all intended for Charles Jones to be dead, and they all did something to assist. They all participated. They all had a role. And they are all guilty as principals to first-degree premeditated murder. And you need to put them and treat them into the shoes as if they had all carried the gun that actually shot and killed him. You will also be asked to make special findings. The judge will tell you and instruct you that the law requires you to find each and every one of the defendants guilty for the highest offense that has been proven beyond all reasonable doubt. A professional hit that was planned and executed and completed is first-degree premeditated murder. It is the highest offense. It has been proven beyond all reasonable doubt. To intentionally try to kill his friends, that is attempted first-degree premeditated murder, proven beyond all reasonable doubt. Each and every one of those top counts have been proven. And you should hold them responsible for what has been proven beyond and to the exclusion of all reasonable doubt. You will be asked to make additional findings. You'll be asked whether or not, with regards to the shooters, if they personally possessed a firearm and if they discharged a firearm. And you'll have to go through each one of those verdict forms. There are going to be separate verdict forms for each defendant. And you'll see after you make your decision that there will be additional questions that you need to make and answer those questions. And with regards to the shooters, there are enhancements if you are the one that actually fired the gun, if you are the one that actually possessed the gun. So for Rashad Murphy, for Davion Murphy, and for Sean Gathright, there will be extra questions for each and every one of the counts that will ask you to say yes or no. And there is no doubt that they are the 3 individuals in the black Chevy Impala. The cell phone evidence proves it, as well as all of the video evidence that corroborates and supports it. Not even having to look at or delve in what is in their social media. The other enhancement that you're going to be asked to make specifically has to do with gang enhancements. And they apply to Isaiah Chance, to Rashad Murphy, and Davion Murphy. You will be asked to make findings whether it was proven that they were in a criminal gang and met the criteria for criminal gang membership or associate. And all 3 of them have met those criteria. That is why you heard all of those testimony from Jacksonville concerning the tattoos, concerning the videos. You've heard what are the requirements for gang membership. And there's 11 different factors. Admits to criminal gang membership. Nobody will admit to being a criminal gang member. Is identified by criminal gang member by parent or guardian. There's reason, or there's factor after factor, but you heard from Detectives Griffin, you heard from Detective Nieder as to what the requirements are and what requirements were met for Rashad Murphy, for Davion Murphy, and for Isaiah Chance. And to be a member, you just need one factor. To be an associate, you just need one of those factors. To be a criminal gang member, you need 2 or more. Now, you have heard from Jacksonville Sheriff's detectives that they are very conservative on this, that any one of these, standing alone, does not mean that you are a gang member. And they personally have different approaches to when they actually will document and keep records on people. Because just hanging out with one can be considered a person of interest or an associate. And there are a lot of people that may hang out with gang members that have no gang membership. So when they are documenting, they tend to look for 3 or 4 factors. The law only requires 1 and 2, but it's not these standing alone. To be a gang member, you have to meet one of these criteria, but you have to be in a criminal gang, which means a formal or informal. The law requires that it is a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts that consists of 3 or more persons that have identifying signs, colors, symbols, including to but not limited to terrorist organizations and hate groups. The key being, these are not people that are innocently organizing just to hang out. The key to this is it is a criminal gang, primary activities, the commission of criminal crime. And so the law requires that that be a criminal gang and that to be a member 2 or more or 1 or more. When we're talking about what the law requires and the proof in this case, one of the things that we are talking about for all 3 of them is the commission of this homicide, an attempted homicide. There is no doubt that it is because of the gang war. It is because of their membership in it. And this violence going back and forth, both sides doing it, is why it was the motive for this and why this was committed. It's clear based on the social media, it's clear based on the drill raps, the type of music the victim performed, and it's clear on the violence on both sides. This is why this happened. And that in and of itself shows that gang enhancement, even if the detectives just gave you 1 of them, would qualify all of them as an associate for the purpose of committing the criminal act of killing the head of 6 Block. Qualifies all 3 of them as associates, but you know that there was much more than that. They had been documented as gang members before this homicide ever occurred. And the detectives went over the criteria, all of the different evidence that supported Isaiah Chance being in a gang before this even occurred. The style of dress, the 23, the gang signs, all of that evidence. He met more than 1 or 2 criteria already before this ever happened. There is no doubt that he is part of a criminal gang and that has been proven beyond to the exclusion of all reasonable doubt, and that you should hit yes to that question. Davion Murphy, tattoos. All of those tattoos you saw on him. It's not a crime to have a tattoo of a deceased person on you. It's not a crime to have as many tattoos as you want. But tattoos that have significance, that are used by gang members of a certain gang, especially of their fallen, killed members, are all over his body. Shug, the date of Shug's death is on there, their names, Jacoby, 12 Block is on his back. And you heard on the video with Detective Nieder, when he went to go take a photo of that after the homicide, where he is arrested for killing 6. And the one time where Detective Nieder is going to take a photo of the back of his neck where there is 12 Block, from Davion Murphy's own mouth is, that's the one you want. You heard it for yourselves. He knows why this first-degree homicide was happening, why it happened, why he's being questioned by a gang detective, why they want photographs of his tattoo, and when they take a picture of 1200 Block, he audibly is heard on that interview, that's the one you want. He is a member of 1200 Block, and no matter what he will say to deny it, no matter what excuse he gives for all of those other names on his body, it is because he is 1200. That is one factor. Another factor is that rap song that he wrote well before, where he is talking about Prosper, writing about meeting Prosper in 2007. You saw the posting about Prosper and Junior that was posted immediately after Charles Jones was murdered. They had been up all night, stalking him, tracking him, yet they're up at 5 a.m., 6 a.m. posting on social media.
They had a long
They're
night.
celebrating. That's absolutely what they've done. And you've heard cross-examination, oh, those are their sons. Well, that rap song that he wrote talking about meeting Prosper in 2007 is definitely not a reference to his son. And Bink, another gang member, is in that rap song, that letter that you saw that he'd written well before committing his crime. Physical evidence identifying him as a gang member. Another criteria. And this case, this offense, more than any other factor, is undeniable proof that they are 1200 and that they are ATK, and that gang enhancement applies to Isaiah Chance, Rashad Murphy, and Davion Murphy. That these crimes were committed for the purpose of benefiting a gang, how can there be any doubt? You saw those videos that were posted a day after Charles Jones was killed. Game over. Just do it. All taking credit for killing 6 Block. That was the biggest takedown 1200 and ATK could have done. And there's a rap video saying, game over, you don't want a war. There is a gang war. That is the motive in this case. And the mountain of evidence that you have in front of you shows that each and every one of those defendants is guilty of everything that they are charged with.
Okay, Mr. Gonzalez?
Can we approach her?
Yep.
All right, they're approaching before. Well, I guess they're going to take a break. Let's see if they say anything, and then we'll skip this lunch break. All right.
That's okay, I'm just gonna tell them, okay, and I'll repeat what I said. Okay, it's 11:45, so it's close to, we're not quite at lunch, but we're close to it. So in order not to have to split Mr. Gonzalez's closing argument to you all, we're gonna go ahead and take our lunch break now and take a 1 hour break. We'll be back at 12:45 and continue on with closing arguments, okay? All right, see you all.
All right.
Right, so we will skip that, and we're going to jump this hour. But in the chat, guys, on a scale of 1 to 10, that is the first closing argument by the state. So that was Michelle Doherty. They're going to have a rebuttal. And I think last time they're probably going to give it to Harmon, but maybe not. We'll see. How do you think Michelle did in her closing? Scale of 1 to 10 in the chat. We'll do the same for each of the attorneys when they're done. Okay, there we go.
Ms. Linder, just call it.
Okay, that's fine, cool.
Judge, I did have an issue that I need to report to the court. I told defense attorneys I was on the way back here, getting on the elevator, and I heard someone behind me say, "Good job." And I had to say thank you. When I turned around, it was a juror, and the elevator opened up, and he's like, "Here's the elevator," and then I just walked away. It was the gentleman with salt and pepper hair and glasses, and I think has a Spanish accent, but I just wanted to report it to all the parties.
Carlos, I don't know what's
Yeah, don't.
Oh!
Initials only, so I'm assuming based upon that description, it is juror 32, initials CRP.
Wow. Well,
Okay?
shout out to Cisco for trying to shush it quickly. In all fairness, watch them say, like, let's make that one an alternate.
It's been reported. And before we get going, here's what I showed with the changes, including copies of all of the updated verdict forms, which we already have, but here you go. And that should be the finals of all the inserts. Someone can grab, have Mr. Davion Murphy, Mr. Chance, and Mr. Gathright. You guys want to come grab these? These are the amendments. And Mr. Gonzalez, I think you have everything already, but just in case, Here we go again.
It's all used up after everything.
I know. And one of the jurors had a question about sequestration, and they had a concern about missing Mother's Day if they were being sequestered. So what
that
I'm just going
Sunday?
to tell them is that, I'm just going to reiterate that tomorrow morning, they will
Oh.
have the case by around 10 o'clock in the morning. They'll have all day, they can work as late into the night as they feel like they're being productive. And that essentially sequestration means they get picked up just to sleep, to be taken to a hotel. And if we need to come back, it'll be on Saturday, okay? So,
Wow, I don't love
continue to
that.
sequester people.
This is a death penalty case. I feel like that's rushing it. And you've got to separate, however you feel about these defendants' guilt. If you rush something like that, that could become an appellate issue.
People over.
And you have the
Mother's Day,
juror
which is Sunday.
expressing
That will
the
alleviate any
concerns.
All right, we ready to go? Mr. Gonzalez?
That's right.
State ready?
Yes, Your Honor.
Okay. All right, the other defendants are present with defense counsel, so let's bring in our jurors.
All rise. All jurors are in.
Okay, very good. Everyone have a seat. I believe one of the jurors, or some of you, had a question. Said we've got the Mother's Day holiday coming up on Sunday, and about sequestration and how that works. So again, just a reminder that today is devoted to closing arguments. So we'll be here until the attorneys have all finished their closing arguments. We'll break for the evening. We will reconvene tomorrow morning at 9 a.m. I will read the final set of jury instructions. It'll take maybe an hour tops, and then you all will begin your deliberations. So by mid-morning, you will begin deliberating. I am going to ask you to bring with you just an overnight bag in case you need it. And you all would work until you reach an hour that you can no longer productively work. So you can anticipate having lunch here at the courthouse. You can anticipate having dinner provided here at the courthouse. And if it gets to the evening hours and it's getting late and you guys feel like, you know what, we're not close and we just need to take a break, that's when you would be sequestered. And you would be taken basically to a hotel just to sleep. That'd be basically it. Then we would return Saturday morning. Okay, so you would not be, I would not sequester you all over an entire weekend with no contact with your families, no phone, no TV. I wouldn't do that, okay? And then if you come back, if we came back Saturday morning, it'd be the same deal. We would just go until you all reach a verdict, okay? Okay,
Saturday
very
and
good.
Saturday?
Mr. Gonzalez.
May it please the court.
Yep.
That's a good point.
Ladies and gentlemen, good afternoon. I'd first like to thank you on behalf of Rashad Murphy and my co-counsel Danny Hernandez for the patience and the attentiveness that you've shown us all over what feels like about 6 months. In all seriousness, because this is a serious matter, sometimes we need just a little bit of levity every once in a blue moon to kind of get both of our feet back on the ground. All of us have our commitments. We have our family. We have, in particular, a special day coming up. We have our personal obligations. But certainly as you sit here listening to the evidence over the past 2 weeks, I'm sure if you didn't initially understand it, you now understand how important this process is. Remember that what Ms. Doherty tells you in her closing statement is not evidence. It is her interpretation of the evidence. What I tell you, what Mr. Petredis tells you, what Mr. Wise tells you, what Mr. Sinardi tells you is not evidence. Evidence comes from the witness stand. Evidence comes from those items of evidence that have been admitted for your review that will go back with you to the jury room for your deliberations, whether it be videos, whether it be photographs, whether it be items of any kind. And you are the triers of fact, not us. We interpret what we believe the evidence has shown you. And therefore you can presume and expect we would see things in a different light. I represent Rashad Murphy. As you know, Rashad Murphy sits right there in that first seat. And it's the first seat of a very long L-shaped table with a table behind the table. And the reason that that is important is because because we banged in jury selection for day upon day, that Mr. Rashad Murphy, as well as all of the other defendants, have maintained that they are not guilty, and that presumption of innocence follows them until such time as the evidence proves to you each element. You heard Ms. Doherty talk to you a little bit about certain particular crimes, and she said, element number one, element number two. You will be instructed by the court on each one of the charges that have been brought against every one of the defendants. For the most part the same, but some a little bit different, and they will all have elements. And you have promised us, me in particular, because I'm the one standing here, that you will hold the state to its burden to prove each and every one of those elements as to each charge that has been presented to you for consideration, beyond and to the exclusion of a reasonable doubt. Rashad Murphy, plain and simple, cannot be placed in Tampa, Florida on 4:40 a.m. on June 23rd of 2024, when Charles Jones, Julio Foolio, was killed. The evidence has shown you that Mr. Murphy's phone, and when we talk about phone, we talk about life. We talk about an extension of our breath, an extension of our arm, an extension of our pocket. We all certainly may have a different perception about our phone, but no one leaves their phone in another city to go away for a couple of days unless it's an accident. Not even the smartest of criminals. Nobody anticipates, hey, I don't want somebody to see my Instagram. I don't want somebody to track my phone and give location data through cell sites. Nobody wants and thinks there's going to be timing advance that is going to ruin or complicate whatever crime I intend to commit. What the evidence shows you, I believe, is that Mr. Murphy's phone is not tracking from Jacksonville to Tampa. It is not in Tampa. It is not moving around Tampa at any relevant time to this murder. And the theory of prosecution as to motive is just misplaced. That is evidence. That's what the evidence tells you. And we're going to talk a little bit later about how you categorize that and what I believe the law and what you will be instructed tells you what to do with it. In addition to the absence of Rashad Murphy's phone in Tampa, which is very significant considering everything you know about phones and everything you learned that you probably didn't know about phones before you sat in those seats. The state would suggest to you that evidence of Mr. Murphy's presence in Walmart on June 21st at about 10:20 a.m. at night provides strong evidence that he participated in the murder of Charles Jones, and it is in fact shooter number one. And why do they do that? Solely and simply because the clothing that he was wearing during the course of the video captured at Walmart, as compared to shooter number one in the Home 2 Suites and Tesla videos, is similar. I know the state suggested to you, well, who wears a beanie in June? Well, a lot of people do. A beanie is a standard a piece of clothing that I would suggest to you is yearly. No matter that it's hot, no matter what the temperature might be, it's an article of clothing. It is an article of clothing like a black hoodie is, like black jeans are, like black military boots are, and my suggestion would be in your everyday life, think to yourself how often or how little you see that manner of dress. Black hoodie, what Detective Ramos opines is a black leather belt, black jeans, and black military boot. I would ask that you pay close attention to State's Exhibit 100 and State's Exhibit 59, which will be with you in the course of your deliberations, but they have provided to you, and I will provide to you, this composite. that would show Rashad Murphy at Walmart buying items, and then to your right, shooter number one. Detective Ramos made a comparison of those clothing, and a significant point in his testimony would be what he sees in the form of a unique tear in both sets of jeans at the left knee. Recall that he described it, when asked, as a perfect match. As we look at Exhibit 59 and 100, a composite that is here for you to view at this particular time, you're going to have to draw your own conclusions when you look at this. And you watch it on your screen, or you collaborate with each other and decide, does anything in those two sets of clothing, other than their style and their color, cause you to believe that it is evidence sufficient to convict Rashad Murphy of premeditated first-degree murder, 3 counts of attempted premeditated first-degree murder, and conspiracy to commit first-degree murder? What is equally important is the testimony of Detective Christopher Drabeck. You remember Detective Drabeck is a Jacksonville gang investigator. Didn't really talk to you about a specific gang, but gave you an overview. But his main purpose in his sworn testimony at trial was really his interrelationship with this particular investigation, a little bit different than some of the other Jacksonville detectives who played more of a part in talking to you about gangs. Remember that Detective Drabeck had several roles that relates to Rashad Murphy and the evidence, or what I would suggest is the lack of evidence in this case. Detective Drabeck located the Walmart video. He was the one that provided to the Tampa Police Department. Additionally, recall that he took the post-Miranda statement of Rashad Murphy after his arrest in Jacksonville. Recalling Detective Drabeck's testimony, Rashad Murphy began that interview being less than candid, and that's polite. He lied about being in Tampa the weekend of June 21st through June 23rd. He would not, on several occasions, admit going to Tampa or involving himself in any knowledge in anything that he did before or after the murder of Charles Jones. I would submit to you that you use your life experiences. When someone is scared, ladies and gentlemen, when someone is fearful for a wrongful implication, they sometimes make poor judgments, and that's exactly what Rashad Murphy did. It's common to attempt to remove yourself from the closeness of a bad situation, but don't automatically presume that that means and equates one-to-one that he's lying about having committed a murder, because those are two different things. That's for you to decide when you look at the totality of his statement. But that's exactly what Rashad Murphy told Detective Drabeck. Recall that Detective Drabeck said that Mr. Murphy said that he knew, he actually tells him, he knew if he put himself near Tampa, it would implicate him in something he didn't do. So he rationalizes, or he tells him at a certain point of time, probably way too late, why he did this. And it is there for your consideration. And Detective Drabeck told you that. Only after he was confronted with evidence that he got into the Uber and drove back to Jacksonville from the Airbnb parking lot with Alicia Andrews and Isaiah Chance did he make admissions about what he knew. Because Rashad Murphy was not completely truthful, again, does not make him guilty of first-degree murder. It is for your consideration to determine why. It may not make him the person that you are. It may not make him the person that you would want to be like, but it doesn't, again, make him guilty of first-degree premeditated murder. He actually told Detective Drabeck, as you recall Detective Drabeck's testimony, that he knew at one point in time it made him look like a liar. But what he did tell Detective Drabeck turns out to be very, very important evidence for your consideration. He tells him that he ended up here because he put stuff in his name. Detective Dravick told you that. He also said that his Airbnb account was used and that he would never book an Airbnb in Tampa and didn't know it was in Tampa. He told Detective Dravick that. That is an explanation. That is him attempting to explain to Detective Dravick what occurred. What he said was that his account was used. He also said he thought his vehicle was going to Orlando to take things to his brother. Well, when he's saying that, you don't really put two and two together until you look at the entirety of the evidence. And he said thought he was going to be helped out by having those items taken. You consider the testimony that comes through Detective Dravick and look at your notes if you took them to determine whether Rashad Murphy even owns a car when the state suggests to you a theory of prosecution that Rashad Murphy drove that silver Chevy Cruze down to Tampa. And why do I say that? Because Rashad Murphy told Detective Dravick that he borrowed the car for purposes of being used to go to Martin Correctional Institute, which is where his brother is incarcerated. Rashad Murphy then tells Detective Dravick that he went to go check on the Airbnb. Recall Detective Ramos's testimony that there was phone communication between Davion Murphy's phone, his cousin, and his phone at 5:03 and 5:07 in the morning of June 23rd, the early morning hours of June 23rd. And that's when he went to Tampa, pursuant to those phone calls. He also tells Detective Dravick that he gets a ride from Darius Beals to Tampa, and that when he gets to the parking lot, he goes to the back door and knocks. No one answers, and he goes back to the parking lot. They are coming out of the Airbnb, and he gets in the Uber with Isaiah Chance and Alicia Andrews and drives back to Jacksonville. If you'll remember Detective Ramos, he suggested and battled with me a bit on cross-examination, suggesting that Mr. Murphy's interview indicated that he went to the Airbnb and went into it. And that's an important issue. It's something for your consideration when you seek corroboration, when you seek what is the best evidence. And I'll say this now, I'll probably say it sometime later on. Corroboration is what makes evidence important. Things can't always be corroborated, but when they can, they provide you an important feature for your consideration. And so in State's Exhibit 145, you're going to have that colloquy of that interview for you to listen collectively, individually, one time, 7 times, in order to determine what Rashad Murphy says with regard to entering that Airbnb. Please carefully review 145. So because Darius Beals had been killed on June 28th, ironically, 5 days after this particular trip, he could not be interviewed with regard to seeking corroboration on this trip with Rashad Murphy. What was done, though, is that his phones were in evidence and collected as part of the investigation of his death, and there was an extraction done. We've learned more than we can ever hope to need for the rest of our lives about extraction. I can only presume, and I certainly don't want to presume wrongly as it relates to each of you individually, but you saw, and the state provided you, cell site location, information, and data that would have you believe shows Darius Beals did not drive Rashad Murphy to Tampa. But the problem crept up that there was more than one phone associated with Darius Beals. And as you will see and we'll talk about with Rashad Murphy's extraction, it was not a full extraction. The phone was operational. Detective Ramos said that they could not get location data from it. Detective Dravick said that as well. And although the iPhone can be accounted for, the Samsung did not result in the type of extraction. We didn't see that one. There was an extraction. It wasn't put into evidence what its results were. We only saw the results of the iPhone. And what is curious about that is that it doesn't tell us whether or not Darius Beals traveled with Rashad Murphy as he testified to, and was in possession of the other phone. Now, Detective Ramos, without showing us, told us, well, was it turned on that day? Well, I would submit to you, when we're talking about somebody's life, and we're talking about reasonable doubt, and we're talking about the state meeting their burden, what we have to talk about is, can we simply just dismiss that phone was not in Darius Beal's possession? Because Detective Drabick didn't dismiss it. And how do we know that? When I questioned him about it, he said I could not say where that phone was located, and he could not preclude that it did not travel to Tampa. And that was the right answer. It is the true answer. They cannot tell you that. Recall when Detective Ramos wanted to corroborate Mr. Beal's presence in Jacksonville, he did so by providing 2 pages of thumbnails, of pictures. There's Darius Beal's. The problem with that was, on cross-examination, we went through every one of those pictures. And do you recall what the bottom line was? None of them were relevant to that time frame that we would have been talking about. It's a nothing burger. Unless it was just left to be taken for granted. They talked about facial recognition, but guess what? Facial recognition, more than one profile for facial recognition can be on a phone. It's very common, especially in shared phones, especially in secondary phones where more than one person may use it. When we look for evidence, ladies and gentlemen, in establishing reasonable doubt, corroboration and support would be the primary means for you to be comfortable with that evidence. While we talk about corroboration in the form of evidence, we come to find out the extraction of Rashad Murphy's jointly possessed phone with his girlfriend, Charmaine Steiger, provides additional information. And why is that important? Because we're relating back to trying to corroborate, number one, what Mr. Murphy told us in his interview. So, as we do that, we first look at State's Exhibit 101. 101, I can't read my writing. It's going to be 101L2. 101L2 is the picture of the floorboard in the vehicle that has a Walmart bag with many items in it, purchased at Walmart while Mr. Murphy was at Walmart. Why that's important is because Mr. Murphy told Detective Drabeck that he bought those items to go to Martin Correctional that weekend. And there's corroboration to that. What we also know, and when we talk about the Airbnb, remember the Airbnb and the confirmation email that was sent to Rashad Murphy. Remember what Rashad Murphy's explanation was about that Airbnb. The confirmation, which is State's 101M, we've looked at it a couple of times and talked about it. That confirmation was sent to Mr. Murphy because Mr. Murphy's account was used to book the Airbnb. But what it doesn't tell you is whether Mr. Murphy himself booked the Airbnb. What we know from that confirmation is that A, it asked for a driver's license to be sent in order to finish the booking, which is, at the end of the day, that's the goal of who was renting this Airbnb, is to get the booking finished, and it is Mr. Murphy's account. But what it doesn't tell you, and what wouldn't comport with Mr. Murphy's story, is that I wouldn't let somebody use my account. I let them use my account, but I wouldn't let them use my account to book an Airbnb in Tampa. That's not what was supposed to happen. And you cannot look at this confirmation and say to yourself, well, that tells Rashad Murphy that the Airbnb in Tampa. It doesn't. It has no address. It has no city. When you look at it, all you see is a confirmation at Lagoon Oasis for a 2-bedroom, 2-bath. That's corroboration to his story, to his statement that he gave. When you look at credibility to that extent. Now, understand, let's relate back to the fact that Rashad Murphy lied. Okay? Let's relate back to the fact that it took him to get to a certain point where he said, regardless of how bad this may look for me, okay, I'm going to explain myself. But the explanation, unless, boy, somebody is really thinking on their feet, and I don't mean putting 1 and 1 together. I'm be putting 1 and 1 and 1 and 1 is 5 together in the span of coming out of that apartment with a blanket over your head and figuring out what to say. So you look for this confirmation. And the confirmation doesn't show you that. But what it also shows you, and which is supported by the evidence, is very soon after that, the driver's license is sent, right, to complete the booking. But the records and the data doesn't tell us that that driver's license was sent to Airbnb. It is just as plausible, and I would ask you to consider, based on the evidence, whether it was sent to Isaiah Chance and Alicia Andrews. Why would we think that, other than the story and the explanation that Rashad Murphy is already in the midst of? Because there's evidence that Alicia Andrews and or Isaiah Chance were attempting to rent an Airbnb unsuccessfully, thereby Rashad Murphy's Airbnb account being used. And how do we support that a little bit further? In addition to their attempt to unsuccessfully rent an Airbnb, Isaiah Chance pays for it. He pays for it. And so, to that extent, the cooperation that you should seek becomes much plainer for your consideration. As we continue to use Rashad Murphy's interview as support for the sequence of events, he relates to Detective Drabeck, who testified, and Detective Ramos actually is the one that authenticated the exhibit. I would ask you to look at Defense Exhibit 3. Defense Exhibit 3 is screenshotted in Mr. Murphy's phone. And unless he thought about the bag of the items, and he thought about the Airbnb, and he thought about the text message, and he weaved like a spider a web in a very short period of time, what is being portrayed here, and I'll read it, the first part's cut off, but bathroom inside parking lot, inside the men's bathroom, inside the garbage can, inside the Walmart bag. Okay, them the last instructions, right? Yeah, but remember, before they actually let you in the parking lot, it's going to be a checkpoint. Tell them I'm applying for a job. I called up here yesterday. They told me to come pick up my application today. Then they're going to let you in the parking lot to make sure you park close to the bathroom and have you all in your pants or something. Once you put it in the garbage can, walk up to the entrance window of the prison and get an application before you leave back up. Later, that becomes important because what happened? Things didn't happen. Chevy Cruz didn't go to Martin Correctional. Items didn't go to Martin Correctional. What's going on, brah? Did you make it? My people say didn't see it. Didn't go. Didn't happen. Plan wasn't fulfilled. Detective Ramos, well, first let me go back to Draden. He indicated that there were going to be items going to his brother at Martin Correctional Institute. Where is that? South of Jacksonville, south of Orlando, south of Tampa, on the East Coast. That's where Detective Ramos told you Martin Correctional was. So what does Ramos do? In further corroboration to what Rashad Murphy is telling you, he does a reverse. He gets that phone number on that text messages, and although he doesn't speak to the subscriber, comes back to a person who's incarcerated where? Martin Correctional with Shaheen Murphy, Mr. Murphy's brother. And I hearken you back to 101L2, which was the item, the bag with the items in. One thing that he did continue to maintain from beginning to end without any admission or any waiver is that he was not in Tampa at the time of Charles Jones' murder. He didn't have knowledge of what was going to take place. He didn't conspire and didn't participate in the murder of Charles Jones. I believe that the court will instruct you on conspiracy, because Mr. Murphy is charged with conspiracy in count 2 of the indictment. And in order to commit a conspiracy, the state elements again, element number 1, the intent of the defendant was that the offense of first-degree premeditated murder, not that an offense, not that a crime, that first-degree murder would be committed, and that he agreed, conspired, combined, or confederated with one or more of its co-defendants so that first-degree murder be committed by them, one of them, or some other person. It also goes on to say that the agreement or the conspiracy or the confederation or the combination to commit a first-degree murder has to be expressed in a particular word or a particular words that pass between the conspirators. We also heard from Detective Ramos, who again was the lead detective in this case for a significant amount of time on a couple of different occasions, on a variety of different things over a couple of days. Despite Detective Ramos' wealth of information and evidence uncovered throughout the course of this investigation, he had to indicate to you when asked that there was no evidence to determine the occupants of the black Chevy Impala or the silver Chevy Cruze at any relevant portion of time in Tampa as it relates to Rashad Murphy, because I am here for Rashad Murphy, and Rashad Murphy is one person. He's an individual, and that's what Detective Ramos said. I cannot corroborate and have no evidence that Rashad Murphy was an occupant of either of those vehicles during any relevant times on the way from Jacksonville to Tampa and while in Tampa. Again, no cell phone evidence, no cell site locations, no data that relates to Rashad Murphy, no identification of him as one of the 3 shooters, except for the similarity of clothing, which you will look at, I'm presuming very closely as you deliberate. Not one of the victims can identify anyone. And again, the state told you, and I get it, in that type of circumstance, the way they were dressed, nobody's going to make an identification. But you know what? Sometimes things happen. Didn't happen in this case, and there is no identification. That is the evidence. It doesn't get you closer to a determination as to whether or not Rashad Murphy committed this murder, other than create reasonable doubt. Detective Ramos talked to you about several subjects of evidentiary interest, including firearms, ammunition, located in search warrants, whether it be cars, whether it be houses. Some of that evidence tied to the shooting of Charles Jones in October of 2023, as well as Charles Jones' murder in June 23rd of 2024. What is missing in the entirety of the forensic evidence in this case, as it relates to ballistics, as it relates to firearms, which have become an important part of this case, did you hear that any of it had any relationship to Rashad Murphy? Not a single stitch of it. There is no video in this case at any juncture that would identify Rashad Murphy, short of a guy wearing all black. This becomes critically relevant because you promised me again in jury selection that you understood that each of these defendants needs to be treated separately. You have to compartmentalize the evidence that exists as to one or more, if that be the case, of these defendants and not others, specifically as it relates to Rashad Murphy. You should give consideration to the evidence that you heard from the witness stand, and obviously with those pieces and items that have come into evidence through the court. And to what extent it implicates a person or persons and not other person or persons. It's a tough task. Over 2 weeks, you heard a lot. And it will take, I predict, a significant amount of deep diving into how all of this interrelates. And it won't be simple. It won't be simply just so-and-so talked to so-and-so. We're going to talk about why. It won't be because so-and-so sent a picture to so-and-so. It won't be so-and-so got a picture from somebody who's unknown on a certain day, 4 days before the murder, or a day after the murder. It's going to be more complicated than that if you're going to give each and every one of these defendants the type of review that's necessary in a premeditated first-degree murder with the most significant stakes that anyone could ever face in any crime.
Objection.
All right. Come up here real quick. Just a reminder, we discussed this during jury selection. At this phase, you're only making a determination as to guilt or not. Okay? Nothing else at this juncture. All right, you may continue, Mr. Gonzalez.
Thank you, Your Honor. So I expect that the court's going to instruct you that a separate crime is charged against each defendant in each count of the indictment that you will have back there with you. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. A finding of guilt or not guilty as to one or some of the defendants must not affect your verdict as to any other defendant or other crimes charged. This is the law, and you must apply that law to the facts. Ladies and gentlemen, this case has been overrun and dominated by a significant amount of gang evidence. The gang evidence I would submit to you is to get you to the point and down a path that because Rashad Murphy has been documented by a statute, 874, as a member of 1200, that paves the way for his motivation to participate in the murder of Charles Jones in furtherance of and on behalf of the gang. I believe the court's going to instruct you on the definition of a criminal gang member, and although you've already been exposed to the criteria, you will see them all. And I'm not going to talk about that now. I might talk about it a little bit later. But essentially, you're going to use that as it relates to this documentation. As it relates to Rashad Murphy, in particular, you heard from Detective Griffin from the Jacksonville Sheriff's Office, who indicated to you that he was the gang investigator for 1200. Detective Griffin became the 1200 gang investigator in January of 2024, which is just some five and a half months or so prior to Charles Jones' murder. Detective Griffin indicated to you that he associated the Instagram account Ghost187 to Rashad Murphy for two reasons. Because his field interrogation reports with people on the street said so, and because other detectives with the Jacksonville Sheriff's Department told him that account belonged to Rashad Murphy. When I asked Detective Griffin if he had ever seen a profile picture or a post that referred to Rashad Murphy personally, or profile to him, or family, or one or more of his 4 kids, or anything directly related to him that he could associate with him through the actual account, he indicated that he could not. He had not memorialized any screenshots, memorialized any review of that account. When I asked him, he said no. When I asked him if he recalled the names of those that had associated the account to Rashad Murphy in those field reports, because remember, they're not always written down. They don't take names, they don't take numbers, they don't take pictures. They just get the information. And of course, what he said was no. And while we're talking about that issue, in asking all of the Jacksonville detectives the same questions, they all had the same answers, except for one exception. The exception would have been when I posed that same type of question to Detective Nieder. You will remember that he said, I saw a live screen of Rashad Murphy on that account. When I asked him the date, he said, I don't know. When I asked him what the subject was of the screen recording, he said, I don't know. When I asked him whether or not he documented it, saved it, screenshotted it, put it in a file, in gathering gang intelligence, which is what they do on a day-to-day basis, he said he did not. And this is the mantra of gang investigation. The lack of memorialization, the lack of detail as it creates over and over again a void in time, date, names, or persons is routine and taken for granted simply because of what detectives tell you. I would submit to you that that in and of itself is not reliable evidence for you to consider when determining Rashad Murphy's guilt in a first-degree murder premeditation case. Whether it be Detective Nieder, Detective Griffin, Detective McCullough, this plethora of gang-related information always comes with the same proviso. A majority of that day-to-day investigation is like we talked about, gathering intelligence, monitoring social media, Instagram, Clubhouse, Spaces, YouTube, Twitter, X. They uniformly indicated that much of the time these sources are people's opinion to begin with. They stated that then when they review these sources, the content or the comments can come from Jacksonville residents, they can come from people from other locations that you wouldn't know because you wouldn't know their usernames, and that thousands upon thousands of people flood social media platforms with commentary ranging from celebrations of people's death, disrespect to people's death, you got what you deserve type of commentary when it comes to the reporting of murders and shootings. These detectives also uniformly highlighted that these groups originate in neighborhoods, and we've heard multiple times during the course of the testimony, hybrid gangs. Hybrid gangs, they have no initiations, they have no hierarchy, they have no bosses, they have no rules. They essentially work in a loose format. They don't have consequences. They can go from one to another. Very often the individuals that are associated act on their own. They said that. They testify. They don't need to be instructed to commit a crime. They don't need to be told to go do a crime. They don't say, okay, you, and you go do this crime. It doesn't work that way in a hybrid gang. They admitted that individuals associated with these types of respective gangs can commit a crime, commit a shooting, commit a murder against someone from another group or someone that's outside of that group, just a regular person they may not like, a person they might have a beef with, a person that stole their girlfriend, whatever the circumstances may be. And that could happen even without the rest of the group even knowing that it was committed until after it was done. So what I'm trying to get at is that you shouldn't just poof assume that every time something happens, it's in relationship directly to the gang, especially this kind of gang, as testified to over and over and over again. With respect to Rashad Murphy, I would suggest that there's a lack of evidence that would corroborate this participation at all. And don't just buttress it with this belief that he's a gang member. He's documented as one. Can't lie about that. That's what 874 says. 874 says that when you are in a drill rap video and you do it on 4 occasions, because remember there's a BOGO there when you get to these criteria. There's one that says that if you associate with a gang member, boom, you get a check. Or if you're in the company of a gang member 4 more times, boom, you get a check. But those are both the same things. Listen to them, read them to yourself, put them next to you, and what ends up happening is your criteria has been met in a blink of an eye. And it's certainly the law. I'm not asking you to disregard the law. I'm just asking you to look at how the law is written and what it does to people. So, Rashad Murphy's in videos, drill rap videos. I'm going to ask you to look at those individual stills and determine whether or not he is utilizing a gang sign. Look at the stills, look at the video, because as we talked about, and you can think it makes common sense. When you look at something like this, it may not be what it is when you do this. And therefore, that was kind of crazy what I just did. I apologize now looking back on it. But nonetheless, you understand where I'm going with this. You can't just take things in a vacuum. So follow that up and finish it up with, in 2021 and 2022, Rashad Murphy, based on a field interrogation report, was stopped as a passenger in a car with Noah Williams, Spinabenz, who is, at that time, 2021, a documented gang member of ATK, and therefore you're a passenger in his car, you've known him all your life, you grew up together, and you have now checked off that criteria. Like you'd consider those things. Criminal gang member definitions. I'm not going to go through them. The criteria is there. You heard it multiple times during testimony. You will have it as a definition when you deliberate. And I would ask you to consider it. Going back to Detective Nieder for just a moment, and then I'm going to move on. When we talked about general information based on his history, his opinion on alleged Jacksonville gangs, his opinion and interpretation on lyrics of drill rap videos, and finally his opinion on the gang he is currently assigned, which is ATK. He honestly tells you again that he relies very heavily on social media platforms, and in many cases, he doesn't even know where those posts are coming from. In his day-to-day intelligence gathering, he speaks to people on the street, again, without writing a report or even memorializing these names. He agreed with me that drill rap video is the highest level of disrespect, posting, rapping about people who died, putting it out there for everyone to see in order to get clicks, in order to get views, notoriety, get the community talking about you, celebrating a murder. The more angry, the more violent, the more pointed with disrespect, the more money. He also told you that with respect to many of these incidents that would form the basis of this war, that although not all of them, many of them are unsolved. He told you about the murder of Daquan Pickens, Jake Jitt, unsolved. He told you about the murder of Antonio Tilley, who was in fact killed by Jaquan Mills. This was testified to. And Jaquan Mills is not a gang member. He talked to you about Charles Jones being shot, you remember, in the foot in October of 2023. That case is unsolved. The truth of the matter is that most of these murders are not as simple as you would have them be when you just listen to them, because many have equally plausible explanations and alternative factual basis that would indicate that they're not all gang-related activity. Certainly not leading to enough evidence that would result in an arrest. When asked, none of them connected to Rashad Murphy, except for 1200. That's the only thing that would potentially connect Rashad Murphy to any of those things that would be the impetus, if you will, for him committing a murder in furtherance of the gang. What the state has intimated to you, though, in very clear terms, is that their theory is that Rashad Murphy's motive for killing Charles Jones, Julio Foolio, centered around the murder of Joe Rod Adams, Spaz, who died at 17 while at Raines High School at a football game. You heard testimony about that. A murder that took place 6 years prior to Mr. Jones's death. 6 years prior to Mr. Jones's death. This was not an open wound, as been suggested, based on a motive, ladies and gentlemen. There's no evidence that Rashad Murphy ever attempted to kill Mr. Jones during that 6-year time period. No evidence he participated in Mr. Jones' prior shootings. It's made up vengeance you were asked to attribute to Rashad Murphy and some desire to kill Julio Foolio. And this dovetails into Kenny Capps. And I'm going to try my best not to talk for a very long time about Robert Howard Kenny Capps. Remember, he was charged in the Joe Rod Adams murder, but in addition to telling you that there are no gangs, they're just neighborhoods, Mr. Howard ended up being charged with first-degree murder in that particular case with Joe Rod Adams. And He ended up pleading to manslaughter and doing 5 years. He got out in May of 2023. I'll try to spend as little breath as I possibly can on Mr. Howard because I believe the evidence indicates to you that when he talked, lies fell out. Remember that he identifies Mr. Murphy from a photo pack, and in the same respect, goes on to tell you that he had seen Mr. Murphy multiple times while he was in jail during the course of his arrest, during the course of the case. So I would ask you to look at Mr. Murphy's booking photo when you deliberate, which is 98C. And 98C shows Mr. Murphy. Also, at the same time, and while you're doing that, look at States 107, because States 107 is going to give you the photo pack that Mr. Howard picked Mr. Murphy out of. And it is, in fact, the same picture that was plastered on the news at the time of his arrest, and that should surprise no one and would lend Mr. Howard no additional credibility as to his being able to pick Mr. Murphy out of the photo pack. If you recall, Mr. Howard told you he didn't kill Joe Wright Adams. Adrian Gaynor did. And he said, everybody knew. Said the street knew. Everybody knew. In fact, he considers that some kind of badge of honor. Okay? And it's because he tells you, I don't know, you don't know, they don't know, the state doesn't know, nobody knows. But he says to this day, he said when he sat up there under oath, I didn't do it. So why that is important is because why would Rashad Murphy have a beef with Robert Howard? He knew, everybody knew, he didn't kill Joe Wright Adams. Okay? He's certainly not charged with the murder of Adrian Gaynor, who was supposed to have pulled the trigger. He died later, but somebody was arrested and somebody was convicted of that murder. So I ask you to consider when you think about this motive situation and Joe Wright Adams and why the evidence suggests to you that it shouldn't be the reason why you think Mr. Murphy would have any reason to kill Charles Jones is because, number one, it was 6 years later, nothing happened. And secondly, Charles Jones was a friend of Robert Howard's. Charles Jones was a friend of Adrian Gaynor. But there's never been any suggestion, to my knowledge, in the testimony you heard, that Charles Jones was suspected or was the killer of Joe Wright Adams. So where's the connection? Why all of a sudden is this Joe Wright Adams thing the reason why Rashad Murphy wants to kill Charles Jones? Talk about that and look at how that circle presents itself in your determination as to whether you think there's sufficient evidence. Not that you have to have a motive, and the state will tell you. You don't have to have a motive, but they've already told you that was the motive. Rashad Murphy has no reason to care about Robert Howard, ladies and gentlemen. None whatsoever. And so here comes Robert Howard. He's going to roll in 14 months after Charles Jones' murder, and he's going to say, hi, I would like to talk to the prosecutors and the state attorney and law enforcement. I have information that I spoke to Rashad Murphy before and after on FaceTime, and we had conversations, and he told me things. Then they give him a subpoena. Well, of course, there's a vehicle for him to come subpoena, but now he's testifying under a subpoena. Okay? But at the end of the day, he called them. They didn't call him. And so 14 months later, not on the 23rd of June when he was arrested, not after he got arrested the next day for distribution of methamphetamine, and he's been in jail for those months. Did he contact law enforcement? Did he say, hey, look, I got some information for you. Hey, there's something you ought to know. Hey, I want to be a good citizen. Whatever it may be. When did it happen? 14 months later. 14 months later, after he pled guilty to distribution of methamphetamine in federal court, punishable by life, subject to enhanced sentencing because of his prior serious felony, minimum mandatory 15 years in the federal penitentiary, in addition to, we haven't even got to, his violation of probation on the manslaughter, aggravated battery, and battery on a law enforcement officer, okay, that he's still facing as well. So he trots himself down, and look, I don't believe the state attorney's office promised him anything. I don't believe the federal government promised him anything.
But he thought he'd
why
get
would they?
something.
He needs to testify. He needs to show us what worth he has. And the worth is in the story. And the story is in a story that can't be corroborated. So to that extent, it remains to be seen how Mr. Howard will ultimately benefit from his testimony. But what he will say without equivocation is, hey, of course I want help. Told you that. Hey, I'd like to get some benefit from this. So it's the type of story it is that can't be corroborated. It's the timing of the story that should cause you pause to realize that this is a lie, and the benefit that he is expecting to receive. It's not what somebody will give him, it's what he is expecting to get. That's the key word for your consideration. So, at the end of the day, the court's going to instruct you that you can weigh the evidence, and you decide what evidence is reliable. You'll be instructed that you use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. And I would suggest to you that the evidence would suggest he is not to be believed. He is not to be trusted, and there's too many reasons to count. One of the criteria you should consider how witnesses acted as well as what they said, and one of those particular things is number 4, did the witness have some interest in how the case should be decided? Well, there should be a picture of Robert Howard right next to that. That's how close this fits as it relates to your consideration of his testimony. And finally, as a part, and I'm just paraphrasing, as a part of this instruction, you may rely on your own conclusion about the credibility of any witness. You may believe or disbelieve all or any part of the evidence or the testimony of any witness. But in particular, Robert Howard, I would suggest to you that the evidence suggests it is a straight up, in capital letters, disbelief. I want to talk a little bit. Well, no, I want to finish up with Robert Howard real quick. There was another thing that bothered me in the testimony that I think is relevant for your consideration. So, remember that Robert Howard went in August, 14 months later, and he gave a sworn statement. During the course of that sworn statement, Detective Ramos had the wherewithal to say, hey, listen, did you have a phone? You know, we'd like to look at your phone, corroboration. We're attempting to corroborate to determine whether or not there's evidence somewhere that you should believe or give credence
Say it
to.
again.
And Robert Howard signed a consent form. Federal government, law enforcement had his phone. He used that phone in doing the deals that he was in trouble for, he got arrested for, which means that they got his phone number. So what happens then? Very curious. Recall Detective Ramos. I asked him, what about the phone? You know, you started off getting the iCloud address for Kenny Capps. He remembered that. He told you that they had his phone. You acted like you were going to follow up with regard to getting the consent form signed to look through that phone. But then a couple of emails to the feds, and it kind of just disappeared. The one means of corroborating Mr. Howard was never followed up upon. Never followed up upon. In addition to the fact that we talked about, and there was testimony elicited from one of the detectives, even if you didn't know the phone number, which I would submit to you is going to be the evidence in his criminal case, all you have to do is call 911 from that number once it's powered up, and you'll be able to get the number. What do you do with that number? You get call record details, you do data checks on it, you determine whether it can be extracted, any number of ways that you can go down that road to do what? Corroborate that Mr. Howard had a conversation, or dose or trace, whatever it may be, with Rashad Murphy, because that's important. And Law Enforcement 101, why just stop? The only reason you stop is if you're satisfied with the answer. You're satisfied with the answer. So, moving on to go back to the Airbnb. What you recall from the Airbnb at Laguna Oasis in Tampa, the evidence showed you that there was no attempt to hide their identity, the individuals who were at the Airbnb. Isaiah Chance, Davion Murphy, Alicia Andrews, Sean Gathright. The state would like to tell you that they got sloppy when they started going in and out, and when the Vivint Ring camera captured them. But in the same breath that they want to call them sloppy, they characterize this plan, if you will, smooth, precise, intimately coordinated, thought through and through, expert marksman. Those are phrases that connotate detail. And so I don't believe they can have their cake and eat it too. But at the end of the day, what the evidence shows you is that those individuals freely came and went from that Airbnb, which would indicate their stay there. What it also indicates to you is that Rashad Murphy is not at that Airbnb at times relevant to this murder. Not 1 ounce of evidence, not one, to support that notion. You heard testimony that Alicia Andrews admitted that the other stayed with her at the Airbnb. You saw Davion Murphy activate the camera by crossing the parking lot. And there's a picture of that. It's part of the composite of the Vivid camera. You didn't see Rashad Murphy going across that parking lot. You didn't see Rashad Murphy getting into that Uber. Well, we know he did. The point is, he's not on that video. He's not on that Airbnb. The Airbnb driver, the Uber driver told you he was the front seat passenger. He was the one that slept the whole way. I didn't see where he came from, okay, because I was putting bags in the back of the car. Again, I would point you to the one smidgen of evidence that the state would have you rely on, and that is that if Mr. Murphy went into the Airbnb, it would have been for a fleeting moment based on their their presentation to you of the evidence, and also you can reconcile that when you listen to that portion of his interview. Corroboration of that, as you hearken back in order to get support, would be going back to how the Airbnb was rented, what account, by whom, who paid for it. Go back and tie these strings together for your deliberations. Consciousness of guilt. The state has introduced evidence on 2 fronts with regard to Rashad Murphy, and what they are going to argue and have already argued to you is consciousness of guilt. Number 1 is Mr. Murphy's Jacksonville arrest, where he did not come out for several hours, despite many attempts by law enforcement to get him out. I guess if you want to call that consciousness of guilt, you can. The question is, where was he going? He didn't try to get in a car and speed out of town. He was there. He didn't want to come out, evidently afraid. He was not armed. He was not threatening. Finally, when he either felt it safe to come out or felt that it was time to come out, he came out with his dog, came out with his Bible. He gave himself up. He did not, in any respect, resist law enforcement. But let's consider, when you talk about another reason why that could be the case, you have to go back 3 or 4 weeks ago. Because remember, in Gwinnett County, he was stopped in the Chevy Cruze. He was rolled up on and blocked in that Baymont Hotel. As he was getting out of the car, he had a gun drawn to him, and his instinct was that he ran. Would you have run? Would I have run?
Objection, Your Honor.
He ran. When he ran, he got tased. When he went to the ground and he was immobilized during that portion of time, for whatever reason, he was tased again, and he was tased in his privates. There was a struggle. He separated his shoulder. You could see in the video, there's a gun touching his temple. He went to the hospital. He got treated for a separated shoulder. So when you decide whether what happened in Jacksonville is consciousness of guilt, certainly consider what happened 4 weeks prior to that and decide whether or not there is any other plausible reason for his concern. And while you're at it, and you're considering whether or not there's consciousness of guilt as it relates to the incident at Gwinnett, consider those circumstances as well and look at that video. And you can decide whether simply him running upon seeing that gun in a strange community, in a place that he doesn't live, someone might have done the same. There's also evidence that has been testified to with regard to the flock videos in Gwinnett County. remember, the insinuation, if that is the case, would be that Mr. Murphy's vehicle was traveling in tandem with a black Chrysler 300, which comes back to Noah Williams.
What's
Again,
Benjamin's?
Noah Williams is a childhood friend. Noah Williams and that Chevy Cruze are close to each other on 2 separate occasions within an hour of each other. But recall and understand and take into consideration that you should lend 0 credence to this camera video, because what you also know is that Mr. Murphy was incarcerated at that time. Mr. Murphy's not in that car. Rashad Murphy, look at the times. I won't take time to do it now. Look at the incarceration certified information. He was in jail in Gwinnett County when those SWAT cameras were taken. So choose to give whatever weight you choose to give for that, for whatever reason.
I did think the being in custody thing was a bit weird, but they'll have to address that in rebuttal.
A lot's been said about Mr. Murphy's jointly possessed telephone, the extraction, things on the extraction. Consider all pieces of evidence or lack of evidence when it comes to extractions and context and what you have and what you don't. Why that is particularly important in this case is that if you remember, the testimony from Sergeant Carter from Gwinnett County indicated to you that there became a big problem with that phone. I would suggest to you the evidence would be because it was mismanaged. It was mismanaged because the cover was never taken off. It was put on the Cellbrite charger overnight without looking at it close enough to know that the wireless charger was not charging. And therefore what happens in that circumstance is that the phone goes dead. That's the one thing you can't have when you're doing an extraction, is the phone to go dead while it's in your care. Instead of waiting and starting the extraction again, it was left on overnight, it wasn't charging, and when the analyst came back the next morning, it was dead. What does that do? That changes the ability to get a full and entire extraction. It limits what you can get in terms of data, in terms of text messaging, in terms of location. And so, therefore, you consider what, if anything, that would ultimately have to do after the mismanagement of the Gwinnett County Sheriff's Department in handling that phone and getting from that phone anything that would be contextually important. Before, after, during. Ladies and gentlemen, you also heard briefly about the Spaces conversation between Isaiah Chance and Julio Foolio, and subsequent messaging between Rashad Murphy and Sean Gathright. Recall that there was some banter back and forth between the two amongst 16 other people. This is not a private conversation. It's on an open Spaces conversation line. I'm not very familiar with it, but that's what's happening because you're listening to it. And they're getting after each other a little bit, and Foolio was telling Isaiah Chance, hey, look, you're a fraud, you heard testimony that, he had made mention that he was gay. Remember that Isaiah Chance was an aspiring rapper as well, okay? Remember that he wants to be, if he isn't already at that particular time, a rapper, certainly not with the notoriety and the monetization that Julio Foolio has. And essentially, afterwards, consider that exchange being, look, go do what you do. Don't let that guy bother you. You stay doing what you're doing. It doesn't have to be, hey, look, leave him alone because we're going to go kill him. You decide when you consider the evidence and what you hear and how it relates to the context of the messaging and whether or not there are plausible explanations for it. Ladies and gentlemen, we're going to talk real briefly about direct and circumstantial evidence, okay? Direct evidence is evidence that tends to prove a fact directly that is in question in a case without the necessity on reliance of inferences or proof from other facts, right? Direct evidence versus circumstantial evidence. Circumstantial evidence, on the other hand, and follow me on this, is evidence that first has to be relevant. Once it's relevant, it is of a quality that leads to an inference that an event did or not occur. Circumstantial evidence is legal evidence. It is allowing you, and you can utilize it, but you have to be careful with it. You can't take an inference, and you shouldn't take an inference, that doesn't go from here to here to here, but yet goes from here to here. And then you rely on it in an effort to come to a conclusion. Circumstantial evidence needs to be proved beyond and to the exclusion of a reasonable doubt in and of itself. Things that lead you to other things are very dangerous. And I want you to keep that in mind when you deliberate.
There's more.
I strongly believe, ladies and gentlemen, the evidence in this case and what it's shown you is that Rashad Murphy is not guilty of premeditated first-degree murder, conspiracy to commit the same, and 3 counts of attempted first-degree murder, based on the totality of the evidence. But you need to know that even if the evidence does not convince you that Mr. Murphy committed the crimes for which he is accused, and I just named them to you, there may be evidence that you may find that he committed other acts that would constitute lesser crimes. And so in that regard, the law dictates that if it hasn't been proved beyond and to the exclusion of a reasonable doubt, you would look at lesser crimes. And I want to just go through them with you very quickly. Not going to post them. We're not going to go into them in depth. But the lesser crimes of first-degree murder are second-degree murder and manslaughter. The lesser crimes to attempted first-degree murder are attempted second-degree murder, attempted manslaughter, and aggravated battery. And you should know those, and there will be an instruction that the court gives you that will set them out. So, as I conclude my argument, and thank you for your attention while I've done so, remember, it's not if you believe Rashad Murphy is guilty of one or any of these charges. If you believe that he might have done it, that's not enough. If you believe he possibly did it, that's not enough either. If you're pretty sure, maybe even almost certain, that he's guilty, if you can't exclude a reasonable doubt, then the state hasn't met its burden. It's not about odds. We're here in Tampa, Florida, not Las Vegas. Reasonable doubt can come in the form of a lack of evidence. It can come in the form of the quality of the evidence, which we've talked about that a lot in this closing argument, the quality of the evidence and the lack of being able to prove something. And it also can come in a conflict in the evidence. And I believe the evidence is lacking in all 3 of those phases as you sit down and you categorize what you've heard. Remember that you are 12 individual people when this is all said and done. You're 15 right now, so I don't want to slight anybody, but you will be 12 individual people. And not merely just a group of 12.
A gang.
And the reason I say that is you're going to
Call
go
them a
back
gang.
there and you're going to deliberate as those 12 individuals. And you promised me you're going to do that. But you're going to do it together. Maybe it's compounding. Maybe it's not a great way to explain it. But what I can tell you is this has been going on 30 days or so, even back through jury selection. And you've gotten to talk to each other every day throughout the course of the day, talked about each other's lives, probably each other's families, probably each other's work. And you might have formed friendships with people. You might have determined you don't like somebody so much. You certainly might have built a rapport and respect for your fellow jurors. And to that extent, you might think of yourself as a group. That would be natural. That would be human nature. But at the end of the day, this is an individual decision for each of you. And you told me in jury selection that you would remain true to those beliefs and those convictions based on your oath and your view of the evidence, despite the fact that you may be in a majority or you may be one. You may be that one that is so firm in your convictions that despite having spoken with everyone else and listened, you have a particular place that you are in this case, and you should not give that up unless you are convinced otherwise. Thank you again. You'll be told this again, but when I sit down, and you don't have to all start clapping at one time, you won't hear from me again, but you will hear from Ms. Doherty again. It's called rebuttal, based on the law. I'd love to get up after her, and then she could get up after me, and then I could get after her, and we could go all night and figure out who's left standing and conscious at the end of the day. But having said that, the last word is not always the most credible word. And I would lead you with
Look at Eismer. Hold on, look
Rashad
at
Murphy should
Eismer.
not be,
Watch her face.
the last word is not always the most credible word. And I would lead you with Rashad Murphy should not be penalized for what he did not do and what the evidence does not prove he did, and what I believe the state is incapable of meeting their burden beyond and to the exclusion of a reasonable doubt. So I hope that after you deliberate thoughtfully, you will come back with a verdict of not guilty as to premeditated first-degree murder, not guilty as conspiracy to commit first-degree murder, and not guilty on 3 counts of attempted first-degree murder. Thank you very much.
Okay, very good. Thank you, Mr. Gonzalez. Let's just take a quick 10-minute stretch comfort break. All right, we will come back and continue with closing arguments.
Go see if somebody tells you good job in the elevator. If you missed it when we came back from lunch right after, they took lunch after the prosecutor's opening closing statement, their first close. And Doherty, Michelle Doherty, the prosecutor, said, "Judge, court, everybody, just want to let you know, I heard someone say good job, and I turned around, and it was a juror." Next up, I do think they're going, I think Jason Wise is going second. And then Petredis for Isaiah Chance, and then Nick Sinardi for Davion Murphy is going last for the defense closing arguments. And then the state could have rebuttal. What do you think they're saying? What do you think they're talking about right now? All right, so we'll skip this break. Looking around the courtroom a little bit there. Yeah, probably asking, are we working late? We're definitely working late tonight. And don't ask me to predict how long deliberations will take. It's a lot of material. And it's a heavy decision. So, you know, people could go back there and think all the way guilty, but they still would want to be sure. People could go back there and have questions. People could go back there and be confused by all the lessers and the principle, and can we not do this if we don't think that it was actually a gang, or if we think it was a hybrid gang, like the lady said yesterday. It's a lot. And one of the jurors was worried about being sequestered over Mother's Day, and maybe that's because she didn't, or he, I don't know, didn't feel like they'd get to start deliberating anytime soon. But if that juror has that concern and thinks that they'll be deliberating most of the day tomorrow, maybe they don't think it'll go quickly.
Let's go ahead and bring in our jurors.
No, it's Sinardi doing the closing. It's Damian Smith's attorney doing the closing. And then Rashad wanted to change his name on the forms. And you know, the jury also has to make some considerations, and
Okay, welcome back, members of the
one more thing, Michelle Doherty in her closing was emphasizing, like, for the 3 shooters, you'll have to consider this. So if they get back there and they have to keep reminding themselves, like, all right, well, this one we're only supposed to consider for the 3 shooters, and which one's not the shooter again? Oh, that's Isaiah Chance. You know, they've got to think through all of those things.
Jury, we are ready to proceed, and next up will be Mr. Wise on behalf of defendant Sean Gathright.
Yep. Jason Wise.
Sean Gathright had no part in the shootings that took place here in Tampa. He was a barely 18-year-old young man who found himself caught up in a whirlwind here in Tampa. He found himself caught up in something that, as you've heard about for these last 5 weeks, he had no part in, ever. And as the evidence has shown you, and as I'm going to describe in further detail, he did nothing to knowingly assist anyone in carrying out these shootings that took place in Tampa. The state's case, like any criminal case really, can be looked at like a jigsaw puzzle. And law enforcement's job and the state attorney's job is to try to put the pieces together. Ultimately, it's your job to decide if they fit. And if you've done a jigsaw puzzle, I'm sure all of us have at some point, you know there are times when you see a piece, it looks like it should fit in this spot. Colors seem to be the same, shape is similar, but then you try to jam it in there and it doesn't fit. And that's the nature of jigsaw puzzles. That's why they're fun. Sean Gathright is one of those puzzle pieces. And that's the reason we have the system we have. That's why you all are here. Our system of justice is not perfect, but it's the best one the world has ever seen. And one of the reasons for that is we have protections to ensure people are not wrongfully convicted. One of those protections is to hold the state to burden of proving to you beyond every reasonable doubt that a person is guilty. Now, it's convenient where Mr. Gonzalez left off talking about reasonable doubt. That's where I'm going to start. You'll hear many instructions on the law tomorrow, but one of them will be a definition of reasonable doubt. And our state, I would suggest, has a strange way of defining reasonable doubt, because it starts off first by defining what it's not before it defines what it is. And we may have discussed this instruction in jury selection weeks ago, but you'll hear tomorrow that reasonable doubt is not a mere possible doubt, speculative, imaginary, forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, and this is when it begins defining reasonable doubt, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if you have a conviction and it is not one that is stable but which wavers and vacillates, then the charge has not been proven beyond every reason. The instruction, as Mr. Gonzalez told you, goes on to say a couple sentences later that reasonable doubt can arise from the evidence, lack of evidence, and conflicts in the evidence. I'm going to try to frame my argument on those three areas. I'm going to start by talking about the evidence and conflicts in the evidence, because they kind of go hand in hand in this case, I would use. And I want to start talking about the phone records, because you heard a lot about phone records. All kinds of phone records, frankly. One thing I want to remind you all is that Mr. Gathright's phone is never actually collected in evidence. And law enforcement is relying on cell tower records and iCloud search warrant results. But the one thing I want to talk about a little bit is the phone mapping, because you heard a lot about that from a couple of different witnesses. You first heard about it from Detective Klein, he was tasked with going out and trying to corroborate where there were certain cell tower hits. And he himself told you that this is often a guessing game. It's an estimation based on records that the phone companies keep for their own purposes to try to maximize their coverage areas. One of the things you heard about was timing advance and call detail. And I'm showing you, by the way, this is a print screen from State's Exhibit 77. You'll probably remember I had difficulty playing it. We had to wait 5 minutes for it to catch up, so it's already a long day, so I'm not going to go there. But you all will have that in the back with you when you're delivering. You can watch it. It's much easier to play on a computer than on these on the system we have here. But this is a print screen that stops that at 4:45 a.m. And you'll see that it has timed hits, and this is Mr. Gathright's phone number, hits that span about 4:34 to 4:45, so right in between when the shootings take place. you'll see that there are multiple hits in this area around the time of the shooting. But at the same time, at 4:39, the phone is hitting on the northern sector of this phone tower, which encompasses the Airbnb. It's also just south of Fletcher Avenue, far to the north of the shootings. If you recall when Detective Ramos described this area, and it's really everything involved in this case goes from just north of Fletcher, south to Bush, basically between Nebraska and just past McKinley. But right in between the Airbnb and the shooting is the entire USF campus. So as he described, to go between the two, you either have to go through USF or go around this way. So these hits, I believe, suggest to you, and I'll show you another one that is a print screen from 454, which is a little after the homicide. And here we have phones bouncing off towers over that entire area. I show you this to emphasize, clearly these records are not reliable to pinpoint a location, because within this span, phone is hitting all over that entire area, within just about a 10-minute span. But the one thing that you can be pretty certain of with these records, and Detective Ramos even described that, the phones have the towers have three sectors. And while it's an estimate to say where the phone may be within the range of the tower, the one thing that we can be pretty sure of is that it's within one of the three sectors of the tower. And if you look closely at these phone hits, they're basically almost all, if not all, on the northern sector of these towers. There's a couple on the eastern or western sides, which will cover some of the northern area, but almost all are on the northern sectors of the towers. And that's very important because of this tower right here. Because we know the tower is right here in this area on the USF campus, and really on the northern side of the USF campus. And the phone is hitting on the northern sector of it within seconds of when the shooting's taking place. Now you may be saying, well, how are these other hits taking place down here? Well, again, they're on the northern sides of the towers. So it's perfectly reasonable that the phone could be further away but connecting to the strongest signal, which could be one of these, but it cannot reasonably be south of this tower because it would not be hitting that sector of the tower. And that's the one thing we know. And again, you'll have this back there. You'll have the actual PowerPoint. Play it, watch, take a look closely at where these phones are hit. It shows you not only how unreliable it is to suggest these tower records can give you specific locations, but pay attention to the sector that's being hit. Because there's no explanation, and you haven't heard an explanation for how we're on the northern side of that sector right when the shooting has just taken place. Now, a lot was also taken out of the phone, I guess you could say, but really from the iCloud search warrant. And the state has kind of picked certain pieces of evidence to highlight and suggest it's indicative of guilt. I'm asking you to look at the full picture, pay attention to the times, and pay close attention to really all the evidence surrounding these things that have been pulled out of the phone. You heard about it, and frankly I'm not even sure why, but you heard about Mr. Gathright's Instagram account, but Detective Ramos himself said there was really nothing of relevance from his Instagram account. It was from some others, but not from Mr. Gathright's. Something else you'll see in looking at the phone records, there's very little communication between Mr. Gathright and any of the co-defendants with the exception of Mr. Chance, who is a friend, but again, almost no communication between him and any either of the Murphys or anyone else who's alleged to have been involved in this alleged conspiracy. One of the things, though, that you've heard about a lot is the one text message from Rashad Murphy to Mr. Gathright. And again, this is another example of, you look at that puzzle piece with a cursory glance, maybe it looks like it's going to fit. But here's what I want you to pay attention to about that, and this is why it doesn't fit. That text is allegedly sent to Mr. Gathright in response to the conversation that Isaiah Chance is having with Charles Jones and some other people online. And what is said is, first, we got bigger S to tend to, and then Rashad Murphy is saying, they ain't worth our energy. This is in response to Chance talking to Charles Jones and his entourage. Rashad Murphy himself is saying, they ain't worth our energy. That is not suggesting it has anything to do with Charles Jones. That's suggesting it doesn't have anything to do with Charles Jones, because he's saying those people that Chance is talking to are not worth our energy. There's a suggestion that it's something saying that Sean Gathright is part of some plot, but when you peel back the layers, it actually suggests the exact opposite. Now, what else do we know about that? That text is sent on June 8th. There is never an announcement about Julio Foolio performing in Tampa until June 14th. This is 6 days before there's ever any announcement made that there's going to be a Julio performance in Tampa. So it makes absolutely no sense that that text message, when you look at the full context, has anything to do with this alleged conspiracy. Now, what else do we know from the evidence? That flyer advertised that the performance was going to be from 8 p.m. to 3 a.m. Okay. There is the screen record that you've heard about that was in the iCloud dump, and it's taking place after 8 p.m. It's taking place after, as you heard, the pool party was supposed to be 5 to 6 p.m. Teasers was supposed to start at 8. This is happening long after teasers was supposed to have begun. And if Mr. Gathright is allegedly targeting Charles Jones to try to shoot him, everyone knows where he's going to be at 3 a.m. Yeah, Detective Ramos said, yeah, performers come late, and I'm sure most of us who've been to a concert know that. But Julio Foolio is the headliner. The club's going to close at 3 o'clock. Everyone knows where he's going to be at 3 a.m. So why would Mr. Gathright, if he is trying to shoot Charles Jones, why would he put all this effort into trying to find out where he's at, leading up to the show at Teasers, where he knows Charles Jones will be at 3 a.m.? Very similar to the text messages with Kyle Landry. Again, look at the full context of this. Okay. And I'm glad Ms. Doherty said that it doesn't matter who Fat Boy is, because there was never a Fat Boy identified in Charles Jones' entourage. Detective Ramos came to believe it was Xavier Edwards because Robert Howard, I guess, said that he himself calls him that sometimes. But as you heard Detective Ramos previously testified, he's never identified anyone by the name of Fat Boy at that party. But again, look at the full picture. Those text messages are beginning around 1:30 a.m. The entourage is kicked out of the Airbnb after that. They're starting long before that ever happens. So, and again, by this point, Charles Jones is expected to be at Teasers. And ultimately, that's what Kyle Enright is told. He's going to Teasers. So, why is it being asked of Ms. Enright about 6? Assuming 6 is Charles Jones? Don't know, but it doesn't make any sense that would be anything to do with a plot to shoot him, because everyone knows where he's supposed to be at that point. And again, if Mr. Gathright is intending to shoot Charles Jones, why on earth would he bring someone in, let them know that that he's looking for Charles Jones, someone who has no dog in this fight, and just create another witness? It makes no sense, especially when you consider, again, everyone knows where Charles Jones is going to be at that time of night. And what else do we see from the phone? 2:31, there are 2 texts to his phone, Mr. Gathright's phone, from Alicia Andrews' phone, saying, pick up your effing phone. There's been some suggestion that everyone is communicating on some special app that can't be tracked. But there's no evidence of that. That's a theory. But ask yourselves this: why, if that's happening, why go back and forth? Why would you not communicate on the secretive app the entire time? Why are you going to send a text message in addition to that? Why are you going to make a phone call in addition to that? Because there is a phone call after that, very short. I'm not even sure if it connects. And then there's nothing again until the next morning with Mr. Gathright's phone and Alicia's phone. And similarly, we have seen evidence that Alicia Andrews shares her location with Mr. Gathright. But if Mr. Gathright is part of this whole conspiracy, why would she be doing that? Again, you heard and you even saw video that this Impala is right outside Truth 18, right before it goes to the home suites. If Mr. Gathright is in that Impala, they're following the entourage. And we know it's right in the area of that home suites. Yeah, the cruise pulls into the parking lot before, but the Impala is right in that area. And the Impala, if they're following this person they're going to shoot, knows where it's going to be. They followed it right to that area. So if Mr. Gathright is in there, ready to shoot Charles Jones, why does Alicia need to share the location? And again, one thing that none of this can explain is, why is that phone hitting a tower on the north side of the USF campus? Let me talk a little more now about the videos that we see from the home to suites and the press line. Okay. None of those videos, and I should say even before that point, there is no evidence of who got in that Impala. Okay. Frankly, there's not even evidence of how many people are in that Impala. You heard Detective Ramos' theory of who's in there, but there was no evidence showing who got in that pallet before it's at home to suites. When it gets to the home to suites, you don't see who gets out of it or where they get out of it to know who is sitting where within the car or how many people are even in the car. You'll see the videos, as you have several times now already. You can't tell who gets out of where in that car. And then you never see people getting back in the car, and you never see that pallet leaving. You've heard a lot of theory as to who the shooters are and what you can allegedly tell from the video. You've heard Detective Ramos allege that he can make out a light skin tone of one of the shooters, and he claims that person is Mr. Gathright. And I think this is one of the spots. I want you to pay close attention and compare these still shots to the actual video, because the video is the video is very clear. These still shots are great. But it was pointed out to you, you can see this looks like a light skin tone. Look at the bottom side of this banana leaf. Look at the side of the pole. We know there's a landscape light right there. It makes everything that it hits look lighter. When you watch the video, you'll see that as shooter number 1 runs by this light, his skin was just as pale as the person in this photo. You can't make out anything about skin tone from these still shots or that video. But again, compare these to the video. What else are we able to see from the video? You get a very good look at the firearm that shooter 2 is holding in the video. Again, there are screenshots pulled out. The video, you see this fire. In fact, it stops right before shots are fired. And you can see for a full probably 2 seconds that very gun before it's fired. You can make it out very clear. I would suggest to you, people can look at photos over and over again and begin to see things that are not there. Detective Ramos told you he's looked at this countless times. He's come to believe that this rifle matches the rifle in evidence, which, let me approach.
Sure.
Oh, we're doing a demonstration.
Showing you the actual rifle that Mr. Gathright is alleged to be holding in that photo. 56.
God, Harmon's
We'll
got
have
to
all
be
the-
jealous.
If you recall, Deputy DeJesus, he was the alleged firearms expert. One of the instructions you're going to get tomorrow, by the way, is on weighing the evidence and different factors you can and should.
I had to pause. I was waiting for the captions to come up. He did say alleged firearms expert. He is going after Tatum's man here. He's only an alleged firearms expert. So he had said something to that effect when he was doing the questioning of DeJesus.
Tomorrow, by the way, is on weighing the evidence and different factors you can and should consider. One of them was the witness honest and straightforward in answering the defendant's or the lawyer's questions. I would suggest Detective Jesus was not very straightforward in answering my questions, but one thing he was really straightforward about is that this sight is fixed. This is not something you can flip down. Okay? And this is a pretty big, you'll have this back there to look at. This is a pretty significant piece of metal, the front sight. It is not on the rifle that's being held. Okay? And you really can see it when you look. I'll flip through a couple more screenshots, but you really can see that when you watch the video. Just the same, the hand grip, much wider. The angle of the barrel coming off this does not match what you see in that video. There's a sight that is not on this rifle. And I would suggest to you, when you look at the top piece, this handle on the top, it doesn't match what you see in that video. But you'll have all of this, and you can compare it yourselves. Look at it. There's no question, this is not that rifle. That, by the way, the one I'm showing you is 139N. There's quite a few still shots where you can see this, but again, the video shows it better than anything. 139S, again, can't make out the sight. Does not match the shape of that rifle you saw. 139K, probably an even better angle as far as the still shots, what we can see of that rifle. Again, pay attention to everything on top. And again, 139M, shape doesn't match. Now, what have we heard about the day after the shooting as it relates to Mr. Gathright? The next afternoon, I think it's at 3:11, he is going in the Airbnb. And he's by himself. Everyone else, I'm not sure if they've left yet at that point, but everyone else leaves and goes to Jacksonville. Mr. Gathright is there by himself in Tampa. And he's asking for the code to be let in. Now, the state, again, is at a theory of who has gone into that Airbnb, the one that is north of USF. But there is no evidence of how many people or who has gone in and out of that place, because everyone has been going in the back door. And it's not unreasonable that people would do that. As you saw from the photos, there's a side parking lot right on the side of that particular unit. And if you park on that side, the back door is as close as the front door to get in. And the back door is much wider. And if multiple people are going in and out over the course of a weekend, the back door can be left open while the front door cannot. Because as you heard, the front door requires a code to get in. So the state has a theory as to how many people had stayed in that Airbnb, but there's no evidence to suggest how many people could have gone in and out during that night. But what we also know, aside from that, Mr. Gathright goes on to his grandmother's house in Polk County. And then he goes on to his sister's party in Orlando. And that had been his plan the entire weekend. He's going to his grandmother's house, switch out cars for his business, his pressure washing business, and then he's going to Orlando for the sister's party. And unfortunately, he came to Tampa on the way, apparently with his friend Isaiah Chance, without any idea what was going to be happening to him. But this alleged tampering with physical evidence charge, which is count 6, is alleged to have taken place when he goes to Polk County. And as you heard, one of the elements that you're going to be asked to decide is whether Sean Gathright altered, destroyed, concealed, removed any item with purpose to impair its availability in a basic criminal proceeding. There is nothing that he does to conceal, remove, destroy any evidence. Again, there's a theory that apparently he is wiping down the inner door handles, and by doing that, and then by leaving the car with his grandmother, he has now tampered with physical evidence. But again, step back and look at the big picture. The car is owned by his mother. No question about that. Clearly, that's going to be traced back to him. And he's leaving it with his grandmother. It doesn't take Sherlock Holmes to find out where that car may be if they're looking at Sean Gathright. So there's nothing concealing about leaving it at the grandmother's house. And as you heard, the grandmother's driving. It's not like it's being hit inside the garage and never to be seen again. The very next day, law enforcement finds it. And to suggest that Mr. Gathright is tampering with the car by wiping down the door handles makes no sense. If he's trying to wipe off fingerprints or DNA, why only do the inner door handles? People get inside a car, don't touch just the interior door handle. The steering wheel is probably the most touched, at least by the driver. That's never wiped down. And in fact, as you saw from the evidence, after the door handles have been wiped down on the inside, or the interior door has been wiped down, Mr. Gathright gets back in it and moves the car. So he's clearly leaving any evidence of himself in the car. And if he's trying to get rid of evidence of who's been sitting in the car, wiping off the doors is not going to help. Because clearly, people are going to be touching many, many areas inside the car. And even though, if you would suggest, well, why do that? That's just why, because he's cleaning for his grandmother. But if you're trying to get rid of evidence, why do you leave the rag right there in the garage? As you heard, law enforcement collected that very rag. So while it could have, I guess, wiped off fingerprints, number one, it would still leave fingerprints in many areas. But if it's DNA, the rag's right there to test. So to suggest that is altering, destroying, concealing, and removing evidence is a major stretch that the law does not see. So, as you've heard, Mr. Gathright goes on to Orlando. Now again, he's by himself in Orlando. None of the people who have been in Tampa are with him in Orlando. In fact, they have gone back to Jacksonville, and at least one of them has actually gone inside his house, by the way, while he's in Orlando. You saw, again, this is stuff that's pulled from the phone, and there's, I think, a suggestion that Mr. Gathright taking pictures of Don Julio is somehow indicative of guilt. You have seen Don Julio is everywhere in this case, on both sides. Charles Jones's entourage is drinking Don Julio. They're drinking Don Julio at the pool party. It's in their cars. Taking a picture of Don Julio does not suggest he had some part in Charles Jones's homicide. And trying to make such a stretch is a dangerous thing to do. I'd also point out to you, there's no evidence, and he did not send these videos to anybody. It's not like being sent to the other alleged conspirators saying, hey, let's celebrate. These are videos that are just in his phone that he apparently took, or someone took from his phone. The other thing that's in the phone that I would suggest to you that's important is this allegation that he is making a gang sign. And you have heard all about gang signs during these last few weeks. The one thing you have consistently heard, though, is Mr. Gathright was not known to any of these gang detectives in Jacksonville. He's never been documented as a member of the gang, and none of the Jacksonville detectives ever even knew who he was until Tampa contacts him. Now, you heard, and you will have the video back there, and I'd suggest to you, the video where this alleged gang sign is being thrown up is literally so fast that you blink, you miss it. You'll have it back there to watch. But in any event, as Detective Ramos confirmed, the alleged gang sign has Mr. Gathright putting his ring finger down. Well, in Mr. Foolio's teaser's flyer, he's making the very same sign, and he's clearly not a member of 1200, because that's been the whole theme of this trial. If you also noticed, every witness who told you about the 1200 sign, initially, every witness said the 1200 sign is putting the middle finger down. Every one of them said that until I brought up with Ramos, Detective Ramos, that Mr. Gathright has the ring finger down. And then you hear Detective Griffin say, oh, no, it can be the ring finger or the middle finger. Every other alleged expert, every other alleged gang member said, no, it's the middle finger. Until I said ring. Now it can be both. I want to show you, just briefly, 84A, that chart of the alleged 1200 members. Every one of them has the middle finger down. Again, it's kind of neither here nor there. Mr. Guthright's not alleged to be a gang member. There's been no evidence that he is. But every little piece of evidence from that phone that could be picked out has been thrown in front of you. And that's grasping at straws. Finding that sign, that is not a 1200 sign, being thrown for a flash second in a club that he's at for his sister's birthday party. Okay. So what else do we know about Mr. Gathright? A traffic stop is conducted later in Jacksonville. There is nothing in that car that connects back to the shooting attempt. And the detectives confirmed. Now, there's a vast amount of firearms material inside the car. And I'm sure when law enforcement made that stop and they found all that stuff, probably thought it was a gold mine. Because again, they're trying to jam that puzzle piece into the puzzle. And this sure makes it look like it fits. Because there's a 9mm in there, there's 9mm ammo, all sorts, there's rifle casings, there's rifle ammo, but none of it connects back to the shooting attempt, including the 9mm handgun. And we know a 9mm fired at least 31 rounds, but it wasn't that one. And what else is in that car? This is some loose ammo, especially the rifle ammo, consistent with someone who would reload ammunition, as you heard of. The only thing of relevance to the case, to the alleged relevance anyway, is that there's a group of casings, fired 223 and 556 casings, one of which matches back to a casing from the group that was collected when Julio Foolio was shot in the foot many, many months before in October. Again, the one thing that and I'll talk about this some more when we talk about what's in the house, but the one thing that the examiner told you, not one thing, but one critical thing she told you, is she can't say when any of these casings were fired. All she can say is they're fired from the same handgun, or the same, in this case, rifle. Could be 5 years apart. That was her testimony. There's nothing else connecting Mr. Gathright to that shooting. And what's critical about that is Jacksonville has been investigating that since the prior October. And again, remember, they didn't know anything about Sean Gathright. So there's been no evidence he had anything to do with that shooting. And you better believe those Jacksonville detectives, I'm sure that was high on their priority list, when the most high-profile rapper in Jacksonville was shot, they're going to try to figure out who did it. And they didn't know anything about Sean Gathright. So move ahead to the search of the house, which happened shortly thereafter. And again, this is a house Mr. Gathright shares with his mother, a retired Marine, who, I suggest he was an avid shooter based on the evidence. But the plethora of firearms and firearms material are found within the house. And again, and by this point, by the way, law enforcement doesn't have any forensic testing back from what's found in the car. They probably think they are continuing down this trail and that this gold mine is just getting deeper and deeper. Because there is a massive amount of firearms material in the house. None of it's illegal to own. But I'm sure law enforcement thinks, man, this puzzle piece is really looking right. When all this is tested, again, it doesn't fit. You heard about this cardboard in the sink, and I think there was some suggestion that Mr. Gathright, or someone is trying to get rid of things that were used in the homicide. But you heard from the technician who pulled all that out. She dried it off, tried to find any labels she could. She basically figured out what all those boxes correspond to. But none of them connect back to anything used in the shooting. There's a drum magazine, I think a couple of drum magazines even. Clearly, none of the rifles or handguns used in the homicide have a drum magazine, because you would be able to see that clear as day. There's a Glock chassis, which is apparently something that can convert a Glock into like a rifle. There's no evidence of that being used. There's a red dot sight box, no evidence of that being used. So whatever's in the sink, again, probably at first glance looks like, oh man, they must be trying to get rid of evidence. But when you actually look at what's in there, none of that matches back to Tampa. Same thing with what's in the safe. There's a 9mm again in the safe. Doesn't connect back to this shooting. There are several firearms, but there are two that apparently law enforcement thinks must be involved in the Tampa shooting. And those are the two that we have in evidence, the one I just brought up here. One of those, the 5.56, and I would point out, by the way, you heard a lot of testimony about, no projectiles were collected, they were all broken up, couldn't be tested. But the examiner told you she had 18 projectiles that she was able to test because they had the rifle, including a couple intact bullets. So 18 different projectiles. 16 are completely eliminated from having been fired from that gun, the 5.56. 2 of them are inconclusive. Okay. And you heard that at FDLE they have inconclusive plus, inconclusive minus, or an inconclusive. Those 2 were not inconclusive plus, they were inconclusive. She can't say they were fired from it or they weren't fired from it. No evidence either way to suggest either of the 2 projectiles that couldn't be eliminated came from that gun. You'd be being asked to speculate that that could have been one of thousands of 5.56 that could have fired those projectiles. One of which we don't even know is the same caliber. What else do we know about those guns? The 300 blackout, every projectile is eliminated from that gun. Nothing matches back to that 300 blackout. Again, look at, I think it's shooter number 3 who's alleged to carry that. Compare it. You can't see his as well as the other 2, but it's not used in the shooting. And there's not even any indication of a 30 caliber anything is used in the shooting. Now, why else is that significant? Because you heard from a DNA examiner who came in here. And she testified, the only DNA that really was found in any evidence in this case was from a wrap that was on that 300 blackout, a wrap that was on the handle. She found 4 profiles, and potentially could have even been more because, as you heard, they basically limit their findings to 4. One of them is consistent with Mr. Gathright. The gun's in his house, that's not unreasonable. But what's important to remember is the state's not claiming he held the 300 blackout. Their theory is that he held the 5.56, the one I just showed you. It doesn't match what you see in the video, by the way, but regardless, the 300 he's never alleged to be holding in the shooting. But that's the only place the DNA comes from. That also is the one that has the brass catcher. Now again, I'm sure you all have been saying, well, there's those 2 casings in there. And that's true. You heard the examiner say 2 casings that are found within the house were fired from the same firearm, the same 9mm that fired the one, I guess, 9mm that she was given to test. Remember, the examiner was only given 1 of the 9mm casings. The rest, the other 30, were sent to ATF for their specialized DNA testing process. So she only had 1 to compare. Very well could have been more than 1 9mm used, and I'd suggest you there was because of the rifling that's seen. But in any event, what do we know about that? Again, the examiner can't say when the 2 9mm casings found in the gun safe were fired. Could have been 5 years apart. What's really critical to keep in mind is they are different brands. Now, there's been a lot made about the fact that Max Tech 9mm casings, or rounds rather, are in the Forerunner when it's searched in Jacksonville. I'm showing you for the record what's 48, but that's an L to L or 9I. But again, that's the 2 boxes of Max Tech 9mm ammo that's found within the Forerunner. But look at 44mm. One of those boxes is entirely full. The other one has all but 2 shells out. Now these wouldn't be, they're probably saying, well, there's 2 found in the case. Right, but they're not Max Tech. The ones found in the gun safe are federal rounds, which clearly is further indication those were not fired at the same time. But I'll get back to that in a Another thing Detective DeJesus, I would suggest, was actually straightforward about, is that Max Tech is a pretty common brand of ammo. And it's pretty common because it's one of the cheaper brands. So to suggest that Mr. Gathright must have been connected to the Tampa shooting because he has Max Tech 9mm boxes in his car makes no sense, especially when they're almost completely full and there are 31 fire casings back at the scene. Number 31, by the way, is pretty important. Because as you heard from Detective Ramos, when he found the two casings himself, or he heard about them in being found in the gun safe in Jacksonville, he himself thought, and even put it in his report, those two must have been fired at another time. Because he didn't even think it was possible to get a round or a magazine that would hold more than 30 rounds. He himself thought those must have been fired at a different time. He learned that apparently you can get a 32 round clip, but a 30 is going to be much more common. He didn't even know a 32 existed. And when you think about the fact that, again, every single one of the 31 casings is a Max Tech, and the two in the safe are Federals, it's consistent with what Detective Ramos initially thought. These had to have been fired at a different time. Another reason that makes sense is, hypothetically, and I think you heard a theory that, the 9mm must have flown into the brass catcher at some point. That doesn't make a lot of sense. When you look at, for instance, 8C, and these are markings of where most of those casings are found, they're all up here by the entrance to home suites. I'll show you 8G, same thing, it's out at another angle. And when you compare this to the video, you see that the shooter with a 9mm, or with a handgun, presumably 9mm, is standing right about here. Maybe moves up a little bit. Nowhere near either one of the people with the other firearms. So, based on that alone, it makes no sense that firing the 9mm would have incidentally just shot two of the casings into the brass catcher in one of the rounds. But even if you think, well, maybe that happened, why on earth would someone get rid of all the other brass that's fired in Tampa and just leave these two there? Two that don't match anything else. It makes no sense. It makes no sense because it didn't happen. What does make sense is those two were fired, apparently from the same firearm, but a long time before, not connected to what happens in Tampa.
Look at the state stable.
And another thing that's not been explained is what happens when the people in the Uber get to Jacksonville. Well, Sean Gathright said that. I don't know, but we know people have gone into that house, and you see it on the video. Now, we talked a lot about evidence, about lack of evidence. No motive whatsoever for Mr. Gathright to want to shoot Charles Jones. And as Ms. Doherty said this morning, and is absolutely true, the state doesn't have to prove motive. It's not an element. But it's sure something you can consider. Because you're going to be asked to decide if he's the person he says he is in the context of this case. If he's one of the people who caused the death of Charles Jones. And that goes to identity. And motive is very much something you can consider, and you sure should consider, in deciding if Sean Gathright did the things the state says he did. He has no reason to want to shoot Charles Jones. You heard that this motivation for the shooting goes back to all these prior shootings between the two gangs. Remember, he's barely 18 when this happens. If you look back at the dates of this, I mean, he's a child when these other shootings were taking place. And he has no connection to it. It's not like, he's related to these people who were shot in the prior shootings, that, his parents were gang members in the past. There's no connection. It's like he drops in out of the blue one day and is literally in the middle of a gang war. He's not part of the drill rap scene. There's no evidence Charles Jones even knows who he is, let alone anybody else who's in that entourage. It makes no sense. The puzzle piece doesn't fit. And that's absolutely something that you can and should consider. What else is lacking in evidence? The guns, none of the guns are found that are used in the shooting. I mean, there's a stretch to suggest maybe that 5.56 over here was used. I think I've shown that it wasn't. 9mm, surely not. There's no connection to the 300. And there's nothing beyond literal speculation that the 5.56 was used in the shooting. None of the clothing is found that was used in the shooting. No DNA from anything at the scene. And that's despite the fact that the ATF, as you heard, has this procedure for testing DNA on casings. One thing I want to point out before I move on to some other topics briefly is that Mr. Gathright is charged with 3 counts of attempted first-degree murder, just like both of the Murphys are. And those counts correspond to an alleged attempted murder of Xavier Edwards, Gina Norris, and Camilla Bentley. It's an allegation that it's first-degree premeditated murder, which means whoever is allegedly committing the attempted first-degree murder has to intend to try to murder these people, not Charles Jones. Even if, hypothetically, whoever sets out to shoot Charles Jones, there's no evidence there's an intent to want to kill Xavier Edwards, Gina Norris, or Camilla Bentley. You haven't even heard from Xavier Edwards, by the way. But in any event, an incidental shooting, as occurred with these three unfortunate individuals, cannot be premeditated. If someone tries to shoot Charles Jones and a couple of other people are incidentally hit, that is a crime, but it's not first-degree premeditated murder because the people did not intend to shoot the three people who were shot. That's premeditation. You'll get instructions on what that is. We talked about it, and I'm not going to belabor the point because really, as it pertains to Mr. Gathright, it's neither here nor there because he's not one of the shooters. But in any event, keep that in mind. They're charged with attempted premeditated murder as to those three. One thing I added in my notepad when the Doherty was arguing is, in discussing the attempts, you talk about this being it was an eloquent argument, by the way, but the suggestion that this is so well planned out and these people are well trained. Take a look at the video. It is amazing those shooters did not shoot each other because you've got shooter number 2 under the tree. Right across from that, you have shooter number 3 in the car line as Charles Jones's car is driving between them, and they're both shooting back at each other. Meanwhile, shooter number 1 is presumably running back into the gunfire. To suggest that was some well planned out offense is kind of a wild theory. And again, it's kind of amazing none of the shooters shot themselves or shot each other. So, ladies and gentlemen, the evidence when you peel it back and look. Sean Gathright is a young man who got himself caught up in something in Tampa. Probably didn't realize the extent of it until afterwards. Something that made no sense for him to be connected to. There was no connection between him and all of this that's taking place here in Tampa. I'm going to take my seat in just a moment, and to echo something Mr. Gonzalez said again, whether Mr. Doherty, Ms. Ismer, or Mr. Harmon, one of them will be able to get up and give a rebuttal argument after we've all argued. I can't get back up. As you heard, those are the rules. Again, it's probably going on for another 5 weeks if we didn't make the attorney stops. But I want to leave you with a thought, and it goes back again to the reasonable doubt instruction. I want you to follow that instruction. Carefully consider, compare, and weigh all the evidence. Look at the context of the evidence you're being shown to suggest Sean Gathright had anything to do with these shootings. Compare it all and weigh it all. You will see Sean Gathright is a puzzle piece that doesn't fit in that puzzle. You might look at first glance, and again, I bet law enforcement, when they searched that house, they searched that car, they thought, man, we got that puzzle piece. But look at all the evidence. It doesn't fit. And it makes no sense that he would have involved himself in the shooting. It makes no sense because he's not guilty. He's not guilty of any of these charges, and certainly not guilty of tampering with any evidence. With that, ladies and gentlemen, I'll take my seat. Mr. Gathright, it's in your hands.
Thank you. Mr. Petredis, on behalf of Defendant Isaiah Chance, you may proceed.
Good afternoon. I know this
Oh,
is
yeah,
a lot.
rate his-
One after another, we just keep coming up here. But
Keep forgetting. Rate Jason Wise's closing on a scale of 1 to 10.
good afternoon. I know this is a lot. One after another, we just keep coming up here, but I appreciate your patience. Ladies and gentlemen, the beginning of this case, which was a while ago, the state came in and told us they're going to have a picture. They had a confident picture they were going to tell you about a conspiracy, a gang war, 3 killers, and a surveillance team, all coordinated, all disciplined, and that it pointed back, to, among others, to Isaiah Chance. You've seen everything the state has at this point, all the witnesses, all the evidence, all the exhibits. I'm going to ask you to ask yourself a question during my closing, during the state's closing, and when you're back in the room deliberating. Did the state prove, beyond a reasonable doubt, with actual evidence, not speculation, that Isaiah Chance knew murder was being planned, agreed to participate in it, and took some act in furtherance of that murder? Or do they want you to speculate your way to a guilty verdict? Because that's what the case comes down to. Not whether a murder occurred, because sadly one did, but what Isaiah Chance's involvement in that murder was, if any. On any one of those questions the state has given you, I would submit speculation, not evidence. The court has instructed you on the burden of proof. It is a very high burden. The state must prove every element of every charge, every fact that is necessary to prove those elements beyond a reasonable doubt. They must rule out everything, every reasonable doubt, and all those elements and all the facts necessary to prove that charge. That, again, Isaiah knew of a specific plan, potentially agreed to participate in the plan, and did some act in furtherance. You cannot stack inferences on top of inferences, speculations on top of speculations. They need to be rooted in actual evidence. I submit the state has not done that. Let's talk about some of the speculations and inferences the state wants you to go on. That the Spaces chat was not banter between two people, but had to be proof of murderous intent. That being in Tampa could only be purposeful participation in a murder plot. That Mr. Chance booked the Airbnb with specific advanced knowledge of the plan to kill Charles Jones. That Mr. Chance, not Alicia Andrews, was using her phone all night. That a single phone call that night from Mr. Chance could only have been passing murderous knowledge from one person to another. Could be for no other reason. They cannot rule out any other reason. That Mr. Chance knew what was in the bags being placed into the Impala. That Mr. Chance knew what the Impala was planning that night. That any photos posted after the homicide could only be celebration photos for no other reason. That Mr. Chance was driving the car that entire night, not possibly, probably, Miss Andrews. And this was all done in furtherance of a street gang, criminal gang, excuse me. 12 inferences. I would argue each of those inferences, any of those inferences standing alone is reasonable doubt, and they have all of those inferences. Let's start with the first. Did Isaiah Chance know a murder was planned? It starts with the Spaces chat. I'm not going to play the Spaces chat. You can play it to yourself. But you heard what Detective Drabeck said. He said it didn't sound angry. You have them going back and forth. Mr. Jones actually says, I don't believe the allegations against you. You have Mr. Chance say, how's your foot? The state says that's him goading him. Mr. Jones doesn't seem to take it that way. He says, my foot's good. And Mr. Jones is the one that says, you got bigger fish to fry. And Chance, kind of in a juvenile fashion, says, you got bigger fish to fry. And that's basically the chat. Not angry. Mr. Jones isn't taunting him. Mr. Jones isn't making fun of him. Isaiah Chance doesn't seem angry at anyone. But they tell you that has to be murderous intent. They also claim that Mr. Jones is Isaiah Chance's arch rival and mortal enemy. And I would ask you to look at one piece of evidence in this case that remotely proves any of that. This is all speculation by the Jacksonville Sheriff's Office that Isaiah Chance apparently hatred of Charles Jones. No proof of that. The only time we know them talking to each other is that Spaces chat, and I submit that doesn't remotely prove that. Then they talk about what Mr. Gathright and Rashad Murphy were talking about possibly that chat, but Sean Gathright or Rashad Murphy mentions Instagram as well, so they might not even be talking about that Spaces chat. And we have no idea if they ever talked to Isaiah Chance after their conversation with each other. Then we look at the Instagram post that happened prior to the murder by Mr. Chance. Again, Detective Drabeck initially says, Detective Ramos initially say, when we first saw him, we didn't think anything of them. It's only after they have Isaiah Chance as a suspect that they say, okay, now we look at him, now they're proof of intent for murder. That's not investigation, that's confirmation bias. Isaiah Chance was upset at something. He was upset at apparently the rumors that he was being called homosexual. That upset him. However, again, Mr. Jones said he didn't believe those rumors, and there was no indication from those Instagram posts from Mr. Chance prior to the murder that he was upset at Charles Jones. He was upset at someone. It is not clear who he was upset at. Again, there's no recorded conversation, no text, no call, no witness that says Isaiah Chance was mad at Charles Jones, and that would be required for him to have the intent to kill him. Even if you believe Isaiah Chance knew something was going to happen, and I submit you don't know that, again, you need to prove he specifically intended his death. The state also points to his anger about Antonio Tilley, but again has no proof that he blames Charles Jones for the death of Antonio Tilley. Antonio Tilley was allegedly involved, possibly, over a personal dispute involving a female, and the person who shot him was not in a gang. So again, it's a leap to get from that to specifically blaming Charles Jones as being behind Tilley's murder. Then we get to what did Isaiah Chance do as an act in furtherance of this alleged plan that he was involved in, that they can't prove that he ever made a deal to be involved in. The state says that he was in the cruise, he was on the surveillance team, that's what they call it, providing real-time surveillance information of Charles Jones. Let's go along the way. We do know that he drove to Teasers. That we know. That's on the video. You can see that yourself. However, the cruise leaves Teasers when Charles Jones is still inside. Then goes to multiple places around Hillsborough Avenue, 13th, 15th, I think 19th, I can't remember exactly. You have it all back there. Detective Ramos isn't exactly sure. He knows he goes to multiple places. Again, he follows up on Fizzle in Jacksonville very well and suggests they didn't really follow up on where Isaiah Chance and Alicia Andrews went on Hillsborough quite as well. Didn't get any video from there, didn't check up on that. However, we know he goes other places. He's not following Charles Jones at this point. And we also know the Impala then gets to Teasers the minute, or within a minute, of Charles Jones leaving. But the cruise is no longer there. How did the Impala know to get there? Couldn't have been from the cruise. And then we go to Truth. Now, at this point, we have no idea who's driving the cruise. From the point where they leave Teasers, we have no idea who's driving the cruise. They get to Truth. We have the photo from Alicia's phone, Alicia Andrews' phone, never sent to anyone. That's specifically from her phone, not Mr. Chance's phone. And we see later that the Impala is specifically, as the detective called it, staged across the street, watching what's going on. And we see when the entourage leaves, the Impala follows them. The cruise is not needed for any of that. Now, we go to the home 2 suites. This is on the way to the Airbnb, as Detective Ramos says. The cruise is following it. This is where the state will suggest that Alicia Andrews gives her location information, which brings the Impala to the home 2 suites. Except it doesn't work like that, because when you share your location, it's your actual location. And when you see the order of the cars, the cruise does not go into the home 2 suites until after the Impala goes to the home 2 suites. So if they were truly following the location, the Impala would not have went to the home 2 suites, because the cruise goes right in east on Fowler and comes back around west, then across the street into USF Embassy Suites. So if they were following the location, they would have followed them there. They didn't do that. They went directly, the Impala went directly into the home 2 suites. How do they know to go there? Were they getting information from a different source? Were they off camera and followed them? The state can't rule that out. Detective Ramos says the cruise was staged across the street, but there's no video evidence of that. That's just a speculation. We do not know how they found out to go into the home 2 suites. Again, the state, Detective Ramos says it must be these other apps. This must be this other apps. As Mr. Wise said, there's no evidence of that. And as Mr. Wise also said, they're going back and forth between apps that they know that can hide and apps that they can't. It doesn't make any sense. And again, must have is not evidence. It is definitely not beyond a reasonable doubt. And the Impala, having been staged across the street at Truth, would have seen where Mr. Jones got into the car. It wouldn't need any further information about where he was sitting. And at the home 2 suites, where the cruise does go in, there's no indication there was any communication between the 2 cars at that point. The state wants you to assume that they talked to each other without any proof. The state even says no one can be identified in this case. They were talking about the shooters, but it truly could mean anyone because they cannot identify who's driving that cruise outside of one time in the beginning of the night. They also can't prove who was using Miss Andrews' phone all night. They keep saying that every time they put a picture up of a conversation, it always had Alicia Andrews beside a picture of Isaiah Chance. But it was based on something coming from Miss Andrews' phone. Now, we know Miss Andrews used her phone a lot. We know, for instance, this is her texting about an Airbnb in Tampa. No suggestion from the state or Detective Ramos. This wasn't her, so they assume this is her using her phone. This is her on her phone. She looked up a picture of the victim, Charles Jones. Again, no indication from Detective Ramos, I don't believe that that's not her using her phone. It's her using her phone then, but later they want you to believe Isaiah Chance is using her phone despite having his own phone and using his own phone. Again, she tries to book the Airbnb. Here's the Airbnb, and if, again, above it, here's where tempted to book the Aloft, Tampa. I would submit that is the beginning of the word Midtown. Aloft being Midtown, being nowhere near Teasers or that area. The state said they were using Alicia Andrews to blend in, or Isaiah was using Alicia Andrews to blend in at Teasers and Truth. Speculation, no proof of that. There's plenty of single men, multiple men, and there's no indication that that was the reason for that she wasn't simply just involved. So the attorney says Sean Gathright and Alicia Andrews were using their phones, but then wants you to believe by that she means Isaiah Chance. But when Sean Gathwright's texts come in, they want you to assume it's from Sean Gathright. But when Alicia Andrews' texts come in, they want you to believe it's Isaiah Chance. I would argue it doesn't work that way. The state said they didn't want to use gang members. Except at the time, Rashad Murphy was not a gang member. He wasn't documented until after his homicide. So that doesn't make sense. And they said they wouldn't have let anyone else into this. Well, they allegedly let Alicia Andrews in. She's not in the gang. They let Sean Gathright in. They allegedly let Isaiah Chance in. They would be what the detectives called I think, creative players, so they're letting whoever they want in, I would argue. Now again, what did the state? They cannot rule out that Alicia Andrews wasn't driving the cruise at those locations. They cannot rule out that she wasn't using her phone all night. They cannot rule out the Impala didn't find Charles Jones on their own, either with someone from inside his own entourage. We know Kayla Enright was actually trying to get information and did. We know Mizzle associated with both sides and was not found at the crime scene where the murder occurred. And Charles Jones was posting his location on social media. They didn't need a surveillance team. He was telling them, much to the dismay of Robert Howard. Again, we talk back to the Airbnb. We know someone went in that wasn't caught on camera. The state can't rule out that was Isaiah Chance at the very beginning, and he wasn't hiding, he just didn't caught on camera. We know that happened. They want to convict Isaiah Chance on association, not evidence. And I want to talk about J. Breezy and Young and Ace very quickly. One of the things the detective used to show that Isaiah Chance was involved in this was getting paid from J. Breezy. So that transaction was a piece of evidence that they think connects Isaiah Chance to this. So J. Breezy pays him, then J. Breezy brags about paying for a murder in a song. And they then, not only does he brag about it, they have the actual payment, they say. Is he investigated, arrested, or indicted? No. Is that because they don't believe songs? Well, they have evidence in this case. Or is it because they don't believe the evidence says what they think it says? And we heard from Robert Howard and Mr. Gonzalez talk about him, so I'm not going to rehash him very much, but I will say that what he told us about Isaiah Chance is all his conversations were friendly. Talked about music. They talked about just Jacksonville in general, that he was never a threat. Like I said, always friendly. The one thing they talked about the flyer, he said Isaiah told him that was silly to post it and to be careful. But again, he also said that he never felt threatened and everything was friendly, so he took that in a friendly manner, which it was, because as Robert Howard later told you, he thought it was silly to post your location everywhere. This was information he knew. Mr. Howard said he was just probing Mr. Chance, trying to get information. He took a liking to him. And after the murder, there's no calls from Mr. Chance to Mr. Howard, no bragging, no nothing. Now let's talk a little bit about the gang enhancement. It's a burden I don't believe the state can meet. They must prove that ATK or 1200, depending on what gang they believe Mr. Chance was in at the time, is a criminal street gang under the law, and you'll get all the law back there. They must prove he was a member, and then he committed a criminal act in furtherance of that gang. In furtherance of that gang. All three, not just membership. Is ATK even a criminal street gang? Excuse me. Is their primary activity crimes? I would argue it's not. Are they working together? I would argue they don't. What Detective Nieder said they're independent contractors. I didn't use that word. He used that word. Independent contractors. That's not a gang. Again, what they're most commonly known for is music. Now, they're drill raps. They're making fun of people. They're doing music. The state says they're known for murder. They mentioned about 6 murders, 7 murders over 8 years. That is too many murders. Do not get me wrong. But I would argue that's not their primary activity.
Objection, Your Honor. May we approach?
Yes.
Majority of those murders, all the murders, for all these years, are unsolved. Cannot be, I would argue, remotely attributed to a gang or to a gang war, specifically to ATK. What crimes are committed for the benefit of the group? I would argue the detectives have not been able to show us any crimes for the benefit of the group. We talked about it in general. They say they do a crime, they then do a drill rap about it, and they make money off it. I would argue that is not for the benefit of the group. Again, if crimes were criminal, if these were songs were proof of criminal conduct, J. Breezy would at least be investigated. Again, they don't have structure, they don't have hierarchy. Now let's talk about the documentation of Isaiah Chance. The first one is the number 23 chain. Again, it's a very common number. Detective Nieder gets to decide that it means gang, and only gang. It only means Royale Smith. It cannot mean anything else. It cannot mean LeBron James. It cannot mean Michael Jordan. Has to mean gang. We know ATK members wear chains. You've seen an ATK member wear a chain on that screen at least once. Detective Nieder. Isaiah Chance has never worn an ATK chain. Then other criteria were from his social media. Multiple pictures, some used for multiple criteria, but there were a lot of pictures. But let's look at some of those pictures. Again, multiple detectives said, and witnesses, Isaiah Chance is a rapper. He's not a diss rapper. You make your decision yourself. To me, this looks like a photo shoot. And I think there's a couple things I'd like you to look at here. One is, what song is playing that they have here? Kenny Caps. Robert Howard, allegedly from the Ops. They're playing a song. And what's in the background? This gentleman, Isaiah Chance, allegedly ATK 1200. Gentleman, right above my finger. Again, look at it yourself. This is 126C. Given the alleged 1200 side down, which would mean disrespect to 1200, if that's what we're to believe that is in fact only the 1200 sign, despite the fact that Robert Howard says that sign is used by all people all over Jacksonville, not all people, but a lot of people all over Jacksonville for a lot of different reasons. And there are multiple pictures, so I'm only going to highlight two. And the only reason I highlight this one is Detective Nieder says he can tell that's Isaiah Chance. I don't know if that's Isaiah Chance or not, and I would argue that no one can tell you that that's Isaiah Chance, besides if that's Isaiah Chance himself. He used that to document him, one of his many reasons. He also said he can print out an Instagram post like that, and it's considered physical evidence in his mind. I would argue that is not accurate, and that is not what the law intends. But this has to be your decision. Now, when Dr. Leek was testifying, the state made a big deal to say that she didn't check if he had gang tattoos. One of, you're going to get this law back there, the ways to meet gang criteria is to have a gang tattoo. And you also saw, when Davion Murphy was arrested, they checked to see if he had gang tattoos. You heard from Detective Nieder, who documented Isaiah Chance, did not document as a gang tattoo. And you heard from the person who arrested him, Detective Ramos, nothing about a gang tattoo. He doesn't have a gang tattoo. The hand signs mean different things to different people, and I argue to suggest they mean only one thing. We heard it from Robert Howard. We see it in that picture. There's a post that you're going to get back there that Charles Jones does where he does the thumbs down emoji, allegedly against his own gang or associate gang or whatever they want to call it. Again, there's no evidence that Isaiah Chance did anything benefit himself through the gang. There's no evidence. They call him they say he's Mr. Rich Off War because he gets paid for this somehow. They haven't proved any of that. They simply haven't. Let's get back to the case itself. The forensic record. They have nothing they can use forensically, ballistically, against Isaiah Chance. No fingerprints, no DNA, no ballistics, no murder weapon recovered connected to him, no clothes matching the shooter's, no mask. In the Vivid video, this is what Officer DeJesus said, that he can look at these pictures, and not only can he tell you that that's a gun, but he can tell you, I believe he said, the kind of gun, and that it has an extended mag. Now, I'm not here to tell you that's not a gun. That's your decision. I'm telling you that Officer DeJesus is reaching when he says he can say that, and I think it's not unreasonable to suggest his testimony was reaching, because as Mr. Wise stated, he was a different witness on direct as he was cross. On direct, he answered every question. He was an expert. On cross, he wanted to fight with Mr. Wise, and all of a sudden couldn't agree. I don't know if he would agree the sky was blue. He also agreed on the theory that two of the bullets from the 9mm flew out of the 9mm and into the brass catcher. He said this was possible. This is after he stated that he couldn't think of one reason that anyone would use a brass catcher. He said two bullets flew into the brass catcher. That was possible from two people moving, despite the fact that for that to have happened, that the person who then unloaded the brass catcher would have to unload all the shells and put the two 9mm back, because that's how it was found. It doesn't make any sense. Then we talk about the DNA. There was some DNA, and the state would tell you Mr. Chance could not be excluded. But truly, he could not be included. We heard they use big numbers when they can, 700 billion, but they couldn't even give us a number, anything, on Mr. Chance. They could not produce a meaningful result. I submit it's FDLE's way in saying we cannot include him. And the state doesn't get the benefit of the doubt. They don't get to say, well, we couldn't exclude him either. They have to prove that he touched that gun. They cannot do that. Let's look at what the state chose not to investigate. Again, we know Mr. Chance is at some point in the cruise with Miss Andrews. We don't know who's driving, and we know that the LPR readers and other things are going off in the area of 15th and Hillsborough. We have no video from that area. They didn't try to get video. They didn't investigate that area. They went to the places they wanted to investigate. They didn't investigate the cruise's infotainment system, which would have shown GPS data, browsing history when they had the car. Ramos did not do that. Could have shown us a lot of what the cruise was doing that night. We don't have that. They didn't get Robert Howard's phone. Could have backed up or undercut his testimony. It's in federal custody. They gave an explanation for that, but Detective Ramos simply, I would argue, didn't follow up on that because he got the answer he wanted. The search of Mr. Chance's house produced nothing connected to this murder. The gun was excluded from being involved in this murder, and as Detective Ramos said, he even said, I don't know if that's a gun necessarily, but if it does, it looks similar to the one found. He was at least honest about that in Mr. Chance's house, the one that was excluded. I'd actually look at those pictures too. For Mr. Chance's house, there are bags in those pictures that I would submit look very similar to the bags that he was loading into the car at Mr. Gathright's house. Bags that have clothes in them in Mr. Chance's house. Mr. Chance's interview. Mr. Chance sat down for, I don't remember the exact time, around 2 hours with Detective Ramos. He told him he went to Tampa. He didn't lie about that. He told him he went with Sean Gathright. He told him he went with Alicia Andrews. He told him he went to McDonald's. He said he went to a colorful club. Detective Ramos says he's lying because he can't provide an alibi, and he doesn't know the name of this club. Again, he is not from Tampa. There is indication that he went to clubs all around 15th and Hillsborough. In fact, he doesn't know a name for a club, which he even said, Detective Ramos, I wasn't there, I didn't go in, talked to a bouncer and left, I would argue is not evidence of lying. And again, someone who participated in this murder, someone who went to Tampa for this purpose, doesn't sit down for 2 hours with a detective and tell him about it. The state told you they're going to provide a complete picture of Isaiah Chance's involvement in this case, and I would submit what they've presented is speculation, social media, and gang allegations. They talked about the Spaces chat, talked about social media. They want you to speculate on the meaning of all of those. They talked about the surveillance theory. They can't even put him driving the car or using the phone in that theory. It's a forensic record with zero. It's made of, this case is made of alternative explanations the state simply cannot rule out. Inferences stacked on top of each other, speculations. Isaiah Chance was in Tampa, and Charles Jones is dead, and that is a tragedy. But they still have not proved he knew about the plan, he agreed to the plan, he took an act in furtherance of that plan. Cannot build a conviction based on stacked inferences. The reasonable doubt standard exists primarily for a case, I would argue, like this, where the pressure is high to convict, and the crime is terrible, and the evidence against a specific defendant is built on inference and speculation. The standard does not bend because the crime is serious. It holds for that very reason. The state has not proven Isaiah Chance guilty of first-degree murder or conspiracy to commit first-degree murder. They have not proven the gang enhancement. What they have proven is he was in Tampa, and that is not enough. They want you to fill in the gaps from their case. What I told you they were going to ask you to do in opening, and I ask that you not do that here in closing. You hold them to their burden. And I believe the only verdict consistent with this evidence and consistent with the law is not guilty. Thank you very much.
Mr. Sinardi, on behalf of Defendant Davion Murphy, you may proceed. Yeah, that's fine. No worries. Okay, we'll take one more quick break, and then that'll be it until we're done. Okay?
All rise.
All rise. All dues are in, Judge.
Okay, very good. Okay, everyone have a seat, and Mr. Sinardi, you may proceed.
Good afternoon, ladies and gentlemen of the jury. I know it's been a strenuous past 5 weeks, and I'm thankful for you all bearing with us. On behalf of myself, Attorney Nick Sinardi, Ms. Deborah Toomey, Katie Rayner, and private investigator is not here, and more importantly, Davion Murphy, we want to thank you for filling your civil service duty as a juror these past few weeks. Now, as these 4 gentlemen sit here today, and as this court has already indicated, this is a joint trial, but what's even more important is that you are to judge Mr. Davion Murphy independently and individually, even though he sits here with these 3 other gentlemen. And the reason why I bring that to your attention is because as you sat here these past few weeks, you had viewed over hundreds of exhibits, and out of those hundreds of exhibits, only a select few will apply to Mr. Davion Murphy. We'll start with what we know, that on June 22nd, Davion Murphy traveled from Jacksonville to Tampa, and as you heard Detective Ramos testify, that was supported by the LPR readings from the Silver Chevy Cruze, as well as the CDR records. And we're not denying that Davion was in Tampa, Florida. And the state had presented numerous pieces of evidence. We're not denying those pieces of evidence. The facts are the facts, and the evidence is the evidence. I'm not going to stand here, I'm not going to present some elaborate story, and I'm not going to waste your time. Again, this is just a showing of the LPR hits from Jacksonville to Tampa, which tracked the Chevy Cruze, which was ultimately linked to Davion Murphy. Eventually, Davion Murphy did get to Tampa, and again, you heard from Detective Ramos that his cell phone pinged at the Airbnb prior to the shooting and the homicide. Pinged thereafter, he was at the Airbnb. Again, surveillance at the McDonald's at 1:36 in the morning. He was surveilled on the McDonald's surveillance. He was there. CDR records and the phone data support that. At 1:54 in the morning on June 23rd, what we saw on the CDR records was an outgoing call to Rashad Murphy's cell phone, that number ending in 0925. Now, you had heard from Detective Ramos that he had testified that Rashad Murphy had left his phone in Jacksonville with his fiancee and the mother of his children, Charmaine Steiger. Rashad Murphy didn't come to Tampa with his cell phone. He didn't have a cell phone. Why is this important? Because, you also heard Detective Ramos testify, there was no relationship between Davion Murphy and Charmaine Steiger. There wouldn't be a reason for Davion to call Charmaine Steiger. Based on that, would lead you to conclude that Rashad Murphy had called Charmaine Steiger at 1:54 in the morning on June 23rd for a 26-minute phone call. At 5:03 in the morning, there's an incoming call again from that same number linked to Rashad Murphy and Charmaine Steiger. Again, at the Airbnb, similar to the last call. That was for 7 minutes. Why is that call important? Because at the same time, during the same minutes, between 4:56 and about 5 o'clock, there's a photo saved of Bill Belichick linked to Davion Murphy's iCloud account. Davion Murphy wasn't using his phone at that time. It was Rashad using his phone to call Charmaine back in Jacksonville. You heard Detective Ramos testify. There's no social media obtained of Davion Murphy. There's no text messages linking Davion Murphy to any of these defendants. There's no communications even on any of the other defendants' Apple iCloud dumps or extractions with communications between Davion Murphy, Isaiah Chance, Alicia Andrews, and Sean Gathright. We saw the Bill Belichick photo was favorited, but that was favorited by Rashad Murphy. Even more importantly, on June 23rd, that same photo that was saved on Davion Murphy's iCloud was posted on Ghost 187's Instagram. Again, Davion Murphy didn't have social media. Rashad Murphy had an Instagram, and that Instagram, Ghost 187, was linked to Rashad Murphy.
I think they should have been severed.
Again, this is just showing you the CDR
Real bad.
records. You heard Detective Ramos testify that CDR records aren't always going to be accurate. There's going to be bits and pieces of gaps missing. It's not going to track continuously over time. Same thing with timing advance. There's going to be bits and pieces of information missing. It's not continuous tracking of information. But nonetheless, he was active in Tampa, and he was present at the Airbnb. This is seen on June 23rd, right before Davion Murphy left in the Chevy Cruze, heading back to Jacksonville. he's seen on the Ring camera footage. The state made a big deal about this because they said that's the only time he's ever seen on the Ring camera footage. Well, we heard from Detective Ramos and others that Rashad Murphy was present at the Airbnb and he was never seen on the Ring camera at all. It was his own testimony that he was there. In fact, Ramos even testified that there was someone inside the Airbnb already when Alicia Andrews arrived, and they weren't able to conclude who that person was. I submit to you that simply being seen once is not indicative of some consciousness of guilt to attempt to conceal or hide oneself. Again, this is a mapping of the Chevy Cruze that Davion Murphy was in by himself, heading back to Jacksonville. At no point, from the time that he leaves Jacksonville, to the time that he's heading to Tampa, to the time that he leaves Tampa, heads back to Jacksonville, or rather while he was in Tampa, do we ever see Davion Murphy in the Impala? Never. And why? That wasn't his family's car. It wasn't his cousin's car. He had no ties to that Impala. Just like he doesn't have any ties to Sean Gathright, Isaiah Chance, or Alicia Andrews. The only thing linking Davion Murphy to this is his cousin Rashad Murphy, who he came down here with on the weekend of the 22nd. Now, what hasn't really been indicated in detail, clearly, but I'll get to it in a second, is that during the interrogation, we see Davion Murphy imitating holding a firearm. What's important about that is that Mr. Davion Murphy is left-handed. And so when you see him writing and signing the Miranda form, he's signing with his left hand. When he's holding and mimicking that imaginary firearm, he's discharging it with his left hand. The shooter, clipped from the Tesla video, is right-handed. Shooter number 3, who they believe is Davion Murphy. He's shooting with his right hand. The state may make an argument that there's no way that a person could shoot with the left hand with an assault rifle based on the testimony from DeJesus, because the cartridges would come out and hit you. The shooter didn't have to worry about that. There was brass catchers on that firearm. No casings would have hit a shooter holding it with the left hand on the trigger. Davion Murphy is only seen in the Chevy Cruze. His phone doesn't ever show him leaving the Airbnb during the time of the shooting. He's never seen with any weapons. There's no DNA evidence linking Davion Murphy to any firearms, to any crime scene, nothing. There's no text messages between Davion Murphy or any of the other defendants of some form of an agreement to come down to Tampa and kill Julio Foolio, Charles Jones. There's no agreement to hide any firearms. There's nothing. More importantly, you've heard testimony from several gang experts that they don't even know who Davion Murphy is. They didn't have no clue who he was before this investigation. Now, as you've heard from every other defense attorney already, the state gets the last word. And so this will be the only opportunity that I get to speak to you. And what I anticipate the state's going to make a big deal out of is the interview with Davion Murphy. And how it took them almost 7 months for him to get captured. He didn't leave Jacksonville. He was picked up right in Jacksonville. The same place he went to when he left Tampa, he was picked up right in Jacksonville. He wasn't hiding, but ladies and gentlemen of the jury, when you were first voir dired, you were asked, have you seen this case on the news? Have you seen this case on the TV? Are you familiar with it? This is a high media case. I would submit that Mr. Murphy was familiar with this case due to the high media, and that he wasn't intentionally hiding, but he was in the heart of Jacksonville with his friends and family, and he knew what would happen if he got picked up, and that would be a long process. You've heard that this case occurred, this homicide occurred in 2024. We are in now 2026, 2 years later nearly. I would submit that based on the evidence presented, it's not sufficient enough to prove beyond to the exclusion of every reasonable doubt that Davion Murphy is guilty of homicide, first-degree murder of Charles Jones, Julio Foolio, attempted murder, and conspiracy to commit first-degree murder. Thank you.
All right, so we're going to get to the state's rebuttal, but that took me by surprise. What do you guys think? That took me by surprise. I think his case should have been severed. There were multiple requests for severance denied. We even heard Sinardi Sr. ask again to renew his motion for a mistrial because of the denial of severance earlier this morning when the day started, and it was denied. And now in closing, you get this strong, I did not expect that, a strong, like, pointing at Rashad Murphy. And it wasn't me. I'm not right-handed, and I don't know. I think that's a big issue. I think maybe they could have granted the motion to sever one of the Murphys from this trial and tried 3 at a time, and maybe Davion Murphy separately. let's get into, let's see who's doing rebuttal.
Very good. Rebuttal.
Yes, Your Honor.
Yes, going to be Alicia. Not Scott. Oh, I was actually impressed, and I think he's
Close out
like
Mr.
newer.
Sinardi's, demonstrative. Yes, we will.
We're going to put a poll on the screen. And it's just for the defense. We'll do one for the state after the rebuttal. And it's not who has the best factual case, but who delivered the best closing. Let me get all the names down. I'll put them in order as they went. So,
You have heard a lot of evidence, and we're going to go one by one because this is rebuttal.
it's Michelle.
And the first defense attorney we heard was Mr. Gonzalez representing Rashad Murphy. Talked a lot about the phone and what was on his phone. And he made a lot of comments about those messages that are sent from the phone that Rashad Murphy, his client, shares with Charmaine Steiger. There are a couple of messages about those burner phones and who they're supposed to go to. And those are not the messages themselves, those are screenshots. And that is the very limited activity that is on that phone that he uses, that he has been seen in possession with, that he had at the Walmart. And we know that that phone stays in Jacksonville. Rashad Murphy did not stay in Jacksonville. In fact, he lies about the phone. He specifically tells the detectives that he didn't bring his phone with him. In fact, when he says he needs to use a call in his story, one of many that he gave law enforcement, he says that he has to use Darius Beal's phone because he left his phone in Tampa. So those messages that they are putting out in front of you to suggest that he's really in Jacksonville when this homicide is committed is absolutely not any evidence that that is where he is, because when he is confronted with the evidence after he has denied and denied and denied being in Tampa, it is not until he is confronted with the video from Sean Gathright's house. That is when he finally admits, after those detectives get out, those Jacksonville detectives get up and leave the room, when he finally admits exactly where he has been. And even then, it is story after story, because you know that Darius Beals was not ever in Tampa, not on June 22nd, not on June 23rd. And we heard a lot about this 2 phones. One phone was not in use. So Rashad Murphy definitely wasn't using that phone when he lies to law enforcement to suggest he's with Darius Beals, and Darius Beals drove him from Jacksonville to Tampa. Darius Beals was not around to be interviewed, but they did research and look into the information on that phone. And what is clear is they were also not just looking at the cell site location and where the phone actually was, which never came to Tampa, not on the 22nd, not on the 23rd. Darius Beals, that phone was never utilized by this defendant in Tampa. And we know that it is Darius Beals' phone because they looked into who is the actual possessor of a phone. Because anybody can use anyone's device, but phones are very personal to a person. It has information on there regarding your calendar, regarding all your contacts, everything that you look up on social media. Phones stay with the person. And so the detectives delved into Darius Beals' phone and saw over 30 unlocks on his phone, including on the 22nd and on the 23rd. and it is by facial recognition. And now you've heard, oh yes, there may be more than one person that has a facial recognition on a particular phone. The problem with that is there are multitudes of photos on that phone, and they are trying to see who is actually using the phone. And on June 23rd at midnight, there is a selfie. Jarius Beals isn't in Tampa when these homicides are being committed. He is unlocking his phone and he is taking photographs of himself. Lots of people take selfies. And the selfies that they found during the time when this homicide is occurring is of Jarius Beals. And it should come as no surprise. That is because it is his phone. It shows where he is. They did the location data. It shows that he is in the vicinity of his home, where he is taking photos of himself occasionally during that time period. It is another lie because they are confronted with evidence. And you heard about consciousness of guilt. Consciousness of guilt is when you are lying to law enforcement or go to great efforts to avoid prosecution because you know you are guilty of the crime that you have committed. That is what consciousness of guilt evidence is. And that is why you have heard about the efforts of law enforcement to bring to justice all four of these defendants and the great efforts that they have gone to avoid prosecution, avoid being caught for killing Charles Jones. And it starts with Sean Gathright getting rid of the murder vehicle, the vehicle where 3 assailants were. He doesn't take that car back to Jacksonville. He hides it in Polk County, the last place that anybody would be looking for that vehicle. We don't find the black Chevy Impala in Jacksonville in his driveway where it was when they were loading up all the firearms in his car from his house. We don't find that in Jacksonville. It certainly isn't in Tampa because after they committed the crime, they left. We don't find the silver Chevy Cruze in Jacksonville either because after Rashad Murphy gets back to Jacksonville in the Uber with his co-defendants Isaiah Chance and Alicia Andrews, and Davion Murphy has driven the silver Chevy Cruze back in Jacksonville, they don't just take this vehicle they used in a murder to Jasmine Glennon, the mother of their brother's child. They remove the silver Chevy Cruze out of the state because they all know those are the 2 very vehicles that they drove all night tracking the victim. That is consciousness of guilt. He doesn't live in Georgia. And Sean Gathright didn't live on Opal Ave in Polk County. But that is where they are taking the very vehicles that they used to commit this homicide. Mr. Gonzalez showed you this to the 101 L2. Showed you this photograph, evidence of proof of the phone, and that message, which we both know was not sent by him, Rashad Murphy, in Jacksonville. Tries to look at what the shoes are, that it came from the phone. We know that this is what was bought in Walmart the day before. Talks about all the weaknesses of the case, what he's wearing. Anybody could be dressed in black. Anybody can be wearing combat boots. Anybody can be wearing a ski-type mask or hoodie or hat on your head. Never once mentions this Walmart trip where he is getting ready to commit a first-degree homicide that you can clearly see the handle of a firearm. He's going to take that to the prison to smuggle in phones? He's not getting ready to smuggle phones. All of you know what the evidence in this case shows. He is getting ready to commit a first-degree premeditated murder. The Airbnb. Does it matter if he is the one that booked it himself or that he gave his ID to his co-defendant, Isaiah Chance, to book it for all of them? What is clear, whether or not he tries to say or distance himself by saying to law enforcement, he doesn't want no part of Tampa. He never would have done it if it was in Tampa. Well, ask yourselves this. Why does it matter that the Airbnb is in Tampa as opposed to any other city that Isaiah Chance had to go visit? There's only one reason why he can't be associated to an Airbnb in Tampa, and that is because this Airbnb is in Tampa the very weekend that Charles Jones is murdered. There is no explanation why that even matters. The only reason it matters is because Charles Jones is killed here and he is being questioned specifically in relation to that murder. There was a lot of talk about Robert Howard. You should scrutinize everything that Robert Howard said. And you'll notice in our first close, when we went over the mountain of evidence in this case that absolutely proves each and every player, each and every defendant in this case, there was no mention of Robert Howard. This case has been proven over and over and over again, with each piece of item being more compelling and making this case stronger than it is based on what you see with your own eyes. Mr. Gonzalez talked about circumstantial and direct evidence. Both of those are types of evidence that you can utilize. This isn't just a circumstantial case. There is direct evidence in this case. Direct evidence is stuff that you hear from eyewitnesses, eyewitness testimony that was there. We have talked about that silent witness, and you know exactly how this crime was committed. They are asking you to disregard what you can see with your own eyes and look at a small part of our evidence and look at it and ignore every other item of evidence that we have presented to you. Detective Ramos never said that he could not have evidence of Rashad Murphy being in Tampa when this homicide was committed. When the question was asked 5 different ways to where he was pinned in, to ignore all of the other evidence, all of the other factors, and just look at the video. I'm asking you, just looking at the video, is there any evidence in the video where my client can be seen? The honest answer to that is no. He's never on the room video, right? All of the masked men have their faces covered, so his face is not identifiable. So if you want to ignore every other piece of evidence in this case and rely just on the video, then that is the only time Detective Ramos, when he made the attorney ask him that specific question, was willing to say, no, there is no video that you can see the face of Rashad Murphy. But every other question when he was asked, is there evidence that my client is in Tampa the weekend when Charles Jones was murdered, that detective said yes, because there is a mountain of evidence that proves that he was there. And his name is Ghost. And these Jacksonville gang
Shout out to Ghost in the chat.
they know that he is Ghost. That's how everybody refers to him, as Ghost. Everybody knows Charles Jones is Julio Foolio. Everybody knows Charles Jones is 6. And everybody in Jacksonville knows that he's Ghost. But you don't have to rely on Detective Nieder for that. You don't have to rely on any of the detectives from Jacksonville. You don't have to rely on the investigative work that Detective Ramos did when he tracked down Google Pay that requires a name and a financial institution that is associated with Ghost 187. We can rely on Sean Gathright that this is Ghost. You don't have to rely on one Jacksonville gang detective for that information, because when we got Sean Gathright's phone, he has the phone that he uses with Charmaine Steiger saved in his phone.
What is Cisco doing?
His trusted co-defendant.
Look at Cisco.
Steiger. He has the phone that he uses with Charmaine Steiger saved in his phone, his trusted co-defendant, the person he works with. He calls him Ghost. He knows he's Ghost too. Phone number so important to Sean Gathright that when he got rid of his phone and tried to erase all of the information on that phone from the weekend when they murdered Charles Jones, Julio Foolio, that he then, when he is setting up his new phone, not realizing what was backed up on his iCloud, that he has specifically written down two people's names. GH, that phone number, 904-386-0925, is the very phone that was in his possession in the silver Chevy Cruze when he is arrested in Gwinnett County in one of the suspect vehicles. And guess what? Not only was he saved in his old phone when he's committing the crime as Ghost, he is now going to reprogram it into his new phone.
There's a lot of
and
numbers.
he's designated it GH. It's not RM, Rashad Murphy, it's GH, the first two letters of Ghost. Going back to Robert Howard. Robert Howard testified in this case 100% after he had pled and was facing prison. Not willing to talk to law enforcement before then, gave a brief statement to the detectives. That is not something they do. Nobody in this gang war is going to law enforcement for any kind of justice. They are looking for justice on the streets. And then when he gets popped for a drug offense and is facing sentencing, he comes for the first time to the state. The state has promised him nothing. He is not needed to prove this case, but he is the only person other than the gang experts that can give us any eye into this world. And one of the things that he tells us about is a posting that Charles Jones does when he is on social media. And you know what Charles Jones does, and they are trying to say that none of these defendants care about these deaths that 6 Block has taken credit for. None of them care that Charles Jones has drill rap music that makes fun of their friends, their gang members, the people they call family, that he has made drill rap music videos that denigrate them, that insult them, that make fun of their deaths. You saw that when I See You. He is at a gravesite of the 3 people that were killed in the town center in Jacksonville. Robert Howard was able to tell us that this photograph that Charles Jones posted, again, to incite people, to inflame people, to add to his drill rap clicks, and to make it more controversial, that is Charles Jones, Julio Foolio, photographing himself and others of 6 Block at 23's gravesite. That is where that original post came from. It is then shared by Isaiah Chance in a very different light. 23 is someone who he cares about. 23 is the necklace that you have seen that shows that he is a part of this gang war. He has posted this photo that was on Charles Jones' Instagram story, disrespecting 23, where they're all at his gravesite, disrespecting his death. And he said he reposted this picture to his public Instagram, the biggest mistake anyone on earth could do. He doesn't care about what Charles Jones has done. He's not angry at Charles Jones. Again, you decide who is credible, who is not credible. We don't need Robert Howard to prove this case. This case has been proven over and over and over again. But Robert Howard could provide law enforcement with rare insight that they could not get other means by giving them intelligence into some of the meaning behind some of these postings. We're going to talk about Rashad Murphy's statement one last time. A statement that a defendant makes is only admissible against himself. It is not trustworthy with anybody else because the reasoning is that if they are going to make some kind of implication or incriminating statement, it would only be true if they were truly making it about themselves. Because we expect people who commit crimes to point fingers. And so in the rare moments when they tell the truth about one single fact, it can help prove a case. And so nobody identified Rashad Murphy in any of those videos because their faces cannot be seen. But certainly Rashad Murphy identifies himself. And when confronted with the evidence, he had no other choice to then finally admit that he was in Tampa. So yes, we have the right person. He still lies and tries to maintain that he wasn't in Tampa until after the homicide. But it literally makes no sense, because at some point, I believe Mr. Gonzalez pointed out that he would not absolutely ever agree to an Airbnb in Tampa, yet miraculously the next day, he's got to go to Tampa to check it out. And what is more preposterous about his story, because again, he is caught. He can't admit to what he has done. But what is most preposterous about this story is having no idea where the Airbnb is, having no idea where the address of the Airbnb is, that he magically shows up in Tampa at the address of that Airbnb, because we know he gets into the Uber, and that he doesn't ring the Ring doorbell like any other normal person checking out an Airbnb for the first time. They are trying to normalize going at a Airbnb, a place that you are vacationing or staying in temporarily, and going to a side parking lot of a place that you normally don't know, and trudging through a dirt path to a wooden privacy fence to go through a sliding glass door. It is beyond belief. It is another lie, because they have been caught. So identification of Rashad Murphy as one of the people in Tampa comes from his own mouth. Let's talk about Sean Gathright. I don't know what world it is where you try to say that the evidence from the Toyota 4Runner that he is riding in Jacksonville is not a treasure trove of evidence. Really, nothing relevant from the Toyota 4Runner, a shell casing that matches the murder of the homicide victim is not a piece of evidence relevant to the Tampa homicide. That's not direct evidence of motive. They tried to kill him in October of 2023, was not successful, and evidence is found in their car. What more relevant tie directly linking Sean Gathright to this homicide do we need? So let's now go to his house, because not only does he have the misfortune of being directly tied to the first threat on the deceased victim's life, there's more evidence in his house, in a locked safe. There are 2 shell casings that are fired by the same handgun that is fired into that Dodge Charger here in Tampa. What horrible luck for Mr. Gathright. There's more evidence. Let's go back to the Toyota 4Runner. All of that ammunition, because he still has ammo, he didn't save the boxes of all the rounds and rounds and rounds that were fired in Tampa, and he's got more of it. That somehow suggests that he's not involved in this case. MaxTech is a common brand, but there are dozens and dozens of different type of ammunition that can be fired in a 9mm. And he just happens to have the exact brand in his truck of all the shell casings, all 31 that were left here at our homicide scene. There is link after link after link of Sean Gathright to this case. Suspect vehicle, Sean Gathright. Other suspect vehicle, Rashad Murphy. We know who was in there. And let's get one thing clear. I don't call Isaiah Chance Mr. Rich on War. He gave himself that moniker. I'm just telling you what the evidence in this case shows. And he chose Mr. Rich on War for a cash app where you receive and send money. That is his choice. That was his decision. And it clearly is his cash app, because Gonzalez is his rapper name. And you saw all of those different names that he decided to use. And he, before this homicide, decides that he is going to go as Mr. Rich off War. And we know that he gets payments from other people that are in gangs. This is a very real gang war. Was Rashad Murphy a gang member? You heard all of the evidence regarding Rashad Murphy from Detective Griffin. You saw a lot of videos. You saw videos where there are all kinds of drill raps. There were 3 of them. Is it a crime to hang out with your childhood friend, Noah Williams? It's not. But we know he's been stopped twice in a vehicle with him. And we know he's been in 3 different videos. And these aren't just rap videos. These are drill rap videos that you saw for yourself. You saw what type of music it was, that they were flashing signs. They also were flashing 6. We know who 6 is. And whether it's down or up, it certainly seems to be very disrespectful and very violent to be shooting what appears to be a gun towards it. He is very much a gang member and met multiple different criteria. And most importantly, per statute, per law, not because he's casually hanging out with family or childhood friends, because he is committing a first-degree premeditated murder of the head of their rival gang with other members of the gang. And right after this, their gang members are posting videos, Foolio dead, game over. You heard it's for clicks and likes and money. It is monetized. The more likes, the more profane, the more shocking, the more likes, the more clicks, the more money. That isn't a benefit. Davion Murphy, let's again talk about consciousness of guilt. There was a lot of media on this case. He absolutely was hiding. And again, 7 months. He was the longest. He was able to hide for 7 months. They can try to characterize it any way they want, but you got to hear it for yourself because he said it multiple times. I'm hiding in plain sight. He's hiding everywhere. Airbnbs. He used some colorful language, what he's doing, how he's hiding, how he's frequenting women, but he clearly is hiding from law enforcement. So again, what we're talking about is evading prosecution, evading justice for the crime that you have committed. And he was friendly with those Jacksonville gang detectives, told them outright he was hiding from them, making them do their job, right? He absolutely was hiding from law enforcement. He's not staying with his family. Those are the first places that they went to. And you heard them questioning him about it because they were looking for him and he knew it. Let's talk about what he finally had to admit to. He had to admit that he was in Tampa because guess what? He also is on the ring video. So when confronted 7 months later, do you think he might have had contact with his cousin, his family, Rashad Murphy? Any big coincidence that they're using the same type of alibi? And I know that they put up the photograph to show, I guess, to try to suggest that Davion Murphy isn't in Tampa, even though his phone is, because the phone is calling Rashad Murphy, Charmaine Steiger's phone, because it's in Jacksonville. And I actually do agree with the defense attorney on this, that most likely in both of those instances, Rashad Murphy is calling home to check on Charmaine Steiger both of those times. And he's able to use his cousin's phone, Davion Murphy, because they're in Florida together. So that explains all of the back and forth, the calls, because they can't refute that Davion Murphy's phone is in here in Tampa when the homicides are being committed, when the attempted homicides are being committed. He's just not the one using it to call Charmaine. He's letting his cousin call home because his cousin was smart enough to leave his phone in Jacksonville. And when we talk about him not using his phone during the murder, in this day and age, and all the attention that cell phones have been getting in the news, GPS tracking, geofence, you better believe they know their phones can be tracked. That is why they're using a girlfriend, a person who is not known to be in a gang, and why some of them think that just by turning it off, that will erase all of the evidence, or by throwing the phone away, not realizing that there are backups. It also, can we show the photo of Bill Belichick that was found at what time? I think it was 4:56. So this was posted to Rashad Murphy's Instagram account. 6:23, 8:10 in the morning, pretty early since we know what they were doing all night. But they're actually, before it's posted, it is saved because, again, Rashad Murphy does not have his phone. He does not have Darius Beal's phone. This exact photograph is searched on Davion Murphy's phone. 4:56 a.m. 4:56 a.m. Remember the USF body cam? The shooting had just happened. Armani Turner, Robert Howard, and Miss Randolph fleeing for their lives, desperate to get to USF. USF is close. USF is across the street from Home to Suites. And there is a traffic stop in USF's jurisdiction. And they immediately go to her and Officer Fusco, USF, and they immediately bring them all back. Remember the timing of that? They are searching this celebration post before media is there, as TPD and first responders are responding. How do they know that they're going to need Bill Belichick and Tom Brady, the GOAT, that they have taken out 6th block? How do they know that they're going to need that at 4:56? And again, I agree, Davion Murphy is not doing that. It's Rashad Murphy using his phone because he's getting ready to post to his ghost Instagram Bill Belichick and laughing emojis. I want to talk about this argument about Sean Gathright and the cell phone towers hitting. I'm trying to find, I wrote it down, the exact time where you see a tower utilizing that is pointing at the direction of the Airbnb. Is that 4:39? 4:39. There are multiple hits going off around the murder scene at that time. And you heard from Detective Ramos explain to you that not always the closest tower is being utilized. There could be a variety of reasons why a certain tower is being utilized. USF is on that property. And there is towers there, and there are towers on the other side of USF. And you heard that sometimes it can be a building that is blocking it. It can be based on usage. If there's over usage of a tower, another tower may take over, which absolutely can explain an anomaly that occurs a little bit more north of where the homicide scene has happened. But what happens is it immediately pings right back. There is another hit at 4:39 that is at the homicide scene. And then there are many others that show that that phone is exactly where we believe it is. And that is at the scene of the homicide when this occurs. There are all kinds of hits that are occurring on his phone. And you know that he is moving, the car is moving. They're getting out of the vehicle and moving. But what is clear is the majority of hits at that time are at the Home to Suites. We go to the social media post of Isaiah Chance. So this photograph that they put up there, and that was one of the documentations of his gang activities where he clearly is throwing up 1,200 signs, but his face appears to be covered. Let's not forget that there was a search warrant done at Isaiah Chance's residence, and in the car during the execution of that search warrant is the very jacket that he's wearing in this photograph where he's throwing up 1,200. And there were things of significance that were found at Isaiah Chance's house. There was also a bully down sign that was relevant and shows, again, he hates 6th Block and the subset bully gang so much that he has made a homemade poster, or maybe even gifted with it. I don't know. I don't have to approve how he got it, who made it. I just know it's further evidence that he does not like bully gang. You heard from Jacksonville experts that this is a sign of disrespect, to either do a sign upside down or specifically for bully gang. This is what they do. They don't call them bully gang, they call them bully down. And he has put it in a prized spot over the fireplace, or I'm sorry, over the window in his house, because he does not like 6 Block and the subset bully gang.
Wait, why did she say fireplace? And then say window? Because she was clearly trying to make a point that he intentionally put it somewhere. As if where he placed it was relevant. Was she looking at the picture of the right and thought it was a fireplace and was going to say, like, burn him down? And then because this picture's also here and it's clearly not a fireplace, she had to... What just happened? What just happened?
And let's talk about Isaiah Chance, because you already have heard, again, statements can only be used against the person that has made it. So Rashad Murphy has identified himself as being in Tampa, reluctantly to law enforcement and not completely truthful. Davion Murphy has admitted he is in Tampa because they are confronted with the evidence, photographic evidence that you all got to see as well, photographic evidence that they could no longer deny, but still not telling the truth. Isaiah Chance is also interviewed by law enforcement. And I think the characterization was that he was cooperative. The interview was 2 hours. He continued, although he said he was in Tampa, would not be able to specifically tell the detective where he was at. McDonald's, at some bar. They didn't go in because he talked to the bouncer. We know the 2 clubs that he was at, and there is no video evidence of him ever approaching a bouncer. But again, so we want to talk about identification. He has identified himself as being in Tampa, identified himself as being at the McDonald's. Guess what? That means he's in the silver Chevy Cruze. We have identified him as being in one of those suspect vehicles before they go to hunt and track him down. Some kind of argument from Mr. Gathright's attorney. Why is it, or some that he, I guess, suggested it's evidence that he is somehow not trying to track Charles Jones down because he's looking for the Airbnb. Why would he do that if he already knows where he's going to be at teasers when he appears? Could it possibly be because they want to kill him sooner? Could it possibly be that they want to kill him in a less public place than a full parking lot of a club where Charles Jones is going to be appearing, so there'll be less witnesses? What clearly that evidence shows all of you is how serious they were about finding him. And this is a concerted effort. It is not just Sean Gathright looking at, you saw that video, what was it, 8 minutes long of him looking for every waterfront pool, Airbnb in Tampa, Airbnb close to teasers. He's posting, Julio Foolio's posting, I'm at an Airbnb. Gathright's desperate to find him. He's not the only one looking for him. Rashad Murphy is on Instagram messaging, I really need to find this Airbnb. Not the only one. Mizzle is posting with Mr. Six, with Charles Jones. Who's looking up Mizzle? Isaiah Chance. The evidence in this case is overwhelming. And all of the defendants have been identified. All of them. And what the evidence shows you, what you got to see with your own eyes, is that 2 cars that came to Jacksonville for one night, for one purpose, tracking and stalking Charles Jones and his friends. They did it not at 1 club, they did it at 2 clubs, and then they followed him. And it is the silver Chevy Cruze that follows this car. Let's not forget about the USF pole cam. It is clearly the silver Chevy Cruze that is behind the victim and his friends when they pull off into the hotel. The black Chevy Impala is not even in sight. You cannot see the headlights when that turn happens. And there is nobody who knew other than the silver Chevy Cruze from their side of where Charles Jones and his friends were trying to get a room. Every place the silver Chevy Cruze went first, the black Chevy Impala followed. And then when they knew where the victim was, the black Chevy Impala avoided the line of sight. And one thing that Robert Howard said that you can believe or disbelieve, if he had seen if he had seen Isaiah Chance, if he had seen Rashad or Davion Murphy, he would have been scared. He would have got his weapon. They were armed too. And when I say this was well executed, well coordinated, it was an ambush. None of those victims knew what hit them. They didn't expect what was going to happen to them. All of the defendants have been proven beyond and to the exclusion of all reasonable doubt. They should be held responsible. They have been proven guilty of the only type of homicide that occurred. What separates a first-degree murder from a second-degree murder is premeditation. There can be no more premeditated murder than a hit that was organized in another city where they armed themselves, where they made arrangements for a second vehicle to stalk the victim, where they got masks, where they got enough ammunition to get the job done. This is first-degree premeditated murder. This is attempted murder for all of the people that they fired at and shot at, hoping to kill. Hold them responsible for each and everything that they did. And that means they're guilty as charged of every count, the top count that we have charged them with. Thank you for your time.
All right, members of the jury, that's it for today. So just remember my previous.
Just to get out of here.
Admonition on the overnight recess. Don't talk to anybody about anything related to this case. Don't read, watch, listen to any news accounts, or do any independent investigation. Tomorrow morning, you will return at 9 a.m. And I will give you the final instructions on the law. And once I read the law to you, and you all will then begin your deliberations. Okay? So just bring with you an overnight bag. Doesn't have to be anything too complicated, but just whatever you might need, and bring it with you. We'll keep it in the jury room. Okay? All right. Yes. We have a.
Well, hold on. Let's turn that up because I'm nosy. Let's boost the volume.
Anything too complicated, but just whatever you might need, and bring it with you. We'll keep it in the jury room. Okay? All right. Yes. We have a. Bring any and all medicines you need. Bring your medicine with you. I don't know that anyone's going to be checking your medication. It's not, the deputies are not like the TSA. So, I think more than anything, if you do get sequestered, they're going to be looking more for things like if you bring a book, is it something that might be related to this case? But bring whatever you need to be comfortable overnight. All right? You're good. Okay, very good.
Well then. I'm just having flashbacks to when the attorney was arrested during the YSL trial because he had a prescription with him.
Okay, so just quickly, let's talk. Okay, I'm talking. I know, I understand, Mr. Murphy. Mr. Davion, okay. Okay, Mr. Davion Murphy may need to be removed if he can't stop talking.
All right, the judge is loud, but I'm going to make it louder so we can try to hear Davion. That might make the judge's voice very loud on your end. So take a second. If you think it's going to be too loud, turn it down. Let's see what Davion's saying in the background here.
Okay, so just quickly, let's talk. Okay, I'm talking. I know, I understand, Mr. Murphy. Mr. Davion, okay. Okay, Mr. Davion Murphy may need to be removed if he can't stop talking. Okay. Okay. So, all right, Mr. Murphy, please stop. Okay. So, okay. So, all right, Mr. Murphy, please stop. Okay. You're not helping your situation. Okay. Okay. So After I read the instructions on the law, then I would discharge, at least for the weekend, the 3 alternates, right? And I don't, if we get to penalty phase, I only think we need 1 alternate for penalty phase. I don't think we need to bring back all 3. So you all just need to think about that before tomorrow. And then, if it were me, the lineup would be, this is if we're going to bring 1 back, the next up alternate would be Juror 168, initials Mr. M.N. The second alternate would be Juror 213, Mr. initials J.M. And the third alternate would be Juror 220, initials K.C., Miss K.C. I would be
So CS is still not CS is still gonna be on board.
open to, for only bringing back 1, if there's one among them that would like to volunteer, that doesn't have a job to get back to, that they really need to be attending, to let them pick a volunteer, but only if everyone agreed. Otherwise, I would bring back 1 alternate, and that'd be the alternate number 1 that I just mentioned.
Hey, Judge, the one you mentioned, first initials, that was the first alternate.
Yes, first alternate is Juror 168, initials M.N. Second alternate is Juror 213, initials J.M. Those are 2 males. And then the third alternate is Juror 220, initials K.C.
Your Honor, well, we're discussing. We made it this far, we have all 3. I would propose we have the juror who made contact with Ms. Doherty. I don't think it was anything that, I don't think it had ill intentions, but I think it's a violation of the court's instruction. I would propose he be replaced with the first alternate. We also have to discharge him. I would suggest, given that contact that we had, as incidental as it may have been, I would suggest the first alternate should take the spot.
Well, at this point, no one asked me to do anything, but I'm happy to bring him in and talk to him outside the presence of the others. Just have a discussion with him about what was said and just make sure it's not going to impact him in any way. Okay? And then you can renew your motion. So depending upon what he says. And I'm happy to do that in the morning. So just be thinking about how we're going to handle the alternate situation.
Judge, my inclination is to at least have 2 just in case there's an issue. I know that it asks a lot, but I have 3 files, so we have gone through 3 alternates.
Okay. Well, I'm just raising the topic. You guys just think about it. We'll discuss it in the morning. Okay? Okay. Yep.
I'm getting inquiries from my expert witness rebuttal, possible rebuttal witness. By the way, we have set up evaluation for Saturday for jail. By the way, we have set up evaluation for Saturday for jail. Begin at 9 o'clock. Mr. Davion Murphy and then Mr. Chance will be back. My expert will be appearing by Zoom to conduct the evaluation. I inquired if we could do it on both days, and because of Mother's Day, the jail said we would prefer, because they're going to be short-staffed, to do it all on Saturday.
Okay.
We reserved 3 hours per defendant. They inquired about which attorneys would be present. I advised them. I thought it'd probably be Ms. Toomey and Mr. Petredis. I think Mr. Petredis has indicated he's going to appear by Zoom. This is not your client, counsel.
Okay.
Yeah.
Just about.
Yeah, the people who have filed 202 notices, you didn't file a 202 notice, so I don't think we have the right to evaluate your client.
This is her penalty
I
phase.
want to alert the court to that. Also, another issue's come up this afternoon. Around 2:30, Ms. Toomey advised me that she is now calling Dr. Mark Rubino, who she listed on April 3rd. He's a neurologist, to testify to brain scans that have been taken of Mr. Murphy. So she sent me an email, I have it in front of me, on April 3rd, telling me he was being listed because he wrote prescriptions for those scans. When I talked to her, when I did return, and that April 3rd date was Good Friday. I came down with COVID on Palm Sunday, so I was out those 2 weeks, not able to deal with that. When I did come back during debt qualification, jury selection, I spoke to her about it. She said he would only be testifying to the scripts. Am I right, Ms. Toomey?
That was the intention if we had Dr. Brew available.
Yeah.
We do not. So Dr. Rubino is likely going to be taking the,
So what happened to, who was your original expert to discuss the brain scans? Dr. Who?
Dr. Wu, but I didn't listen because we hadn't gotten the scans done, and so I don't know what they say or don't say.
Now-
I still don't,
yeah.
because we just got them. I'm hoping to get them today. So if they're, get them today, my opinion is that have, if an overnight drivers, then our expert will be able to look at them and be able to.
Well, who's your
determine whether
expert?
or not-
Who's your expert going to be?
Rubino Parker.
So I'm assuming you need to talk
He's
to,
listening.
you need to talk to Dr. Rubino,
I
right?
advised Ms. Toomey I need to take his depo, but I was not told he may be a possible substitute. She
Right.
had told me they were going to attempt to get scans done, attempt to get Dr. Wu listed. I haven't seen any discovery. I think I asked counsel about it before the actual trial started. She advised they had not been able to get it done. She didn't know if it would be done. And now we're right here on the eve of the penalty phase. So I don't have a rebuttal expert. I'm trying to scramble now to find somebody. I was under the, and I don't even know what the scans are. Counsel apparently doesn't know what the scripts are for, the prescriptions, whether it's MRI or PET scans. That's what I've been told.
Ms. Toomey, you know what those prescriptions are for.
They are for both.
She knows.
Okay, so that's the first time I'm hearing that. So, all right, that restricts which expert. I inquired of one expert who only does MRI. So he does not do PET scans, and so I did not retain him. I can't go out and retain a cluster of experts in anticipation of something I don't have, so in any event, we're dealing with that. Now, if she's saying she doesn't have the scans yet, and I depose him tomorrow, he probably will not have opinions about the scans, I'm assuming, because he doesn't have them. Is that right? Or
That would be correct. And he's actually attending his son's graduation, so he's not there.
Okay, so, okay. So it looks like Monday morning you would have to depose him, right? Soon he's got the scans, it's ready to go, right?
that's fine with the state judge.
Okay. All right, that's what we're gonna have to do. It's less than ideal. So state, if we get to penalty phase, I can't imagine your presentation's gonna take all that long.
It's not, Your Honor. We're going to potentially have victim impact, and then we have a rebuttal witness after the defense is presented.
Okay. So what,
Judge, may I ask a question? We have a couple of last-minute witnesses of Mr. Gathright that were hoping to be here, but I thought until today, are not going to be able to be here from out of state. Would there be a potential to do a Zoom?
only if the state agrees.
Are they witnesses that we've already deposed?
I mean, we set depots, but I don't think even really to depose any of them, so,
I'll get with you, if I can take their depositions ahead of time.
yeah.
Those are family members, Mr.
One's
Murphy?
a family, cousin, stepfather, and then the guidance counselor was hoping to be here, had an emergency with his father, and was trying to drive down and couldn't come.
Judge, if we could, I
We can
would like to
arrange
be,
something.
I'm sorry, excuse me. I'm sorry, go ahead, Mr.
No, I was saying we can arrange for you to talk with them or whatever before. We had set out time for you to discuss it, just things never got done, but I literally found out today, so I just said that I would ask.
So if we can inquire just to try to figure out how long we think this is being, because I do want to give my doctor, she's trying to block off a day next week or two for her testimony.
A day or two. Okay, so I guess let's just start, Mr. Hernandez, Mr. Gonzalez. About how long do you think your presentation would take if we get to penalty phase?
I have some family members. There's actually one from the jail that was transported here, and I think he was actually testifying.
I don't need to know who they are, just tell me how long.
We have a doctor, so overall, I would think that 3 to 4 hours.
Okay, all right, and then Ms. Toomey, how long do you anticipate?
I have 2 fosters, 2 family members, one of which is also affiliated with this facade.
And one short one.
Okay, all right, Ms.
Say 5
Finkelstein,
hours?
what's your best?
Did she say 5 hours?
Okay,
And one short one.
okay, all right, Ms. Finkelstein, what's your best estimate?
I would say 3 or 4 hours. We have mostly the friends, family, guidance counselor. We have one expert, he's a penal expert. That would be the longer
Yeah.
explanation, but I mean.
Okay, and Mr. Petredis?
5 to 6 lay witnesses and an expert, doctor, so I would say 45 hours, maybe,
Yeah.
at the worst.
So if we give you all Monday morning to wrap up whatever you need to do discovery-wise, and we begin in the afternoon, the opening statements, state's not gonna take that long, and then who's gonna go first? Have you all got a lineup for
We were
penalty
going
phase?
to go first because we have an expert that needed to testify on Monday, so that was
Okay,
okay.
that's fine. So I'm guessing probably plan on through and close of business Wednesday to get through all of the defense witnesses, and then Thursday would be rebuttal for the state.
Okay. And Judge, I didn't mean to suggest that our expert's going to take 2 days. she needs to have a time period to block off on her calendar for when she may.
I'd say Thursday.
I have a doctor that may have a conflict later in the week, so you're saying it would definitely be Monday, Tuesday, or Wednesday, right?
Yes.
Okay.
Yep.
Your Honor, if I could, just because we heard some witnesses, I believe Mr. Doherty had advised in the recitation of witnesses to the jury that we didn't recognize as previously being listed. Do you remember who that was that read those?
I don't know, and
Okay.
I honestly can be mistaken because I've gotten multiple different lists.
Okay, so when you guys come back tomorrow morning, I'm going to read the jury instructions. You'll all be together. I want everyone to give their final list for penalty phase witnesses, okay?
Thank you.
So you cannot leave this courtroom until you have given each other your final penalty phase witnesses.
And Judge, I have one other matter that I may need to continue, but Alicia Andrews is set for
Monday, a hearing.
motion hearing and or possible sentencing Monday. Do you think I need to ask for a continuance of that, or
What time is it set for?
is it 8:30?
8:30.
I think it's 8:30.
I don't know, because we're not, the way it's shaping up, we're not gonna start court till the afternoon.
Okay.
So only you know what you need to do in the morning for this case. So, okay?
All right, I'll figure it out.
Okey doke.
All right, so sounds like Michelle Doherty is going to be arguing for the state, or at least needs to be present in some capacity for the Alicia Andrews hearing, which is currently set for the morning of the 11th. That's this Monday. So I'm planning on watching that as it happens, if you guys are interested in seeing that. And if it doesn't get postponed, that's what we'll be doing first thing Monday. Let's make sure this is the very end of this, that we don't miss anything, because it's kind of been a lot. All right, looks like they go to the flag. All right, that's everyone clearing out. Okay, so there was a lot happening in that last little bit. So we have Davion Murphy saying something. It seems like it was loud, but I couldn't discern much of what he was saying. You could hear words here and there. He's taken out, and then we get this back and forth about the 3202 motions. And what they're referring to there, this is specifically in relation to Isaiah Chance and also Davion Murphy. So the defense, those two defendants have filed motions in some capacity, notifying the court, notifying the parties that they're going to present some type of mental mitigation. So real quick, Isaiah Chance here, he has intent to present expert testimony and mental mitigation through his undersigned attorney, pursuant to Florida Rules of Criminal Procedure 3202, and files this notice of intent to present expert testimony of mental mitigation, which may be used at trial. They're looking to use Dr. Tracy Hartig. Now, this is specifically what they're saying would be relevant here as it pertains to their client Chance. So, particulars of statutory and non-statutory mental mitigation circumstances, Mr. Chance experts to establish through the above expert witness as follows. First, that Mr. Chance is borderline intellectually deficient. Next, that Mr. Chance suffers from ADHD, which affects his ability to process information. And then they also say kind of more broadly, other mental health factors in Mr. Chance's background that would mitigate against the imposition of the death penalty. And then this is signed off on by Justin Petredis. Now, this isn't like, oh, he's going to plead some type of insanity defense. This is all related to mitigation, which stays contained within the sentencing phase. So if there's a conviction, since this is a capital case where the state is recommending death penalty for all four of these individuals, they're going to argue for aggravating factors. The state's going to argue for aggravating factors and say, here's the criteria that would allow you, if you find that they are met, to recommend the death penalty. In Florida, only 8 of 12 jurors need to be in agreement to make a recommendation. On the flip side, the defendants get to offer evidence of mitigation. And for 2 of the defendants, they're going to go the mental route with some of it and say something about their condition, whether all the time or it's an acute condition that they were experiencing at the time these crimes for which they, if they're convicted of, occurred. It's something that it would be cruel and unusual. It should mitigate your consideration for the death penalty down. That doesn't mean they're going to be found not guilty, right? The guilt phase will already be done. What it means is now that the jury is going to consider the death penalty, these are the arguments for and against that recommendation for the purpose of sentencing. For Davion Murphy, this is just the order granting the funds. So we're not going to go through the initial motions requesting these things, but this will sum it up. So because Davion Murphy is indigent, when he needs to hire an expert, his attorneys are making an application with the court saying, hey, you know what? We need these experts for these reasons. It's important for this proceeding that we get these witnesses, and we need the court to approve it. So this is the court's order approving the request. But specifically, it was they needed these funds for a confidential expert witness to read, interpret, and possibly testify in reference to brain imaging tests. And this court, having reviewed the motion and the response of the Justice Administrative Commission, That's who handles like the funding and the requests for this type of thing. I think a lot of states call it the same thing, but even if they call it something different, states all have their own version of this. And they find as follows. Mr. Murphy was indicted on a 6-count indictment for 1 count of first-degree murder, 1 count of conspiracy to commit murder, 3 counts of attempted murder in the first degree, and 1 count of tampering with evidence, and Florida seeking the death penalty. This court previously declared Mr. Murphy indigent and appointed undersigned counsel to represent him. This court finds that the expert services to the defendant are relevant and necessary to the defense of the case. So to get this application, right, they've got to say, like, it's necessary, right, to make this application to get the funds covered for it. So here's what's authorized. The defense is authorized to incur the following fees. PET scan, a PET scan review, and statistical analysis, 3 hours at the reduced rate of $350 per hour for a total of $1,050. The PET region of interest measurements and analysis, 7 hours. We've got MRI, DTI scan, post-processing analysis, region of interest statistical assessments, 3 hours at a reduced rate of $350. We've got the MRI qualitative volumetric analysis, statistical review, 4 hours. So they're going to pay to get these results done, do this imaging, and have someone analyze it, and then also allow funds to pay that person to come testify. And then to record, review, conferences, clinical correlation reports, and discussion with counsels of record at the reduced rate. So this would be any of the time that the expert, spends their Monday evening, it seems like, maybe Sunday evening, calling and conferencing with counsel. Then the trial testimony, they're getting the same reduced rate, and then travel costs with travel time, including airfare, meals, hotels, and taxis for in-person trial court testimony. So defense shall not exceed an initial cap. So these are what they're being granted for. There's like micro caps, but overall, if they're going to go above this cap of $15,000 total, they'll need to seek court approval for that funding. And then that's Cisco signing off on it. So a little bit of a sneak peek on what we're going to hear. We're going to hear a little bit, it seems like, ADHD and below average intelligence for Isaiah Chance as a mitigating factor. And we're going to hear, beyond my layperson understanding, I'd have to wait and see what the expert would say, but it seems like we're going to have some testimony about Davion's brain. So we'll see. We'll see. We will see about that. And then that was, right, what else? And then after that, they just went through the time. So it seems like it's going to be like 2 days of the defense doing the sentencing phase. And I don't know what Harmon would do, but he said it wouldn't be that long, and then they had a rebuttal, but I don't know if I really trust his time. But I think the sentencing phase next week, whenever it starts, if it's going to be for all 4 defendants, I do think that could be like 2 to 4 days, 3 days, 4 days. So there's that. Yes, I have it queued up, actually. So before we rewatch Davion being taken out, that sounds bad, taken out of the courtroom, I wanted to give a thank you to KC Dog. I was getting my lunch and I saw this come in. Big thank you to KC Dog for the super. Prediction here is 4 guilty verdicts might spare the enhancements on Sean. Overt acts will be in place for the RICO. So KC Dog seems ready to watch this penalty phase. I'm opposed to the death penalty, you guys. I'm just across the board, I'm opposed to it because I just don't think it's cool to take the chance if we ever get it wrong one time. That's just my view on it. But I still think it's going to be interesting to watch a penalty phase with you guys if we get there. So thank you for that. Thank you, Derek, for the super sticker. And also, I think this came from Fingerfeller over on the tip jar, saying thank you for your coverage. Your channel is a first for me. I usually use Grizzly. So shout out, I'm assuming Grizzly True Crime. So shout out to Gisela or Crime and News. So very cool to have you hang out with us today. Hope you liked it here. I hope the chat was great. I love the chat here. Thank you for joining. And thank you for the tip. Thank you so much. So now we've got it queued up. We've got, where's Aaron? Where's Adventure Aaron? Let's see. Here we go. And hold on one second. Because we'll get I think I might be able to put a little bit more boost on it. Let me see if I'm at the max. I'm already at the max boost. So I think the judge says something, and then I'm going to turn the volume up to try to hear Davion here.
Okay, so just quickly, let's talk. Okay, I'm talking. I know, I understand, Mr. Murphy. Mr. Davion. Okay, so just quickly, let's talk. Okay, I'm talking. I know, I understand, Mr. Murphy. Mr. Davion, okay. Okay, Mr. Davion Murphy may need to be removed if he can't stop talking. Okay. Okay. So, all right, Mr. Murphy, please stop, okay? You're not helping your situation. Okay. Okay. So after I read the instructions on the law, then I would discharge, at least for the.
So there we go. I think when I end this, I might put it in a, like, I could clip it and then try to like raise the volume, because I could hear a little bit like F you talking about, but that's really all I can make out. So I still can't hear listening to it. That's our third time, and I can't really. Mafka says, I heard completely out of touch and an insult to the intelligence of the American people and their lived. Are you trolling me? Don't do that. I just rolled with it. I'm like, all right, yeah, okay, he's cooking. I think you got me, but who knows? I really couldn't hear it, so that could have been what was said. Let's see. Conker says, I don't see defendants getting the death penalty if found guilty. What I think could be interesting, and it's something I've thought about a lot over the last couple of weeks with this, right when the trial started approaching and was on my mind, the idea that, we as people, our own psychology, if we were sitting there as jurors, we might not even realize it, but maybe there's something in us that's like, heck yeah, we think these people did this and they meet the criteria for the death penalty. But maybe there'd be a desire stronger than anything that's related to the merits of the arguments for mitigating or for aggravating factors. That's just, but if I convict all four of them, I'm going to feel like a bad person with no compassion. So maybe there's going to be some type of draw, psychological draw for one or several of the jurors where they don't want to do the DP recommendation for all four. So they want to do a sort of split the baby. Not necessarily splitting the baby along the lines of analyzing one defendant at a time to say, based on everything, do we think yes or no? But just the idea that we want to be able to feel moral and feel like we still can give grace to somebody and have some compassion and split their decision on that based off just that psychological subconscious level desire to not feel like there's someone who would just wish everybody to death. And I don't know, I think there are things that come into consideration, and I'm sure that's got to be part of the voir dire for the jury impaneling for a death penalty case. But I don't know, I feel like, how do you sit back there and not go beyond the facts of the case when you're thinking about a decision like that? Especially if any of the jurors are religious, and I'm sure, again, that's something that they probe during voir dire, if that would interfere. You're not going to be selected for a death penalty jury if you say I couldn't do a death penalty case. I should and would be disqualified from the pool. Likewise, if you just think everybody should die just because they've ever committed a crime and you don't even care if they could be rehabilitated, you shouldn't sit on a jury for a trial like this either. But still, I just think that there's a lot that goes into it. You know, I just think that and I don't wish it on any jurors that have to go through the decision. So, TT Diva, yeah, good question. So if you guys missed earlier, now we just got through the end of the day highlight. If you guys missed earlier, right at when we got back from the lunch break, Prosecutor Michelle Doherty came in and said, I just want to put everybody on notice that during the break, I heard someone behind me near the elevator say, good job. And context is that she'd just gotten done with her first half of closing arguments. She said, I turned around and it's a juror. So a juror in the elevator saw the prosecutor right after she got done with her opening close and said, hey, good job. So, and she said, I kept it moving. I just realized it was a juror and didn't say anything back to them, and let everybody know. So, sounds like at least one juror. And they said his name and initials, and it doesn't sound like he's an alternate, but there's probably a safe bet unless they were saying good job sarcastically. That they were persuaded by Michelle's, or not persuaded, but vibed with Michelle Doherty's closing statements. So, the judge did not that I know of, and I don't think, unless they did it between like one of those quick little 5-minute recesses, I don't see how they would have. And it would have had to have been something that the parties were made aware of. It could have been something that the camera pool didn't come back in, and we might not be on notice that they did it. But if the judge did end up speaking to the juror, all parties would know. So I don't really see a time frame where that would have been possible to happen. So I'm going to guess no. Okay, and Sonia says tomorrow, so. And then let's see. Let's see what we've got tomorrow for jury instructions. I think jury instructions is going to be a long read, you guys. You want to start that? I don't think they'll take all day, but maybe we could fire that up like an hour late and watch it on 1.25, 1.5, depending on how fast she reads. So I don't think a noon start would make sense because she might actually be done reading them by that point. So, okay, so she said she's going to talk to them tomorrow. Let's see. Mafka says, would you lie to get on a death penalty jury like I would? See, the problem with that is I do believe that prosecutors go and look up jurors' names on social media. I mean, I feel like they could figure out, like, I don't think I'd be sneaky anyway, but I have extra reasons not to be sneaky because they could very easily find out I'm lying. So I don't think that'd be smart. I don't think that'd be a good idea for me. However, I think this is an important question because I do think in both directions that people might intentionally answer certain voir dire questions because they don't want to get kicked off or because they don't want to be impaneled, right? And sometimes it's just because they just don't want to be stuck on jury duty. But I do think there's cases where people really want to get on because they know a little bit about the case and they already do have some opinions in mind going into the case, and they want to go in there and fight for whichever angle they're already anchored in before the trial even starts. I don't think it's all that common, but I think it's certainly happens. And likewise, I think there's people that answer voir dire questions honestly because they think a certain way about themselves, but they don't really have the self-awareness to realize, hey, maybe I don't actually have the ability to approach a case with fairness and take in all the facts and give considerations to things that might be different than what I'm used to. And so they might answer the questions honestly, but that's only because they don't really know themselves. So that's why voir dire is so cool. I thought we'd get to see a little bit more of the voir dire for the Stephon Diggs trial, but they kind of booted us out of there after like 5 questions, it felt like. So it was just a little bit. But if you guys watch the Afro Man trial here, that is jury selection we got to watch together. So always cool when we do get to see it. Yeah, and don't forget the Mother's Day weekend thing too. How would you feel if you had when I say complicated case, 4 defendants, lots of like digital information, the social media, it's a lot of evidence and it's a lot of instructions. How would you feel, unless it was like a 1-day quick trial, if your fate was in the hands of someone who, if they don't decide quickly, they're going to miss Mother's Day? I wouldn't love that. I wouldn't love that. But, you know, I've seen that a couple of appeals that we've read through. And one of the issues raised was the jury was rushed. Doesn't really seem to go anywhere. But yeah. Half Irish says I'd feel pressured to wrap it up by Saturday afternoon. A recent overturned conviction, Andrew Hayes, shall be, well, it's supposed to be overturned. Every party seems like they want to overturn it. They're just like waiting for it to go through the motions. But a podcaster, Stephanie Tinsley, wife of Mark Tinsley, who did some representation of Alec Murdaugh and is also representing Scott Spivey's estate for, I don't know if you followed, like the road rage shooting case, the civil case in South Carolina. But his wife, Stephanie Tinsley, wanted to find a case to be passionate about, found this case relating to the wrongful conviction of Andrew Hayes. And after her podcast set out, the son of the victim heard her podcast, felt like something wasn't right, wanted answers, contacted the alternate suspect, built rapport with her, and then the alternate suspect ended up confessing to him, the victim's son. So this confession was then presented to the courts and the district attorney in Shelby County, and they're like, look, this is wrong. This has to be undone. But part of Stephanie Tinsley's podcast, she did an episode where she interviewed some of the jurors from the trial. And the jurors were expressing that, well, I had a birthday party to go to. So I didn't really feel like Andrew Hayes did it. And I certainly didn't think there was enough evidence for it. But I had a birthday party to go to. And it was a Friday night and we all wanted to get out of there. So, and let me double check, because Stephanie pulled the podcast down. She's preparing to put season 2 out. Let me see if it's up. It's called the Everything They Missed podcast. But she did a great job telling the story of the case, but also bringing in these other interesting things that even if you're not interested in the particulars of Andrew Hayes' story, which is a crazy story, she has different episodes that just talk about like the read technique, and different academics come and speak with her about how it's been applied, its history, how to challenge it. And again, the juror interviews are awesome. She has the season 1 back up. Okay, let me link to that. Everything They Missed. And it's real short. It's like, what is this? 7 episodes? 7 episodes, 30 minutes each about. You could watch that tonight. It's an incredible podcast with a lot of information, a lot of food for thought. So, and there's that. EJF said earlier in the chat that Michelle Doherty's closing is like me wrapping up a stream, because we always go down another rabbit hole. You know, I never know if you guys have heard about some of these other stories and always want to put them out in the air. So it's not unusual for me to take forever to wrap it up. Thank you, Derek. You're sending in a super sticker. This is send off. This is the goodie bag. This is the send off message. Always good to see you, Derek. Appreciate you. And tomorrow, guys, I'll throw a scheduled stream up a couple hours before I kick off, but I think we'll give ourselves at least an hour of time to skip any downtime and kick up the speed for the jury instructions. And then after that, it'll be in the jury's hands. So, yeah, I know you meant it with love about my extended goodbyes. Do you guys want to do the Reasonable Doubt song? We don't get to end with songs often. The content of this song is not about this trial. This is about the Christopher Wolfenbarger trial in Fulton County, Georgia. Simone Hilton, who you might remember from the YSL trial, was one of the prosecutors there. Their case was so bad that Judge Rachel Krause actually granted a directed verdict on the felony murder count because their case was so bad. So, or lacking in evidence, I should say. So I created this song with the context of that case. It's called Reasonable Doubt, and that will be our send-off. Take care, guys.
Objection, you're ruining my case. State keeps spinning stories all over the place. From source to letters, they got no trace. Objection, you're ruining my case. Can't rule it out, rule it out. That's reasonable doubt, doubt, doubt. State says anything goes, spinning theories around. Can't rule it out. That's reasonable doubt. Letters on the table, custody fights in July, TPO dismissed, and they never asked why. Action glass saw, borrowed or stole, but no proof at all, just a story they told. Waffle House nights, Brookline Street, torso missing, but they call it complete. Can't rule it out, rule it out. That's reasonable doubt, doubt, doubt. Every path's open, they're throwing it wide. Can't rule it out when the facts don't align. Objection rising, cross on the stand. Every new theory slipping out of their hand. Christmas dinner missed, jail in the fall. 30 cops stormed in, but no answers at all. Paint chips, fibers, DNA won't stick. They're dancing around the truth, playing legal tricks. Can't rule it out, rule it out. That's reasonable doubt. Say it loud. From source to cars, they're spinning it out. Can't rule it out. That's reasonable doubt. From letters to source, from cars to tools, theories on theories, rewriting the rules. If every path's open, then none of them prove. Reasonable doubt is the courtroom groove. Rule it out. That's reasonable doubt. Say it loud. Can't rule it out. Rule it out. That's reasonable doubt. Say it proud. State's got no limit, but the truth still stout. Can't rule it out. That's reasonable.